Pam, will you hit record? All right, thank you very much. We're on day 5 of the hearing in WQCC 25-74 related to surface water quality state permitting programs. Going to begin this morning with the presentation by the water protection organizations. Ms. Fox.
Thank you, Madam Hearing Officer. My name is Tanis Fox, and I represent Amigos Bravos, New Mexico Acequia Association, and New Mexico Wilderness Alliance in this proceeding. We will call our first witness, Rachel Kahn.
Would you spell your first and last name, please?
R-A-C-H. Green light. R-A-C-H-E-L-C-O-N-N.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Please state your name.
Rachel Kahn.
What is your current employment?
I am the Deputy Director of Amigos Bravos, a nonprofit water conservation organization dedicated to protecting and restoring the waters of New Mexico. Amigos Bravos has been working for 30 years to protect water quality across the state.
Would you please summarize your work background?
I have worked for the past 28 years in the environmental field, with my primary focus on water quality policy and protection. For the past 26 years, I've worked for Amigos Bravos on New Mexico water quality policy and protection. I've provided technical testimony related to the Clean Water Act and the Water Quality Act requirements before the Commission on many occasions, including during the last 4 triennial reviews of New Mexico's surface water standards, as well as during all 5 rulemakings, designating and promulgating rules governing outstanding national resource waters.
What is your educational background?
I have a bachelor's in environmental biology from Colorado College.
Is Water Protection Organizations Exhibit 3 an accurate copy of your resume?
Yes.
Ms. Kahn, you filed direct and rebuttal testimony in this proceeding, correct?
Yes. Exhibit 3 is my direct testimony, and Exhibit 19 is my rebuttal testimony.
Is that testimony accurate to the best of your knowledge?
Yes.
Madam Hearing Officer, Commissioners, Ms. Kahn has prepared a presentation summarizing her direct and rebuttal testimony that she will now proceed to give.
Madam Hearing Officer. Madam Hearing Officer, Mr. Chair, and members of the Commission, thank you for this opportunity to speak here today. I've been working on issues related to Clean Water Act jurisdiction in New Mexico since 2001, when I started working for Amigos Bravos. I helped identify the impacts of the U.S. Supreme Court decisions in 2006, 2001, 2006, and 2023 on water quality protections in the state. New Mexico tried to initiate primacy and set up a permitting program first in 2006. At that time, I served on a stakeholder advisory committee to provide input on the draft legislation and regulations developed by NMAC at that time. More recently, I served on NMAC's Surface Water Advisory Panel that met during the fall of 2024 to discuss development of a New Mexico surface water quality program through legislation and rule. During the 2025 legislative session, I worked closely with the sponsors of SB 21, NMAC, and other partners on bill language and legislative strategy. Water protection organizations support the efforts of Governor Lujan Grisham, the state legislature, and NMAC to protect New Mexico's surface waters in the face of substantial federal deregulation. By creating a state program for waters of the state that are no longer federally protected, and by obtaining delegation from EPA of the National Pollutant Discharge Elimination System. We want to thank NMAC management and staff for their hard work helping to secure funding for a surface water permitting program even prior to the 2023 SAC decision, convening the SWAP, working to pass SB 21, and drafting the proposed rules that are the subject of this hearing. NMED staff have put in countless hours of work on this effort and have worked collaboratively with all stakeholders. We commend their efforts to protect New Mexico's rivers, streams, wetlands, and other water bodies. So this is kind of an overview slide. I think at this point, the Commission appreciates this rulemaking relates to point source, which the picture on the top, and dredge and fill permits, for example, types of activities depicted at the bottom photo. This slide shows the current regulatory regime and the regime that SB 21 and these rules will create. New Mexico is moving from a combination of EPA and Corps of Engineers issued permits and a whole bunch of unpermitted discharges to the regulatory regime depicted on the right, in which NMED will issue point source permits for both WOTUS and state waters and dredge and fill permits for state waters. The Corps of Engineers will continue to issue dredge and fill permits for waters of the U.S. Water protection organizations thank NMED for incorporating many of our proposals, beginning with the draft rules circulated during the SWAP and continuing through this rulemaking. As a result of NMED's rebuttal testimony and Exhibit 79, and their Exhibit 79, and their proposed changes, water protection organizations withdraw a good number of our proposal. This slide highlights key areas where we are withdrawing proposed language. For example, we support NMED's proposed definition of functional assessment and withdraw our proposed definition. Water protection organizations' proposed changes to NMED's petition fall into 4 general categories. First, we propose meaningful avoidance first provisions. Applicants should be required to demonstrate they will avoid damage or destruction to a wetland or waterway before minimization and mitigation is considered for both individual and general permits. To accomplish this, the project purpose must be clearly defined, and applicants should be required to identify and select the least environmentally damaging practicable alternative before a dredge and fill permit is issued. Second, we propose robust compensatory mitigation requirements with a requirement to establish a minimum 2-to-1 mitigation ratio. So when wetland or water areas are destroyed, twice as much as created or remediated. This is because remediated areas are usually not as highly functioning as the original areas that were destroyed. A 2-to-1 baseline mitigation ratio tracks what is required by numerous other states and helps prevent loss of wetland acreage and function. Our proposal also outlines core concepts that should be included in NMED's forthcoming compensatory mitigation guidance. Third, we propose state rules to be at least as protective as lost federal requirements. To ensure the state is adequately protecting New Mexico waters, the historic Clean Water Act protections, under which industry, agriculture, and communities thrived, should be a minimum, not a maximum, for protections. Specifically, federal requirements for avoiding, minimizing, and compensating for impacts from dredging and filling in wetlands and other waters should be included in the state program. These requirements are referred to as the 404B1 guidelines and are found at 40 CFR Part 230. Fourth, we propose meaningful department review of and participation in general permit coverage. We propose that NMED hold a 15-day comment period on all pre-construction notices and notices of intent for general permits and allow the public to seek commission review on decisions on general permit coverage. This would ensure residents impacted by a proposed discharge have a voice in the process. In addition, we propose the rules include criteria for department review of pre-construction notifications and notices of intent. Here is a key to help understand my slides. For 20.6.2 NMAC, NMED's proposals are shown in blue underline, and our proposed changes are shown in red. For 20.6.5 NMAC, NMED's proposals are shown in black, and our proposed changes are shown in red, underlined. I guess the basic key is that all of our proposed language will be in red in these slides. And the other language not in red is either NMEDs or in some cases NRPs where we're doing rebuttal. Beginning with 20.6.2 NMAC, Water Protection Organization proposed to add a definition of project purpose. Identifying a clear project purpose is critical for avoiding and minimizing project impacts and conducting alternative analyses. Here up on the screen is our proposed definition of project purpose. Determining a project purpose is foundational to the permitting review process. The project purpose dictates the entire scope of the permit review, alternatives analysis, and final permitting decisions by NMED. The project purpose also serves as the benchmark against which practical alternatives are measured for dredge and fill permits to ensure the project is the least environmentally damaging practicable alternative. NMED uses project purpose 5 times in the rule, but doesn't define the term. It is important that the project purpose be the applicant's fundamental goal. If the project purpose is defined too narrowly, it could result in a preordained alternative, prematurely eliminating all other valid project alternatives. Moving on to the general permit issue part of the rules at section 2305. Water Protection Organization proposed substantial additions to section 2305, which governs general permit issuance. And I'd like to give a bit of context why our proposed amendments are so extensive in this section. Almost all discharges regulated under the state program will be through general permits. Therefore, it is critical that all general permits sufficiently protect water quality, aquatic resources, and downstream communities. Section 2305 establishes requirements for NMED's development and issuance of general permits. Therefore, this section must include appropriate guardrails to prevent pollution, the Commission's first and foremost statutory objective. In this section, water protection organizations focus on 4 issues. First, our proposed amendments require NMED to follow federal requirements for developing, evaluating, and conditioning general permits. This is a critical addition to ensure that the state's general permits are at least as protective as federal general permits regulating similar discharges. Second, our proposed amendments require NMED to consult with state, federal, and tribal agencies in the development of general permits. Again, this is done at the federal level. Third, NMED's proposal collapses many different kinds of discharge into one general permit. Water protection organizations propose to separate these categories into separate categories, tracking what is done at the federal level. Fourth, we propose to add a requirement that discharges from all categories of general permits cannot individually or cumulatively cause or contribute to a violation of water quality standards, including the state's anti-degradation rules. This requirement tracks with federal requirements and requirements of the Water Quality Act. So moving to the first of those issues, this is up on the screen is our proposed language, where water protection organizations recommend that the issuance, renewal, or modification of a point source general permit comply with 40 CFR section 122.28, which are the federal regulations that set forth the framework for general permits under state point source programs. These regulations include requirements as to which categories are appropriate general permits, which sources of pollution are appropriate, and what they must have in common, such as similar types of operations, same effluent limitations or standards, and similar monitoring and application of similar water quality-based limits. Similarly, we recommend that issuance, renewal, or modification of a dredge and fill general permit must comply with the federal 404B1 guidelines at 40 CFR Part 230. The Water Quality Act states that the Commission may, quote, Consider the requirements for permits and general permits that are consistent with the requirements of similar permits under Section 404 of the Federal Clean Water Act, end quote. The 404B1 guidelines are federal requirements for permits and general permits. The guidelines require that activities covered by each general permit be similar in nature and similar in their impact upon water quality and the aquatic environment, will have only minimal adverse effects when performed separately, or minimal cumulative adverse effects on water quality and the aquatic environment. It is important to include these provisions because they ensure that New Mexico's state program is at least as protective as federal requirements. Water protection organizations propose to make consultation with other agencies a requirement with developing general permits. This proposal tracks federal practice of consulting with relevant agencies before issuing general permits. Consultation will assist NMED to develop permits that are protective of aquatic resources and comply with federal, tribal, state, and local law. In addition, consultation will help make the permit process smoother for the permittee when applying for coverage under the general permit by requiring NMED to address any potential concerns from federal, state, and local agencies and tribes up front during the development of the general permit, instead of on a case-by-case basis when individual permittees apply for coverage under the general permit. Again, most of the permit coverage in the state will be through these general permits, and much less review occurs for general permit coverage compared to individual permit issuance. Therefore, it's critical that general permits are sufficiently protective and have taken into account upfront public health, tribal concerns, and wildlife. Under the federal program, stormwater discharges from municipalities, construction sites, and industrial facilities are regulated under separate general permits. NMED's proposed amendments collapse all of these discharges into one general permit. In addition, as seen on this slide here, NMED's proposal would collapse treatment works for municipal, domestic, and industrial wastewater into one general permit. Discharges from these distinct activities can be substantially different and therefore need different permit requirements, as the federal government recognizes. Water protection organizations propose to separate a general permit for industrial wastewater from a general permit for municipal or domestic wastewater treatment because the operations, types of waste, effluent limitations, operating conditions, and monitoring differ substantially. For example, industrial wastewater general permits must establish controls for a range of toxic substances, heavy metals, dissolved solids, and radionuclides. In fact, at the federal level, industrial wastewater permits are divided further into different categories such as hard rock mining, non-metals mining, coal mining, natural gas extraction, oil extraction, and pesticide application. In contrast, municipal and domestic wastewater general permits must control biochemical oxygen demand, total suspended solids, biosolids, and bacteria. We propose to mirror federal permits and separate these different types of discharges into separate categories. While our proposals up here appear as if we propose a lot of changes because there's a lot of red, the only substantive changes we propose are what are highlighted in yellow. We propose to separate the general permit categories and then add a provision that discharges under a general permit may not individually or cumulatively cause or contribute to a violation of water quality standards. This requirement is critical to ensure activities permitted under the general permit will not result in degradation of the state's water. The remainder of the red lines merely include the same requirements NMED proposed for its combined categories to apply to our proposed kicked out industrial wastewater general permit category. So moving on now to Water Protection Organization's proposals for general permit coverage, and that's found in section 2306 of the rules. It is critically important that requirements for coverage under general permits are detailed, clear, and protective of water quality and aquatic resources, since the vast majority of permit coverage will be through general, not individual permits. First, we'd like to thank NMAC for incorporating minimum pre-construction notification, which is abbreviated as PCN, and notice of intent, which is abbreviated as NOI, requirements into Section 2306. PCNs for dredge and fill permits and NOIs for point source permits are the documents permittees file with NMED to request permit coverage under a general permit. Water Protection Organization proposed changes would ensure that 1, PCNs must include appropriate information to determine whether water quality and aquatic resources are protected. 2, that there are detailed and clear criteria for NMED to review these NOIs and PCNs. And 3, there's an opportunity for the public to review, comment on, and appeal NOIs and PCNs. Water protection organizations propose to add 4 additional PCN requirements, as shown here on the slide. The first requires project proponents to explain the project purpose. This is a component of federal permits in accordance with 404B1 guidelines. As stated, project purpose is a critical component to determine how to avoid adverse impacts. NMED included requirements related to the project purpose elsewhere in the rule, and it makes sense for applicants to include the purpose of their proposed project in each PCN. This will also allow NMED to evaluate alternatives that project proponents have considered in light of the basic purpose of the project. Second, we propose to require project proponents to describe how compensatory mitigation requirements will be met if the activity will impact aquatic resources above thresholds. This also tracks requirements at the federal level. Water Protection Organization's Exhibit 7 is a Corps of Engineers PCN that requires compensatory mitigation information at box 24. Third, we propose to require project proponents provide information that will assist NMED in determining whether projects are being stacked. That is, whether a project proponent is splitting up a project into mini projects to avoid applying for an individual permit. This requirement tracks with federal requirements, and you can see that in the core PCN form at our Exhibit 7 in box 23. Fourth, water protection organizations propose to require project proponents provide information about any state, federal, or state endangered species or habitat that may be impacted. This also tracks with federal requirements as seen at our Exhibit 7, box 26. We propose allowing a short window for public comment on NOIs and PCNs. More specifically, we propose NOIs and PCNs must be posted within 5 days of determination that a notice is complete. This would start the clock on our proposed 15-day public comment period. Notably, we do not propose to lengthen the time NMED has proposed for NOI and PCN review once a notice is determined complete. We propose that the 15-day comment period be included as part of NMED's 30-day review window. This short public comment period ensures that the public has an opportunity to review proposed activities that may impact water quality and the health of their watersheds. Water protection organizations propose several evaluation criteria to assess whether to approve general permit coverage. Clear and consistent criteria are necessary to review requests for general permit coverage to make sure the proposed discharge meets the scope of the general permit and isn't more appropriately regulated under an individual permit. Water protection organizations propose NMED first determine whether the proposed discharge qualifies for general permit coverage, and if it does, whether the proposed discharge meets the conditions of the applicable general permit. It is essential that NMED review each NOI and PCN to determine if these 2 baseline criteria are met. Next, to ensure the discharge will not violate the Water Quality Act, It is essential to analyze each discharge to ensure it will not cause or contribute to a violation of state or tribal water quality standards. We propose additional evaluation criteria to make sure point source discharges comply with applicable water quality requirements, and dredge and fill discharges will not have more than minimal individual or cumulative adverse impacts. We also propose recourse to members of the public who are adversely impacted by a decision to grant general permit. Without this mechanism, the public has no avenue to seek relief from impacts from a discharge that does not comply with the law. In addition, for transparency, we propose that NMED specify if projects have been approved on its website. All right, now moving to the other regulation, the 20.6.5 for the NMDs program. Water protection organizations, again, appreciates that NMED incorporated many of our proposals as indicated in their rebuttal testimony and reflected in their Exhibit 79B. We withdraw all proposed changes except 3 to the general, and these all relate to general permit review of NOIs. And that's in section 303A4 of the NMDs reg. Our proposal here tracks with our proposals for 20.6.2 related to department and public review of NOIs and the right to seek review of general permit coverage decisions. We proposed, as I mentioned, similar provisions governing department and public review of general permit coverage. And it's the same provisions that we proposed for 20.6.2. So here on the slide is a similar language that we proposed in the other piece of the other rule. First, we propose provisions to ensure that the public has an opportunity to comment on proposed discharge to be authorized under general permits. Second, as proposed here in the slide, we propose clear and consistent criteria for reviewing requests for general permit coverage to ensure the proposed discharge meets the scope of the general permit and isn't more appropriately regulated under an individual permit. Without this proposed language, there are no clear criteria for reviewing general permit coverage. Third, we propose a right to petition the Commission for a review of an NMED determination to allow general permit coverage for a discharge, similar to what we did in 20.6.2. That concludes my testimony of that concludes my summary of my direct testimony. And so moving on to rebuttal testimony. Starting with the definition of tribal water quality standards. We support NMED's amended definition as reflected in Exhibit 79 and as shown here on the screen. Importantly, the Pueblos of Laguna and Jemez proposed this definition to NMED. NRP proposes a definition that would limit the surface water permitting program both at 20.6.2 and 20.6.5 to only tribal water quality standards that are applied, quote, in accordance with the Federal Clean Water Act, end quote. Danielle Shurin from the Water Utility Authority argues for a definition that would restrict protected tribal water quality standards to those that must be approved by EPA under its Treatment of Estate, or TAS program. We oppose NRP's proposal and disagree with Ms. Shurin's testimony. First, NRP witnesses do not provide any testimony explaining the intent of NRP's proposal to add the phrase under the Clean Water Act to NMED's proposed definition. And its meaning is not at all clear from the language itself. With no testimony in support, NRP's proposal should be rejected on this basis alone. Second, the Water Utility Authority does not propose any amendments to NMED's definition of tribal water quality standards to reflect Ms. Shurin's testimony as required by Commission rules. On this basis alone, the Water Utility Authority's proposal should be rejected. Third, assuming NRP's intent is similar to the water utility proposal, that is to require that tribes and pueblos have TAA status for downstream tribal water quality standards to be protected, water protection organizations object. Again, neither the Water Quality Act nor the NIPTES Act require that tribes have TAS status to be protected from upstream discharges. If the legislature had intended to limit protection of downstream tribal water quality standards to tribes with TAS status, as NRP and the Water Utility Authority proposed, it would have done so. But it did not. Their proposal should be rejected as inconsistent with the authorizing statutes. Fourth, achieving TAS status is a time and resource-consuming process that, even if the acts allowed the Commission to limit protections to tribal waters in this way, should not be required. Fifth, for the New Mexico waters subject to 20.6.2 that are not WOTUS, it makes no sense to require tribes who do not have TAS to go through that process. The federal government does not exercise jurisdiction over those waters. Therefore, a sovereign nation should not have to do a burdensome federal process to be recognized under a state-only program. Practically, requiring tribes to attain TAS status would result in fewer tribes being protected from upstream discharges of contaminants in waters of the state. This is the opposite result of the clear intent of SB 21, which committed the state to protecting downstream tribal waters. Establishing water quality standards pursuant to Indian Nation, tribal, or Pueblo law provides a sufficient guardrail to ensure the standards have been authorized by the tribe or Pueblo. This is the definition proposed by the Pueblos of Laguna and Jemez, and their proposal should be given deference. NRP proposes to exclude defining in 20.6.2 and 20.6.5 all terms defined in statute based on their interpretation of the State Rules Act. In their Exhibit 79, NMAC proposes to reference the statutory definitions. We support this approach because it makes it easier for readers to understand the rules instead of having no reference at all, as NRP proposes. As a practical matter, as someone who often pores over the state rules, in my opinion, the definitions word for word in the rule, as they appear in the statute, would be my preference, not just a reference. Moving on now to the scope of the program. Mr. Lindenlaub and Mr. Pierce assert on behalf of NRP that NMED's proposed definition of surface waters does not provide sufficiently clear criteria as to which surface waters will be subject to permits. I disagree. I'm quite familiar with the existing definition of surface waters of the state in 20.6.4 in NMAC, and I have a great deal of experience working with that definition in various contexts, including for use in water quality monitoring, reviewing effluent limits and permits, and participating in revisions to the definition itself. I'm not aware that this definition, which has been in effect for 2 decades, has created controversy or confusion. The terms used within the definition of surface waters of the state, such as intermittent and ephemeral and perennial, are themselves defined in 20.6.4 NMAC and are clear. These definitions have worked well over time to identify those types of streams. NRP witnesses are particularly worried about including ephemeral and their tributaries in the definition of surface waters. However, the vast majority of streams in New Mexico are non-perennial. It is entirely appropriate, and in fact, it's necessary for New Mexico to protect these streams from discharges. These streams are the capillaries that feed the veins and arteries of larger streams and rivers. If toxins are introduced into these small channels, they are flushed into the larger systems when the channels flow seasonally or in response to rain events. To protect water quality in the state's largest largest rivers, such as the Rio Grande, it is essential that discharges into the small streams and wetlands that feed into those larger systems, that those too are protected and regulated. In addition, these small streams themselves perform important ecological services, and water quality in these small systems should be protected to ensure these functions are not impaired. It is precisely because ephemeral streams and isolated waters, including wetlands, waters in closed basins, and playa lakes, are no longer protected under the Federal Clean Water Act that New Mexico has moved forward with establishing a state program. NRP proposes to limit the definition of surface waters of the state to only those surface waters that were considered WOTUS immediately prior to the Sackett decision in May 25, 2023. Mr. Lindenlaub claims this was the intent of SB 21. This is not accurate. First, it's important to understand the history of the evolution in New Mexico of the definition of surface waters of the state. During this commission's 2003 triennial review, Amigos Bravos was a party and supported NMED's proposed change to the definition of surface waters of the state, which removed the language that limited surface waters of the state to only those waters that were waters of the U.S. NMED proposed this definition in response to the Supreme Court's 2001 Swank decision, which narrowed the surface waters protected under the Clean Water Act by excluding isolated waters, including isolated wetlands. Recognizing that state protection of New Mexico water resources should not be limited or bound by what is protected at the federal level, the Commission delinked the state's definition from the federal definition at that time. This reasoning was clearly articulated in the Commission's statement of reason for that 2003 triennial review in support of adopting the current definition of surface waters of the state. Second, both NMED and the legislature have been working to establish a surface water permitting program to protect all surface waters of the state since well before the 2023 Sackett decision. And as far back as 2006, NMED worked to set up a surface water permitting program to protect waters left unprotected by two previous Supreme Court decisions, the 2001 Swank decision and the 2006 Rapanos decision. In 2006, NMED convened a group of stakeholders to discuss the state gaining primacy of the NPDES program and setting up a state program to regulate discharges into waters of the state no longer WOTUS. I participated in that stakeholder process. At that time, NMED prepared draft rules that would have applied the permitting program to all surface waters of the state, specifically referencing the definition of surface waters of the state in 20.6.4 NMAC as defining the scope of that program. In 2021, again, before the Sackett decision in 2023, NMED commissioned an analysis to investigate the resources it would take for the state to develop a program that would both take over primacy of the NPDES program and establish a program to regulate discharges into waters that were no longer WOTUS. NMED presented its plans to develop a surface water permitting program to the Water and Natural Resources Committee interim legislative meeting on September 22nd, 2022, again, before the 2023 Sackett decision. This history demonstrates the state's long-standing commitment, dating back at least to 2003, to protect all surface waters in New Mexico, regardless whether they're protected federally under the Clean Water Act. Third, it's important to observe that on May 24th, 2023, the day before the Sackett decision, there was tremendous regulatory uncertainty as to which waters were federally protected. Each succeeding federal administration has interpreted the 2001 and the 2006 Supreme Court rulings differently, causing large swings, huge swings in jurisdiction. Interpretation of each iteration of the federal WOTUS rules has been challenging to both, it's been challenging to both regulators and the regulated community. Adopting NRP's language would adopt all of this regulatory uncertainty into the state rule. NRP's proposed definition for surface waters of the state would not result in the clarity and certainty NRP claims to strive for, but just the opposite. Fourth, and most importantly, NRP's proposed definition would leave many New Mexico's surface waters unprotected. As stated, Supreme Court decisions in 2001 and 2006, it drastically shrank the scope of the clean water protection in New Mexico. Many smaller streams and all isolated waters, such as playa lakes and waters in closed basins, lost protections under those decisions. Approximately 20% of the land area of New Mexico falls within closed basins. If NRP's proposal is adopted, these waters would not be protected under the surface water permitting program. Oh, sorry. Here on the screen is the language from the 2003 triennial review record when the commission delinked the state's definition of surface waters of the state from the federal definition of WOTUS. And here's an excerpt from that 2021 NMED commissioned report showing that the state was planning on setting up a surface water permitting program before the 2023 SACIT decision. In conclusion, this commission and NMED have for more than 2 decades recognized that the vast majority of the state's waters are not perennial, and that the state's ephemeral and intermittent waters have immense environmental, economic, and cultural value and must be protected. So moving on to exclusions. Mr. Lindenlaub, in his testimony, supports exclusions from surface waters proposed by NRP at 20.6.210C. Water protection organizations do not support NRP's exclusions. First, they are duplicative and they're not necessary. Mr. Lindenlaub acknowledges that many of the waters NRP proposes for exemption may qualify as private waters that are already excluded under the definition of surface waters in 20.6.4. Therefore, many of NRP's proposed exclusions are duplicative of exclusions already incorporated into the rule. Second, Mr. Lindenlaub provides no rationale and testimony except they were included in Colorado's rules, and provides no substantive testimony supporting the rationale for any of the individual exclusions, but instead simply relies on the fact that they are in Colorado Regulation 87. Therefore, there is insufficient justification to adopt any of NRP's proposed exclusions. Third, several of NRP's proposed exclusions are not found at the federal level or have been substantially changed from the federal exclusions. Specifically, NRP proposes to exclude wetlands that are adjacent to ditches from permitting requirements. That one is not included at the federal level and was instead the result of contentious negotiations and give and take among parties in Colorado and should not be viewed in a vacuum. This proposed exclusion of wetlands that are adjacent to ditches would lead to exclusion of a multitude of wetlands in New Mexico from protection under the state program, resulting in the loss of the functions that these wetlands provide, including habitat, flood control, and water filtration. Fourth, many of NRP's exclusions, while tracking some of the general buckets of exclusions that exist at the federal level, have been changed, excuse me, and expanded to varying degrees. For example, NRP's exclusion of water-filled depressions adds depressions created during mining activity when the federal language only excludes depressions related to construction activity. Fifth, and most importantly, the exclusions that now exist at the federal level are themselves a product of those 2001, 2006, and 2023 Supreme Court decisions, limiting Clean Water Act jurisdiction. At the federal level, these exclusions appear in the definition of waters of the U.S. itself, which is the focus of these decisions. The Supreme Court decisions and the exclusion of waters from Clean Water Act protection is exactly why New Mexico embarked on establishing its own state program to fill the gap in federal protections. Prior to the first Supreme Court WOTUS decision in 2001, the only exclusion at the federal level was the prior converted cropland exclusion, which was adopted in 1993 at the federal level. In conclusion, the exclusions proposed by NRP fall into two categories. Either they are unnecessary and attempt to fix a problem that doesn't exist, such as excluding swimming pools, or they represent similar or expanded versions of the federal exclusions adopted to implement the series of Supreme Court decisions that carve out waters that New Mexico remains committed to protecting. NRP's proposed exclusions are either unnecessary or counter to New Mexico's historic commitment to protect these waters and should not be adopted. Moving on to alternatives analyses. NRP proposes to amend NMED's definition of alternative analysis and remove language requiring selection of the least environmentally damaging alternative. Mr. Lindenlaub sets forth a range of objections to NMED's proposed definition for alternatives analysis, including that it's too open-ended, doesn't reflect the federal process, and doesn't take into account cost considerations. I disagree. First, I'd like to point out that this proposal, like so many of NRP's, is hard to read and has confusing colors showing NRP's proposed language in both blue and black. So a lot of time was spent trying to figure out what was actually being proposed. Second, NMED's proposed definition of alternatives analysis parallels the current federal requirements and language. This federal provision drives the requirement for an alternatives analysis. Permittees are accustomed to this requirement. Regarding Mr. Lindenlaub's claim that the definition goes beyond the scope of the Clean Water Act, implementation of the decades-old federal 404B1 guidelines employs the least environmentally damaging practicable alternative, or LEDPA, as the standard for evaluating alternatives. NMED is appropriately replicating that standard and process, which will focus on impacts to aquatic resources that are within the scope of the Water Quality Act. I also disagree with Mr. Lindenlaub's claim that NMED's definition of alternatives analysis does not take cost into consideration. NMED's definition clearly states that an alternatives analysis involves, quote, analyzing all feasible project alternatives to the maximum extent practicable, end quote. NMED's proposed definition of practicable expressly takes cost, existing technology, and logistics into consideration. NRP proposes language that requires NMED to consider not requiring general permit coverage for activities associated with permits issued under the Mining Act, the Hazardous Waste Act, the Oil and Gas Act, the Solid Waste Act, and others. NRP's only testimony in support of this is from Mr. Lindenlaub, who, in a one-word answer, says that the Water Quality Act requires this provision. The Water Quality Act does not require this consideration of other permits. As you can see from the slide, the language is a may. Mr. Lindenlaub doesn't provide any testimony how regulations under these other state laws represent effective and enforceable water quality requirements as required by the exemption language, and will not result in a violation of applicable state water quality standards. NRP has not provided justification and support, and this proposal should be rejected. This concludes my direct and rebuttal testimony.
Madam Hearing Officer, I move for admission of Water Protection Organization's Exhibits 1 through 7 and 19.
Let me pause for objections. Mr. Mullenberg, we need you at the microphone. Oh, sorry.
No objection, but just a clarification. Did I understand correctly that you offered these exhibits as direct and rebuttal testimony? Is it my understanding that they also include the surrebuttal testimony?
Yes.
Okay, thank you.
Thank you. 1 through 7 and 19 are admitted.
Oh, wait.
Oh.
Ms. Khan doesn't have any rebuttal
I do have
exhibits.
surrebuttal.
Oh,
The exhibits are, we have slides for
Oh.
surrebuttal.
no, but
sorry.
those aren't exhibits. Those are demonstratives.
Right. Sorry, Mr. Mullenberg, were you asking whether the demonstrative exhibit, the PowerPoint, has, I have some slides for surrebuttal in the PowerPoint.
Right. I really, what I was getting to is that point that the demonstrative exhibits, as I interpreted them, addressed some surrebuttal testimony. So as to the exhibits, the surrebuttal testimony was given in your testimony just now. I guess they probably weren't in the demonstrative exhibits, but you were giving surrebuttal testimony based on the demonstrative exhibits.
Mr. Mullenberg, we just gave, Ms. Khan just gave a summary of direct and rebuttal, and we're going to now proceed to rebuttal.
Okay, fair enough. Thank you.
And we have no rebuttal exhibits for Ms. Khan.
Fair enough. Thank you.
Anytime. Madam Hearing Officer, Ms. Khan has rebuttal testimony that responds directly to rebuttal testimony that we would like to introduce.
Let's go ahead.
Thank you.
Madam Hearing Officer, Mr. Chair, members of the commission, moving on to my surrebuttal testimony. First, starting with definition of waters of the state. In its rebuttal testimony and as included in NMED Exhibit 79, NMED proposes to amend the definition of surface waters of the state to exclude two types of waters. First, NMED proposes to exclude waters of the United States as defined under the Clean Water Act, and second, to exclude erosional features. Water protection organizations do not object to excluding erosional features, but we do object to excluding waters of the U.S. for several reasons. First, NMED attempts to fix a problem that doesn't exist. The Water Quality Act and corresponding proposed rules already expressly exempt at Section 2303A4 and B6 discharges that are subject to federal permits. This would include Section 404 permits issued by the Corps of Engineers for dredge and fill discharges into waters of the U.S. and NMD's permits issued under 20.6.5 for point source discharges into waters of the U.S. It would also include any federal permit for which the department issues a 401 certification. Therefore, there is no risk of duplicative permitting under the state program for discharges into waters of the U.S. Second, excluding waters of the U.S. from the definition would create significant confusion as to the scope of the state permitting program. This is because, to date, there is still no certainty at the federal level which waters are considered waters of the U.S. and which are not. This is especially true for states like New Mexico, whose streams are mostly intermittent and ephemeral, and whose wetlands generally do not have a continuous surface water connection with a jurisdictional water. And just, I want to add one more thing on that point. We really don't want the state to get into the business of making those jurisdictional decisions. If we link our definition to something that is not a waters of the U.S., it creates that burden on the state, and we don't want to go there when we already have clear provisions in the rule that exempt discharges that have federal permits from having to get a state permit. So moving on to incorporating federal regulations. This is the 404B1 guidelines issue. Ms. Lemon rebuts Water Protection Organization's proposal at section 2305A1 and 2 to follow federal regulations when developing point source and dredge and fill general permits. She states that adopting federal requirements into the rule reduces NMAD's flexibility, and NMAD can incorporate appropriate federal concepts during implementation without constraining the program's flexibility, end quote. While regulatory agencies should retain flexibility in appropriate circumstances, these federal rules regulating dredge and fill activities have been in place for decades, are fully vetted and tested, and are understood by permittees and do not represent new regulatory requirements. The new Colorado rule, Colorado Regulation 87, which is Water Protection Organization's Exhibit 15, governs that the state dredge and fill program incorporates the 404B guidelines by reference to ensure that the state permits will be at least as protective as federal dredge and fill permits. New Mexico should set the same floor as our neighbor to the north, a floor that has helped protect New Mexico's surface waters for over 50 years. In its rebuttal testimony and in NMED Exhibit 79, NMED proposes to add language suggested by NRP to the exemptions at Section 2303, clarifying that a discharge subject to a federal 404 permit and a permit issued under 20.6.5 NMAC for point source discharges into federal waters are exempt from state surface water permitting regulations. Water protection organizations do not object to this addition of these provisions. Excuse me. However, NMED also proposes to incorporate a concept proposed by NRP into the exemptions for dredge and fill activities at Section 2303B, as seen here on the slide, that would presumptively exempt discharges subject to a groundwater discharge permit issued under the Commission's dairy rule at 20.6.6 NMAC and the copper rule at 20.6.7 NMAC if the permit prevents a discharge to surface water. This language is highlighted in yellow on the slide. This proposal is confusing and unnecessary, and we oppose its inclusion. It is not clear why a groundwater discharge permit that protects water quality should exempt dischargers from requirements to get a surface water permit. There is no assurance that a groundwater permit issued under rules whose focus is on the protection of groundwater, not surface water, would be sufficient to protect surface water. God, after almost an hour, I'm having a hard time with a basic word like water. It's not clear that these groundwater permits would be sufficient to protect surface water, and neither NRP nor NMED has explained in their testimony how or why surface waters are fully protected through groundwater permits issued by technical staff who are not necessarily trained to protect surface waters. The state's groundwater permitting program, implemented by NMED's Groundwater Quality Bureau, was established to protect groundwater quality and ensure that groundwater standards at 20.6.2, 3103, and NMAC are met. The groundwater permitting program has different goals, standards, and requirements than a surface water permitting program, whose purpose is to protect the state surface water quality standards at 20.6.4 NMAC. Groundwater permits do not necessarily require compliance with the surface water standards, do not require avoidance and minimization of impacts of dredging and filling of wetlands or other surface waters, do not take into account of impacts to aquatic resources, and do not require compensatory mitigation for unavoidable impacts. If the intent or result of this proposal is to exempt discharges to surface waters because a groundwater permit held by the same discharger includes some sort of containment provisions for surface waters, but there is still or could be an actual surface water discharge, we strongly object, because there would be a discharge to surface waters without appropriate surface water discharge protections. At best, NMAD's proposed language creates confusion and regulatory uncertainty and has not been fully evaluated. At worst, it creates a sizable loophole in the surface water permitting regulations. If the intent of NRP's and NMAD's proposal is to exclude discharges that are regulated under a groundwater permit that effectively prevents any discharge to a surface water, the provision is unnecessary, because if discharges are truly contained and there's no discharge to a surface water, a state surface water permit wouldn't be required. So therefore, we strongly urge the commission to not adopt this proposal. Moving on to temporary authorizations. Water protection organizations thank NRP for proposing an amendment to address issuance of temporary authorizations. Temporary authorization for discharges prior to issuance of general permits is necessary. Water protection organizations proposed amendments to NRP's temporary authorization proposal in our rebuttal testimony, but now NMED has proposed a temporary authorization provision at 20.6.2 2306J in its Exhibit 79A. We support NMED's proposed temporary authorization language and withdraw our proposal. And with that, that concludes my testimony. Thank you for your time and your attention.
Madam Hearing Officer, Madam Hearing Officer, this concludes Ms. Khan's SIR rebuttal testimony. She will sit on a panel for cross-examination with Mr. Siebert and Dr. Seltenfuss for cross-examination. And therefore, we'd like to call our next witness, Mr. David Siebert.
Thank you, Ms. Fox. Thank you, Ms. Khan.
I'm back. Got it spread out.
I get some extra steps.
There you go. We're good for something.
Ms. Fox, we have about a half hour before we need a break, if that's okay.
Now would be a great time because I've got to put up the PowerPoint.
Oh, all righty. Shall we take our morning break then? It's a little early.
Or not, whatever your pleasure.
What do you think? Well, well, we need like a 15-minute break in order to break up the 3 hours is the thing. I have a theory, you know. Ms. Fox, do you have a natural breaking point about 30 minutes with Mr. Siebert?
I think so.
Okay, let's do that then.
Okay. I need to put up just the PowerPoint.
Okay.
So I need a few minutes for it, a couple
Okay.
minutes for that. Thanks. We are ready to roll, Madam Hearing
Great.
Officer.
Terrific. Let's come back to attention. Would you spell your first and last name, please?
Yes, good morning. David, D-A-V-I-D, Siebert, S-I-E-B-E-R-T.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. Go ahead.
Thank you, Madam Hearing Officer. Please state your name.
David Siebert.
What is your work background?
Yes. I retired in 2023 after serving 32 years with the Department of Natural Resources in the state of Wisconsin, a career that included positions working in, developing, and managing state wetland and waterway protection policy. I began working at the department in 1990 as a wetlands ecologist, and I led a team that developed a rapid assessment methodology related to wetland functional values to implement our new, in 1991, state water quality standards for wetlands. In the early 2000s, I led a team that developed compensatory mitigation rules for the state. And I finished up my career at the department in 2023 after serving 4 years as a governor-appointed division administrator, responsible for managing 6 programs with a staff over 400 and a budget of $48 million approximately. My direct testimony and resume provide more details on my work experience over the years with the department, and now I do some consulting on water policy matters.
What is your educational background?
I have a Bachelor in Science in Environmental Science from Bowling Green State University in Bowling Green, Ohio, and a Master of Science in Water Resources Management with a focus on wetland policy and ecology from the University of Wisconsin-Madison.
Mr. Siebert, you supplied direct and rebuttal testimony on behalf of water protection organizations in this matter, exhibits 11 and 20, respectively, correct?
Yes.
Is that written testimony accurate to the best of your knowledge, and do you adopt it?
Yes, though I do have one change, if I may.
Please.
In my direct testimony, page 17, line 13, where I'm referring to a federal CFR reg, it currently says 33 CFR part 332, and that should actually read part 330.2.
Is Water Protection Organizations Exhibit 10 an accurate copy of your resume?
Yes, it is.
Mr. Siebert, let's begin with fundamentals about protecting wetlands from dredge and fill activities. In general, what is meant by avoiding, minimizing, and ensuring there are no significant impacts to wetland functional values? And why are those measures critical to protecting aquatic resources, including wetlands?
The fundamental concept established in the requirements of the Clean Water Act under Section 404 Dredge and Fill Permitting Program is a reliance on that sequence: avoid, minimize, and mitigate. Water Protection Organizations Exhibit 12 is an EPA fact sheet that I think does a good job of explaining those 3 steps of the sequence. These steps were developed to address the tremendous loss of wetlands and other aquatic resources that the nation had experienced over time. Recognizing that protecting those important resources is in the public interest and ensuring that further loss be as limited as possible. States like Wisconsin have adopted a similar process to the federal government to minimize impacts and maintain consistency between the state and federal agencies. Now, with the federal government asserting less and less authority over which waters are regulated under the Clean Water Act, it's up to the states to have solid and defensible rules and policy to protect its aquatic resources. So that sequence starts with avoid, requiring that every project proponent do everything possible to avoid adverse impacts. A permit applicant must consider practicable alternatives, how to accomplish the overall project purpose, and taking into consideration things like pollutant discharge, location, timing, types of machinery used to avoid any adverse impacts to aquatic resources, both functions and acreage. Part of the demonstration of avoidance must be to determine and choose the least environmentally damaging practicable alternative, or LEDPA as it's referred to. And the definition of practicable includes consideration of costs, logistics, and existing technologies. The next step, once a permittee has demonstrated that they have avoided adverse impacts to aquatic resources, the permittee must evaluate all ways they can minimize adverse impacts. Minimization can similarly include decisions about the amount of pollutant discharge, location, timing, methods, types of machinery used, etc. These evaluations and decisions must be documented in an application for an individual permit, as well as in the process for requesting coverage under a general permit. The final step is to develop and implement a compensatory mitigation plan to address any adverse impacts to aquatic resources, again, both acreage and function, that are unavoidable and have been minimized to the maximum extent practicable. The agency should then consider the benefits of the mitigation in making a determination that the activity will not result in significant adverse impacts to aquatic resources. In my opinion, administrative rules should provide clear direction to applicants as to what the process requires and what types of information will be needed for that review. Then I think the rules should clearly establish the findings that the agency must make in order to defend its permitting decision.
Can you please provide an overview of your approach to NMED's proposed rules and water protection organizations' proposed amendments?
Yes. Based on my 30+ years of experience drafting administrative rules, crafting guidance, training field-based staff in wetland ecology and policy, and then later managing the programs and staff that had to implement these policies and programs, it's my opinion that NMED has put together a solid and impressive package for the state to implement its surface water permitting programs in New Mexico. In my opinion, the water protection organizations have proposed rule language amendments that will provide additional detail and clarity within the administrative rules that improve on the department's proposed language and will provide necessary regulatory provisions that will be helpful to the regulators, to the regulated community, and the other interested parties. I think in many places, the suggested amendments from the water protection organizations use language that is similar to, and in some cases verbatim, from federal rules and guidance. In my experience, aquatic resource protection programs need to rely on good science, and then you have to follow the statute and rules of the state. Also, I think the programs must recognize that development projects will have some impacts on the environment. The purpose of the laws is not to prohibit development or prevent development, but it's to assure that there is a reasonable approach for allowing projects to be permitted if the applicant demonstrates that they have clearly met the conditions set forth in the laws, including that strict adherence to avoid, minimize, and compensatory mitigation. It's important for state programs to use language and process elements that are consistent with federal approaches in the regulation of water resources. Consistency between state and federal regulations is a positive for the agencies, the regulated community, and other interested parties, recognizing, of course, that each state must consider its own unique set of circumstances and adjust accordingly. For example, I recognize that the rules and policies that we have in Wisconsin are not going to be a good fit for a southwestern state like New Mexico. I also fully appreciate the difficulties that state environmental agencies have in managing huge workloads with limited budgets. And so I agree with policies and rules that include ways such as using general permits to allow the department to prioritize its review and staff time on the most critical impacts and the most critical needs for protection of aquatic resources. Lastly, my testimony is based on my decades of experience working directly with applicants and their consultants in processing often complex permit applications. Having detailed and clear administrative rule language is important to help ensure that high quality, complete applications come in upfront to the agency staff, minimizing the amount of back and forth between applicant submittals, agency information requests, all of that which could, if we avoid that, could save time and money for everybody.
Let's turn to proposed amendments at 20.6.2 NMAC. For a number of provisions, water protection organizations propose requiring more information and analysis from the applicant on the nature of the discharge, impacts, and measures a discharger will take to avoid, minimize, and ensure there are no significant impacts. Based on your 3 decades of experience with state regulations governing dredge and fill activities, is it necessary to require applicants to provide the types of information and analysis proposed by water protection organizations?
Yes. And I'll say, I think none of what water protection organizations are proposing run counter to the department's proposals. In fact, I think they add clarity and consistency with federal practice, and I just believe that that would improve these rules. The proposed changes from the water protection organizations are largely based on language from those analogous federal regulations. The types and amounts of information listed in the proposed language are consistent with what is required under Wisconsin law. And the goal is to provide clear expectations for what constitutes a complete application, and then clearly outline the formal findings that the department must make.
Turning now to specific proposals, NMAC proposes a definition for alternatives analysis. Do you support this proposal?
Yes, I do. I support having important definitions in the rules as a means to provide clarity about the details of permit application requirements. The definition of alternatives analysis provides appropriate clarity that an applicant must demonstrate that they used an upfront planning process to try to avoid and minimize aquatic resource impacts. This language is consistent with what other states use and consistent with federal language. Because the rules require a showing of how an applicant avoids impacts, it's critical that the rules define how alternatives must be considered. The definition of alternatives analysis summarizes what is required in section 2307.I under the permit conditions for discharges of dredge and or fill material to accomplish avoidance by determining the least environmentally damaging practicable alternative. Identifying and analyzing all feasible project alternatives is the only way to arrive at that determination.
Water protection organizations propose an amendment to NMAC's definition of avoidance. Do you support this proposal?
Yes, the rules require an analysis of alternatives to avoid impacts to aquatic resources, which includes ways to both avoid direct and indirect impacts. So adding the phrase "or adjacent to" provides clarity as to that scope of analysis. In addition, this language makes clear that the rules cover potential impacts of placing fill near waters of the state, which include runoff and sedimentation from erosion, for example.
For clarification, we should have highlighted, or we should have put the or adjacent to language in red. That is the additional language. Apologies. It's my fault. Section 2304.C2 sets forth requirements for an application for a new individual permit for dredged and filled discharges. In rebuttal, NMAC accepted a number of water protection organizations' proposed amendments, which is appreciated. Therefore, we have revised our proposals accordingly, as shown on the PowerPoint, and is reflected in Water Protection Organizations Exhibit 1, Addendum 2. What is the basis of Water Protection Organizations' proposed amendments to that provision?
Well, first, I think the department's proposal is solid and clear and uses language that's consistent with the federal regulations. The Water Protection Organization's proposed additions, as shown on the slide, are also consistent with federal language and will add clarity and details that, in my opinion, will promote more complete applications being submitted up front. Again, it's important for the rules to minimize that back and forth need for more information between the applicant and the regulator during the review process. The suggested language requiring a functional assessment, an alternatives analysis, and a compensatory mitigation plan if necessary we'll make sure that we provide the department with information it needs to make a determination called for by the rules. The proposed amendments requiring compensatory mitigation for unavoidable losses of aquatic resources over 1/10 of an acre of aquatic resources or 3/100ths of an acre of stream bed allow the department discretion to require compensatory mitigation below those levels. Obtaining an explanation from the project proponent as to why compensatory mitigation should not be required will only help the department in determining whether to require compensatory mitigation for losses below those thresholds.
Oops. Well, I think I might have just gotten cut off. Am I on the platform? Oh. Here we go. Yeah. Yeah. It's not moving. There we go. Subsection D of section 2305, as amended in NMED's Exhibit 79, governs conditions included in general permits. What is the basis of your support for water protection organizations' proposed amendments to NMED's proposals to that subsection?
Under subsection D3, general permits must set forth clear criteria for certain kickouts. That is, a general permit must have criteria specifying that it cannot be used if certain resources would be impacted. In my experience, those projects that could affect, say, high quality resources, those are the kinds of projects that require additional staff time and attention and may be better handled under an individual permit. Subsection 5 clarifies that both acreage and functions of impacted aquatic resources must be evaluated. And the proposed language clarifies that when a functional assessment is required, that a scientifically defensible and accepted methodology must be used.
Water protection organizations propose a new subsection E to section. I am not getting it. I don't, this, the PowerPoint is not the right PowerPoint. Apologies. So there you go. Thank you.
I meant 1040 onto the green.
Looks like it.
Thank you, Pam. We're back after a short break. We're going to return to the testimony of David Siebert. Ms. Fox.
Thank you, Madam Hearing Officer. Apologies for the technical difficulties. I think we've straightened them out. We have the right PowerPoint, so we will continue. Mr. Siebert, water protection organizations propose a new subsection E to section 2305 that establishes the basis of the NMED Secretary's issuance, renewal, and modification of general permits. Do you support this proposal?
Yes, in my opinion, it's important to split out the provisions for what must be in a general permit as required in subsection C that I previously discussed, and the findings that the department must make in order to issue a general permit in this new subsection E on this very nice PowerPoint slide that we have in front of you. Each of the three required findings is consistent with federal regulations as outlined in my direct testimony. These three provisions require that general permits developed by the department include sufficient requirements, procedures, and conditions to ensure that activities authorized will abide by the listed prohibitions and procedural steps.
Section 2306A governs the contents of notices of intent for point source discharges or general permits and pre-construction notifications for general permits for discharge of dredge or fill material. In rebuttal, NMAC accepted a number of water protection organizations' proposed amendments to this subsection. Therefore, we have revised our proposals accordingly. Water protection organizations continue, however, to propose that coverage for general permits for dredge and fill activities ensure that a project is not divided into smaller projects, but is considered a, quote, single and complete project. What is the basis of your support for this amendment?
The suggested language clarifying coverages for a single and complete project is proposed to make sure that applicants for dredge and fill general permits do not artificially split a larger project into parts for permitting purposes. This is consistent with federal rules in 33 CFR Part 330 and federal guidelines preventing what's called stacking of several general permits for one project. So this would prevent, for example, an applicant splitting a large housing development into permits just for the impacts to for the construction of roads, separate from the permits for stormwater ponds, separate from permits for a parking lot, separate from permits from the home sites. It's all one project for permitting purposes.
Section 2307G4 which is not before us. Governs a permittee's duty to avoid, minimize, and mitigate under all surface water discharge permits. What is the basis of your support for water protection organizations' proposed amendments?
The proposed amendment from water protection organizations complements and adds further clarity to the department's proposal by adding detail on an important concept, that adverse impacts can both be a loss of the amount of the resource, that is acreage, and also the loss of functions of the resource. This amendment would codify and drive home the important point that the analysis includes impacts to acreage and functions, both of which must be accounted for.
Section 2307I governs conditions and permits for discharges of dredge or fill material. In Exhibit 79, NMAC adopted a number of water protection organizations' proposal. An important proposal NMAC did not adopt is a proposal to prohibit significant degradation of aquatic resources. What is the basis for your support for this proposal?
Water protection organizations propose a prohibition on discharging dredge and fill materials if it will cause significant degradation. This proposal tracks with similar federal prohibitions at 40 CFR Part 230.10C. In my experience, the final determination necessary before you can issue a permit after the avoid, minimize, and mitigate steps is the determination that the activity will not result in significant adverse impacts to functions and values of aquatic resources.
Subsection 2307J2 governs the requirements for compensatory mitigation. Water protection organizations proposed more detailed requirements for the guidance to be developed by NMAC for mitigation. What is the basis of your support for these more detailed proposals?
It's my opinion that the water protection organization's proposed amendments are fully consistent with the purpose and intent of the department's proposals, but will add important detail and clarity. At the beginning of subsection J of section 2307, water protection organizations propose language that sets up possible future approaches for compensatory mitigation, that being in lieu fees program or mitigation banking. In my experience, reliance on permittee responsible mitigation projects has not resulted in the best outcomes in terms of project success and the best use of staff time. Other states and regions have been invested in mitigation banking for decades, and some states have implemented in lieu fee programs quite successfully. The proposed amendments will give direction to the department, the regulated community, and the interested parties for future policy work regarding banking and in lieu fee programs. The remainder of the Water Protection Organization's proposed amendments in paragraph 2 of subsection J expand on the department proposed language, but offer much more detail, using language that's consistent with federal guidelines for compensatory mitigation in 33 CFR Part 333.2, especially what must be included in a mitigation site plan. In my opinion, it's important for the rules to establish the minimum information needs that a mitigation project plan must include. That is, setting clear objectives, describing in detail the baseline conditions and proposed work plan, describing how success of the project will be measured, developing a plan for short and long-term management, and also developing a plan for short and long-term protection of the site. Since permits will allow immediate impacts of loss of functions and values of aquatic resources, and the proposed compensatory mitigation is intended to offset those losses, it's important that you have a defensible and complete planning process up front to help ensure that the mitigation projects are successful. I do understand that the department expects to establish many of the details on how compensatory mitigation will be done through its guidance. And as such, the proposed amendment language would add clarity on the range of important issues and topics that must be included in that future guidance. As the department embarks on crafting guidance for compensatory mitigation, the proposed language for subsection 2307.J2 provides the regulated community and interested parties a clear understanding of what to expect in that guidance.
This concludes Mr. Siebert's summary of his direct testimony. We'll now move to his rebuttal testimony. Let's begin with the direct testimony of NRP witness Brian Lindenlaub, which is NRP Exhibit 2. On pages 7 through 9, he sets forth a range of objections to NMED's proposed definition for alternatives analysis, including that it's too open-ended, would potentially require an endless analysis of project alternatives by requiring an analysis of quote-unquote all feasible project alternatives, and would require selection of an alternative regardless of cost. NRP's proposed language is shown on the PowerPoint. What is your response?
I don't see the need for any of the changes that are being proposed by NRP. I think much of the concerns raised by Mr. Lindenlaub are addressed in the department's proposed definition of practicable. That is, available and capable of being done after taking into consideration cost, existing technology, and logistics in light of overall project purposes. The department's proposed definition for alternatives analysis, requiring permittees to analyze all feasible project alternatives to the maximum extent practicable, takes into account cost, contrary to what Mr. Lindenlaub claims, and other practicable considerations such as existing technology and logistics. Mr. Lindenlaub's argument that the definition requires a quote endless analysis of project alternatives doesn't square with the definition of alternatives analysis, which requires an evaluation of all reasonable and feasible project alternatives. Those are qualifications, I think, that limit the alternatives that must be considered.
NRP proposes a procedure for NMED to make jurisdictional determinations whether a water body is a surface water and a permit is required. NRP proposes that NMED publish a map of all surface waters to determine whether a water course or body of water is a surface water. NRP further proposes that prior to publishing the map or any revisions, NMED must put the map out for public notice and comment, and that any changes to the map are subject to appeal to the Commission. Mr. Pierce, in his direct testimony at page 6, supports the proposal, arguing that it's, quote, essential for this map to be subject to public comment and review by the commission prior to use. What is your response?
Well, as a former state regulator, I think it'd be a daunting, maybe impossible task to accurately map all surface waters of an entire state, especially one as large as New Mexico. As to the public notice and comment requirements proposed by NRP, it doesn't make sense to subject the highly technical task of mapping surface waters to a requirement to gather public comment prior to having legal authority to place a water body on that map. Accurate mapping requires training in hydrology and geographic information systems, so it's a technical exercise, not a political one. I also question the value of such a mapping resource in making permit-specific determinations, since regulatory determinations require site-specific, project-specific, and time-specific analysis. It's my opinion that the state could create a mapping tool with the best information it has at hand and make that available to applicants and the public. And I understand that the department's working on such a tool at this time. However, the department's map should never be the final call as to whether a particular river, stream, tributary, creek, or wetland is subject to permitting requirements.
NRP proposes to restrict general permits for point source discharges and dredge and fill activities to, quote, not be more stringent than the conditions in the corresponding federal permit as certified by the state. Mr. Lindenlaub supports these amendments with rather sparse testimony, asserting that the federal requirements are, quote, are protective of the aquatic environment. What is your response?
I don't understand what Mr. Lindenlaub means by the term no more stringent than in reference to current federal permits and in the context of general permits and conditions. In my opinion, such language actually could lead to greater uncertainty or confusion for the regulated parties. It's my experience that in many water programs, the federal requirements establish a floor, and it's expected that the states will adopt rules that meet the federal minimum and then rely on state-specific factors to tailor those requirements to the qualities of the state's aquatic resources or other state-specific matters. This is why federal general permits and nationwide permits allow for regional conditions, and why the Clean Water Act water quality certification process contemplates and allows for state-specific conditions. So while the department may decide to issue general permits that closely mirror the current suite of federal general permits, I think it makes good sense for there to be an allowance for some modifications to fit New Mexico specifics and any changed conditions since the last issuance of those federal permits. State-specific conditions certified in the past by the state of New Mexico may not reflect changes to the state's water quality standards and policies or current conditions, and therefore limiting those conditions to past certifications is not at all adequate. If the department were to propose conditions different from those current federal permits in the new state-issued general permits, there's clearly a process established in rule for public comments from the interested parties prior to that issuance.
This ends Mr. Siebert's summary of testimony. Water protection advocates move for admission of exhibits 10 through 12 and 20.
Thank you, Ms. Fox. I'll pause for a moment in the event there are objections. Exhibits 10 through 12 and 20. Okay, they're admitted. While you're looking though, there was a question from one of the commissioners about whether the exhibits associated with Ms. Khan's testimony were in fact 1 through 7 and 19.
Is that what I moved, or is that?
That's what I remember you moving. But
I think that's what they were. Let me just check.
okay. Sorry to slow this down here.
One through 7 and 19.
That's what I wrote. All right, commissioners, thank you. Please go ahead with the rebuttal.
Thank you. It's brief. Mr. Siebert, on pages 4 through 6 of the rebuttal testimony of NRP witness Tom Shelley, he contends that water protection organizations' proposed rule language, quote, would add significant complexity to the general permit notification process, including the required alternatives analysis to what should be a fairly simple process, and that your testimony threatens to convert ordinary maintenance into major permitting actions requiring extensive environmental review and consultant involvement. And quote, applicants could be required to evaluate multiple project alternatives. What is your response?
I don't think that Mr. Shelley's characterization of water protection organizations' proposals is accurate. I think that a general permit process can and should be simpler to the individual permit process. To apply for coverage under a general permit, the applicant has to provide information to the department that demonstrates that they've met the conditions of that permit. One aspect of any of these permits should be a showing that alternatives to avoid and minimize have been considered. The depth and breadth of such analysis will differ between an individual permit and a general permit application. And the scope of what expertise is needed to complete an application is going to have to vary depending on the scope of the project being proposed.
Ms. Saki Delet, NMED witness, objects on pages 2 to 3 of her rebuttal testimony that incorporating the concept of single and complete project somehow inappropriately introduces a federal concept that creates ambiguity and confusion into the state program. It would not improve environmental outcomes. What is your response?
In her rebuttal testimony, Ms. Zaki Dalit, I said that properly, appears to agree with water protection organizations and other parties that there should be requirements in the rules to ensure that applicants for dredge and fill general permit coverage do not artificially split a project into parts for permitting purposes. And she states that such provisions already exist in the state's proposed rule package. However, I don't see where that occurs, and she didn't provide a citation. So therefore, I agree with water protection organizations' proposal to add a reference, as I mentioned earlier, to a single and complete project in section 2306 in order to make that concept clear. This requirement prevents stacking of permits to evade regulatory oversight of large projects. Ms. Zaki Dalit goes on to assert that the reasons for this suggested language is based on, quote, an assumption that federal terminology must be mirrored in state rules. It's my view that language proposed by water protection organizations is not based on an assumption that federal requirements must be mirrored in the state rules. Rather, it's based on an idea that where appropriate, rules could use or at least borrow from existing federal language that's been in practice for years. I also don't agree with her argument that the proposed language creates ambiguity and confusion and wouldn't improve environmental outcomes. Because the concept of single and complete project is based on federal regulation and practice, both regulators and permittees have experience with the concept, and therefore it's not confusing. Also, preventing stacking of general permits should improve environmental outcomes by ensuring that cumulative impacts are taken into account during that permitting process.
On pages 42 to 43 of Ms. Lemon's rebuttal testimony, she argues that water protection organizations' proposals at subsection J at section 2307 relating to compensatory mitigation are, quote, highly detailed and prescriptive mitigation requirements that reduce program flexibility and responsiveness without demonstrable improvements in water quality outcomes. She also argues that the proposals would limit NMED's professional discretion to adapt to site-specific conditions, complicates simple or low-impact projects, and proposes substantial administrative and financial burdens on the permittees and the department. What is your response?
I don't agree with Ms. Lemon that the suggested language for subsection J will limit agency flexibility and professional discretion, nor do I agree that the suggested language is too prescriptive. It's my experience, and I certainly support having rules that respect and allow for flexibility for the department in making its regulatory decisions. And I think that it's good to have rules that allow for professional discretion of the agency. Having such flexibility will only yield benefits for the regulated entities. I don't agree with Ms. Lemon's criticisms of water protection organizations' proposals here. Rather, I think the suggested language creates a clear framework for mitigation requirements. And having that framework laid out in the rule will only help provide sideboards and an outline for what the more detailed guidance that is being developed looks like. It's my opinion that water protection organizations have suggested language to help prevent time-consuming back and forth review interactions with applicants. There needs to be some framework so applicants know what's expected of them or submitting an approvable compensatory mitigation plan. The outline proposed by water protection organizations is used in states across the nation. Lacking clear guidance and rule language, applicants may submit incomplete information, thus forcing the department to ask for more. Without a clear outline in the rule, an applicant may challenge any department request for more information or other details in the plan. I think it makes sense to frame out in the rule what is expected for any proposed compensatory mitigation submittal. And it makes sense for the rule to provide direction as to what the detailed guidance is going to include. The proposed language from water protection organizations would establish a framework that allows for flexibility for both the applicants and the exercise of professional discretion and judgment by the department to tailor mitigation projects to site-specific needs.
This concludes Mr. Siebert's SIR rebuttal. Thank you, Mr. Siebert. Mr. Siebert will stand for cross-examination in a panel with Ms. Kahn and Dr. Selton-Foos.
All right. So we hear next from Dr. Selton-Foos. All right. Thank you, Mr. Siebert. Hello. Would you spell your first and last name, please?
Yeah. Thank you for your time. My name is Jeremy Selton-Foos. Uenfus.
Do you swear or affirm to tell the truth? Thank you. Go ahead, Ms. Pice.
Your position.
Oh, is that
Yes.
important?
Yes, sir.
It is indeed. My apologies.
Where are you currently employed and what is your position?
I'm an associate professor of ecology, restoration, and natural resource management at Colorado State University in Fort Collins, Colorado.
Is an accurate copy of your curriculum vitae attached as Exhibit 13?
It is.
Dr. Selton-Foos, can you briefly describe your work and experience, particularly as it relates to the proposed rules for surface water discharges?
Absolutely. I teach courses on ecology and restoration, including courses specific to wetland restoration. My research includes both field ecology and the development of policy guidance related to restoration and mitigation of impacts to aquatic resources, including wetlands and rivers. I have experience providing policy recommendations to federal agencies, and I'm currently collaborating with the National Park Service and have historically collaborated with the U.S. Army Corps of Engineers, specifically related to wetland mitigation. Regarding state policy, I recently worked with stakeholders in Colorado to develop, or the development of Regulation 87, to develop language for that, which is Colorado's new rule to regulate dredge and fill activities that impact state waters, including provisions related to compensatory mitigation for surface water discharge impacts.
Dr. Selton-Foos, did you provide direct and rebuttal testimony on behalf of water protection organizations marked as Exhibits 14 and 21?
Yes.
Is that written testimony accurate to the best of your knowledge, and do you adopt it today?
I do. It is.
you. Dr. Sultan-Foos, in broad terms, what opinions will you provide in your testimony today, your summary of testimony?
My testimony will address the importance of protecting New Mexico's aquatic resources, including wetlands and ephemeral streams. I will explain the concepts of compensatory mitigation and functional assessments. I will address why it is important to require compensatory mitigation for unavoidable losses to the functions of New Mexico's aquatic resources, in addition to lost acreage, and how such losses should be quantified using an approved functional assessment methodology, such as the New Mexico Rapid Assessment Method, which is already being used in the state. These opinions support amendments to NMED's proposals that are being offered by water protection organizations, as outlined in detail in my direct and rebuttal testimony. My recommendations are based in part on analogous regulatory requirements under Section 404 of the Clean Water Act, the 2008 mitigation rule, and what is being done in other states, including Colorado under the recently established Regulation 87.
Thank you. Let's start by talking about wetlands. What important functions do wetlands serve in New Mexico?
Wetland functions benefit humans in many ways, especially in the arid Southwest, where wetlands are naturally rare. For example, wetlands store water and regulate river flows, helping maintain stream flow during dry periods and lowering the intensity of flood events. Flood damages to life and property are consistently highest in areas where floodplains and wetlands have been the most altered. Additionally, wetlands improve downstream water quality by retaining sediment and the phosphorus that is often absorbed onto those sediments, and by transforming nitrogen, typically in the form of nitrate, which can cause algal blooms and fish die-offs, into benign nitrogen gas, which simply diffuses into the atmosphere. Finally, wetlands support biodiversity by providing habitat and access to water. Although wetlands provide significant biodiversity support across the world, their role in supporting biodiversity in arid systems is particularly important. Not all wetland types perform all functions at all times. For example, a high elevation groundwater fed wetland, which we might call a wet meadow or fen, provides carbon sequestration and water flow regulation to downstream systems, while a floodplain wetland in the Rio Grande Bosque provides water quality improvements and habitat for many species. Although each aquatic resource is important for its functionality, it is the combined action of each aquatic resource and riparian area at a large watershed scale that sustains the health of the watershed and promotes resilience.
Can you give some?
I'm sorry, Dr.
Certainly.
Sultan-Foos, would you keep it a little slower?
Slower, absolutely. Thank you.
Can you give some examples of wetland types that exist in New Mexico?
Yes, there are many different wetland types that exist across the arid Southwest landscape, each with different landscape positions, characteristics, and functions they provide. New Mexico has wetlands associated with rivers, wetlands associated with topographic depressions, such as marshes and playas, and wetlands at high elevations associated with groundwater discharge that creates springs or slope wetlands.
Are wetlands consistently and continually wet?
No, it only takes a small amount of time for inundation or saturation to lead to wetland conditions. Many wetlands in the arid Southwest may actually only be wet for a few weeks out of the year.
In general, what is meant by avoiding, minimizing, and ensuring there are no significant impacts to wetland area and functional values, and why are those measures critical to protecting wetlands?
Once a wetland system has been degraded, our ability to restore that wetland to the previous level of ecological integrity and functional value is really quite limited. Because restored wetlands don't function as well as unimpacted wetlands, it is important to avoid wetland impacts wherever possible, and then if impacts are unavoidable, to minimize unavoidable impacts. One way to minimize impacts is to site a project in location that will impact only lower functioning wetlands, thereby avoiding impacts to higher functioning wetlands.
What is compensatory mitigation, and what role does it play in protecting wetlands and aquatic resources?
Compensatory mitigation is the way we address impacts to wetlands and aquatic resources after appropriate and practicable actions have been taken to avoid and minimize impacts. Compensatory mitigation is a regulatory requirement that refers to the restoration, establishment, enhancement, or in very limited scenarios, preservation of aquatic resources to offset impacts that cannot be avoided during permitted activities. Compensatory mitigation is intended to not just offset lost area, but also lost functions and values. Over half of all originally existing wetlands in New Mexico have already been lost from land use change. So compensatory mitigation is critical to maintain the current extents, functions, and values of the aquatic resources in riparian areas that still exist.
Before we move on to specific proposals, what is the general reasoning and framework for the Water Protection Organization's proposed recommendations for compensatory mitigation?
Well, I support the proposed amendments because they are scientifically sound and reflect best practices developed in analogous programs. The amendments clarify when compensatory mitigation is required, establish clear expectations of how it should be done, and ensure that unavoidable impacts to aquatic resources are in fact offset. The structure and substance of the proposed amendments closely track the Federal Clean Water Act framework and are also consistent with Colorado's recently adopted Regulation 87, which provides a useful regional comparison as the most recently adopted comprehensive state dredge and fill program in the Western United States. The New Mexico proposal adopts many of the core concepts in the other programs: functional replacement, watershed scale planning, clear guidance for mitigation plans, clear direction to applicants, and a hierarchy of mitigation options.
Thank you. Let's turn to Water Protection Organization's proposed amendments to 20.6.2 NMAC. And from here on, I'm not going to say 20.6.2. We'll be speaking to sections of that regulation only. And let's start with Section 2307J, which addresses compensatory mitigation requirements for both individual and general permits. This subsection, as proposed by Water Protection Organizations, is too long to fit on a slide that's useful. So for the full provision, I refer the Commission to our Exhibit 1, pages 36 through 38 from our direct NOI. Dr. Salton-Foos, please start by discussing your opinion of the proposed subsection overall, and specifically the first paragraph is shown on the slide.
Yeah, this introductory paragraph of Section 2307J, as proposed here, as seen on the slide, establishes clear thresholds above which compensatory mitigation is required while preserving regulatory discretion for smaller impacts. I recommend removing the language that would allow NMED to waive the mitigation requirement above the stated thresholds if the, quote, adverse environmental effects of the proposed activity are no more than minimal, end quote. In an arid state like New Mexico, where over half of the originally existing wetlands have already been lost in a landscape that didn't have many to begin with, all impacts above the stated threshold should require mitigation. Removing this clause makes it clear that any impact above the threshold requires mitigation, removing any ambiguity for the regulators and the regulated public.
Can you explain the proposed addition of the phrase "and functions" to Section J1?
The addition of "and functions" in this clause ensures consistency with the rest of the regulatory program, taking into account both acreage and function when considering impacts and required mitigation. Two wetlands of equal size may provide very different levels of flood attenuation, nutrient processing, habitat, or groundwater recharge. For example, the images on this slide are from the exact same mountain valley, the same wetland area. But due to past land use, one wetland area has had significant degradation, as can be seen by this large amount of bare ground, while the other is intact and fully vegetated. We could impact the same acreage from each of these areas, but the current functions being provided by the higher condition wetland should be acknowledged when considering compensatory mitigation requirements. Simply restoring acres is insufficient to maintain the functions and values we currently have across the landscape.
Dr. Salton-Foos, please explain the basis for the proposed changes to Section J2 as they relate to mitigation ratios.
Identifying mitigation ratios is often a negotiation process with the regulator. This section directs NMED to develop mitigation guidance on how to calculate appropriate mitigation ratios and ensures those ratios are at least 2 to 1. A ratio of at least 2 to 1 is needed for two reasons. First, restored sites do not function as high as unimpacted sites and require a long time for ecosystem development. Recognizing the difference in functionality between an unimpacted site and a restored site, ratios in excess of 2:1 are needed to truly offset loss function. Second, regulatory programs to date have not actually stopped wetland losses around the country. To address these issues, permitting actions under the federal 2008 mitigation rule often require mitigation ratios in excess of 1:1 to account for various aspects, like the likelihood of success and differences in functions lost and functions gained through mitigation, among other criteria. Ratios are typically higher for impacts to more rare wetland types, like forested wetlands, and lower for more common aquatic resources, like open water features.
Dr. Saltenfuss, can you walk the commission through the proposed changes to section J2C, which would require NMED to develop mitigation guidance that is consistent with the federal mitigation requirements and that addresses various requirements for mitigation plans?
The requirements in section J2C are already established in other programs. These requirements reflect what is required in mitigation plans for the federal regulatory program as set forth in the 2008 mitigation rule, as well as in Colorado Regulation 87, which leans heavily on the federal program. Site protection instruments, financial assurance, and performance standards are particularly important. Site protection instruments and financial assurances are legal mechanisms that ensure mitigation sites are protected into perpetuity and that funding exists for the long-term management of mitigation sites to ensure lasting functionality. Performance standards are a requirement of any mitigation at the federal level and a requirement under recent Regulation 87 of Colorado, and it is important to include them here to ensure that mitigation sites are ecologically functional according to clearly articulated criteria.
Turning to general permits, why is it important to include each of the compensatory mitigation requirements in a general permit as set forth in proposed section 2305C6?
NMED should not issue general permits that allow impacts greater than the identified threshold unless compensatory mitigation requirements are described in the permit. The proposed language helps ensure that a project proponent seeking coverage under a general permit is aware of mitigation requirements. This will reduce the burden on NMED staff to explain these details to the applicant. But to be clear, this proposed language does not require compensatory mitigation of all permittees who obtain coverage under a general permit, but rather requires NMED to include the thresholds and requirements for compensatory mitigation as set forth in section 2307J. In each general permit as set forth in 2307J, in each general permit to clarify when mitigation is required. If a discharge doesn't trigger the thresholds, then the permittee wouldn't be required to undertake compensatory mitigation.
Regarding general permit coverage, what is the basis for the proposal requiring an explanation in a pre-construction notification of how mitigation requirements will be met if the proposed permit activity will result in an unavoidable loss greater than 1/10 of an acre of surface waters or 1/300th of an acre of a stream bed as set forth in Water Protection Organization's proposed section 2306A4K?
Requiring applicants to include compensatory mitigation requirements in the pre-construction notification ensures applicants will determine upfront whether their activity will have impacts above the acreage thresholds identified in section 2307J. This will facilitate a smooth permitting process for applicants and NMED staff and avoid confusion and wasted time in back and forth conversations to explain and clarify mitigation requirements.
Dr. Saltenfuss, you've talked about the importance of considering the functions of aquatic resources as defined in section 7F5, in addition to quantifying the impacted acreage. Please summarize why this is important and explain the basis for the Water Protection Organization's proposal to amend sections 2305D4 and 5 and section 2307G4, all to include aquatic resource function in addition to acreage.
In Exhibit 79A, NMED defines functions in Section 7F5 as, quote, the physical, chemical, biological, and hydrological processes that occur in aquatic ecosystems, end quote. I support this definition. It is important to consider impacts to aquatic resource function in addition to impacted acreage, because acreage alone does not describe what an aquatic resource does for a watershed, downstream users, or ecological systems. Aquatic resource functions are the mechanisms and processes through which wetlands and streams provide real environmental value. Without considering function, a permitting program risks treating very different resources as equivalent simply because they occupy the same number of acres, which can lead to incomplete avoidance, insufficient minimization, and inadequate mitigation. Including function in avoidance and minimization requirements, as proposed in sections 2305 D4 and D5. Fair enough. Including functions in avoidance and minimization requirements, as proposed in sections 2305 D4 and D5, and in section 2307 G4, improves decision-making at the front end of the permitting process. When applicants must consider functional impacts, they are encouraged to design projects that avoid disrupting the most ecologically valuable areas of a site, even if alternative designs result in a similar acreage of impact. Remember those two wetlands from the earlier slide, one higher condition, one lower condition. From a regulatory standpoint, this ensures that avoidance and minimization are not reduced to purely geometric exercises, but instead focus on protecting the processes that maintain water quality, habitat, and stream stability.
What is the basis for proposing a definition for New Mexico Rapid Assessment Method in section 7N1? Please also describe how tools like this can be used to perform functional assessments.
Including this definition in the rule makes it clear that functions will be assessed using an approved tool or framework rather than qualitatively characterized by an applicant. Many functional assessment methods exist around the country, and because aquatic resources vary across regions, functional assessment methods are generally developed for specific states or regions. The level of rigor and detail varies among different assessment methods. Some require detailed field data collection, while others are designed to be rapid, completed in less than a single day in the field. Although creating a new functional assessment method is an arduous task, the New Mexico Rapid Assessment Method, NMRAM, already exists and has been calibrated for various aquatic resource types across the state. The NMRAM is based on the California Rapid Assessment Method, which has been used for approximately 20 years. The NMRAM can be used to assess sites before they are impacted, as well as before and after restoration to document restoration outcomes.
Why is it important for a general permit to specify the use of an approved functional assessment tool as set forth in proposed section 2305 D7?
Compensatory mitigation is required for impacts to aquatic resource function in addition to acreage. So a functional assessment is therefore needed to characterize and quantify impacts to aquatic resource functions.
Thank you for your direct testimony. We will now move on to Dr. Seltenfuss's rebuttal testimony. Did you provide rebuttal testimony in this matter?
Yes, my rebuttal testimony is Water Protection Organization's Exhibit 21.
At the outset, do you have any general comments regarding the direct testimony filed by other parties in this matter?
Yes. In my opinion, the proposals from Natural Resource Partnership, or NRP, seeks to inappropriately narrow the scope of 20.6.2 NMAC. NRP seeks to build loopholes into the regulation, burden NMED with unworkable requirements, and narrowly define the regulation to cover only those surface waters that were covered by federal regulations immediately prior to the U.S. Supreme Court Sackett decision in 2023. NRP attempts to justify their red line changes by asserting that they would increase clarity and transparency, yet much of the language proposed by NRP would make the rule more ambiguous. NRP's suggested changes appear to be aimed primarily at removing surface waters and aquatic resources from protection under this regulation.
As you noted, NRP argues that New Mexico should regulate only those waters that would have been considered waters of the United States, or WOTUS, under the federal permitting program immediately prior to Sackett, which narrowed the scope of waters subject to federal jurisdiction. In your opinion, would this approach provide adequate protection for New Mexico's surface waters?
No, this approach would not provide adequate protection for New Mexico's surface waters and watersheds. First, NRP's proposal disregards the fact that the jurisdictional limits of federal regulation have fluctuated broadly over time. The federal 404 dredge and fill program only regulates jurisdictional waters of the United States. There have been many adjustments to WOTUS definitions since the Clean Water Act was passed in 1972. Simply choosing the definition that was in place right before Sackett feels arbitrary. Second, even before the Sackett decision, the federal program was not adequately protecting the aquatic resources of New Mexico, including some ephemeral streams, wetlands, and playa lakes. The federal 404 program was created to protect navigation and commerce on large perennial river systems, primarily in the eastern US. Most of New Mexico's surface waters don't serve this function, although they serve many other important functions. And many of New Mexico's surface waters lost federal regulation after US Supreme Court decisions in 2001 and 2006, long before Sackett. Finally, streams and wetlands are more rare in New Mexico than in the eastern US, and their rarity makes them disproportionately important to watershed health. We should regulate these systems to support the wide variety of functions they provide.
Let's talk about ephemeral waters. In their testimony for NRP, Mr. Lindenlaub and Mr. Pierce target ephemeral waters as resources that should be carefully scrutinized for protection. Why are ephemeral streams important?
Ephemeral streams are the dominant stream type in New Mexico. They make up over 80% of the streams in arid and semi-arid states and are particularly important to watershed health in the Southwest. Ephemeral streams are headwater systems that transport and regulate water, sediment, nutrients, and organic matter to perennial waters downstream. These systems function not only during flow events, but also when the channel appears dry. Water moves underground through what we call the hyperheic zone, beneath and adjacent. Hyperheic. Hyporheic. A hyperheic zone beneath and adjacent to channels, providing regulatory function to downstream systems and important groundwater recharge functions. In arid states like New Mexico, this groundwater recharge function is particularly valuable because a substantial portion of groundwater aquifer recharge occurs within these channels as compared to the surrounding uplands.
NRP witnesses Mr. Lindenlaub and Mr. Pierce argue that NMED's definition of surface waters lacks criteria that define ephemeral drainage in terms of the frequency of flowing water, the relationship of an ephemeral drainage to a river or other perennial water, and the functions of an ephemeral drainage that qualify for regulation, including the presence of aquatic resources. What is your response?
Mr. Lindenlaub and Mr. Pierce continue to view this regulation under the overly limited scope of the Clean Water Act. NMED's proposed regulation protects and regulates impacts to all ephemeral surface waters, regardless of their orientation in relation to other rivers and perennial waters. Additionally, the proposed regulation recognizes and protects all the functions that ephemeral waters provide. It is unnecessary for this regulation to specify either connective properties with adjacent features or specific functions. New Mexico defines ephemeral at section 20.6.4.7 E3 NMAC as a water body that, quote, contains water briefly only in direct response to precipitation. Its bed is always above the water table of the adjacent region, end quote. The two parameters in this definition provide clear guidance. First, an ephemeral surface water is only wet immediately following and because of precipitation. This is different from intermittent surface waters that flow seasonally and predictably during the wet season. Second, an ephemeral water must have a bed, which is a geomorphically important term useful in distinguishing ephemeral streams from erosional features. Erosional features are now specifically excluded from being a surface water in the revised definition proposed by NMED in section 7S11 in Exhibit 79A. A stream bed is created by sustained water transport, even if that water transport is ephemeral, which is differentiated from an erosional feature with very short-term runoff. These hydrologic differences create visually distinct features. A stream bed will have a more defined, stable channel with a distinct channel bed at the bottom, with sediment sorted into different sized sands and gravels. An erosional gully, in contrast, will be more V-shaped, with no distinct and stable bed at the bottom and unsorted sediments. In my opinion, the existing definitions of surface waters and ephemeral provide adequate criteria to identify ephemeral surface waters.
Related to that, Mr. Pierce objects that the definition of surface waters includes tributaries to ephemeral streams because these could include rills or gullies, which are considered erosional features. What is your response?
I believe Mr. Pierce dramatically overstates the lack of clarity. He claims that professionals will have a difficult time identifying ephemeral streams. The criteria for ephemeral streams are established in New Mexico rule and are well established by federal guidance, including the federal guidance provided by NRP as exhibits. Mr. Pierce argues that all tributaries can be defined differently by different people, and some may include rills and gullies. I personally know of no technically trained person who would identify a rill or gully as an ephemeral water. Additionally, erosional features are now specifically excluded from the definition of surface water as proposed in NMED's Exhibit 79A, which should address Mr. Pierce's concerns.
Along the same lines, Mr. Pierce asserts that small washes or arroyos with low volume, infrequent, or short duration flows should not be regulated under the rule. And Mr. Lindenlaub similarly expresses concern that under NMED's proposed definition of surface water, desert areas with very small channels and infrequent flows would be regulated. In your opinion, are ephemeral washes and arroyos with low volume, infrequent, or short duration flows important to overall water quality protection in New Mexico?
They are. It is important to identify desert areas with very small channels and infrequent flows as ephemeral streams, if these features have a defined bed. If that's the case, then these features are surface waters of the state and should be protected. In my opinion, the inclusion of the word bed in the definition of ephemeral limits regulatory oversight of erosional features that do not meet the definition of surface waters. Ephemeral channels are the dominant channel type in New Mexico and, as headwater systems, provide critical functions for downstream areas.
Mr. Lindenlaub claims that ephemeral waters provide fewer functions than perennial waters, and that mitigating impacts to ephemeral waters in kind is difficult. What is your response?
Scientific evidence is clear that ephemeral systems provide different functions than perennial waters, but not fewer. The federal 404 program has been so focused on navigable waters that the regulated public has not had the opportunity to learn about the functions provided by ephemeral streams. While they clearly are not important for navigation, ephemeral streams are important for water quality, flood mitigation, and aquifer recharge. I do agree with Mr. Lindenlaub that impacts to ephemeral waters are more difficult to mitigate in kind. However, this is not a scientifically valid argument to not regulate them. Ephemeral streams are subject to the same sources of impairment as perennial waters, yet have less ability to recover due to their limited flows. If a valued resource is particularly hard to restore and replicate on the landscape, we should go to greater lengths to protect that resource from impacts in the first place. Fortunately, a robust body of knowledge on ephemeral surface waters exists, and methods to evaluate their condition and functional capacity have been developed. The Commission should include ephemeral streams in this regulation, recognizing that they provide unique functions that are distinct from perennial systems.
Let's move back to wetlands. In his written testimony, Mr. Lindenlaub argues that the existing definition of wetlands at section 20.6.4.7 NMAC is overly broad because it includes wetland type features that are isolated and not supportive of other protected surface waters. What is your response?
Some people have a misconception that the definition of a wetland includes whether it is jurisdictional at the federal level. As defined in New Mexico's existing regulations, a wetland is an area that is inundated or saturated by surface or groundwater at a frequency and duration sufficient to support, and under normal circumstances does support, a prevalence of vegetation typically adapted for life in saturated soil conditions. The three parameters for determining if something is a wetland thus include hydrology, hydric soil characteristics, and a vegetation community dominated by wetland plants. At the federal level, if all three parameters are met, the area is a wetland, regardless of its jurisdictional status. If a wetland is identified, a prospective permittee must coordinate with the U.S. Army Corps of Engineers to obtain a jurisdictional determination. If it isn't jurisdictional, the area is still a wetland from a technical perspective. It just isn't regulated under the Clean Water Act. If a feature has wetland vegetation, hydric soils, and wetland hydrology, it is a wetland that provides critical functions for watershed health and should be included in New Mexico's regulation.
Mr. Lindenlaub and Mr. Pierce provide testimony in support of NRP's proposal to add more, quote, limitations or exclusions to the scope of regulated surface waters in Section 10C. They propose to exclude 11 additional categories of waters based on exclusions in Colorado's Regulation 87, including an exclusion for wetlands adjacent to a ditch or canal. What is your response to NRP's proposed exclusions?
I do not support NRP's proposed exclusions. First, it should be noted that both Mr. Lindenlaub and Mr. Pierce acknowledge that some of their described categories are already excluded under the existing definitions of surface waters. It is therefore unnecessary to include further exemptions for these features. Moreover, in aggregate and by individual component, NRP's proposed exclusions are not appropriate for New Mexico. SB 21 already included statutory exemptions based on the Clean Water Act. Adding additional negotiated exclusions from Colorado law would undermine the scope of protections under SB 21 and proposed by NMED. I am especially concerned about NRP's proposal to exclude wetlands adjacent to a ditch or canal that are supported by water from that ditch or canal. This slide illustrates this type of wetland and shows really how nice these features can be. NRP's proposed exclusion could affect the ecological function of New Mexico's important wetland features. Western states rely heavily on river water for irrigation, not new information. We divert water and send it across miles and miles of upland area. These diversions, though, have dried up many acres of wetland and riparian habitat along our western rivers. However, these lost wetlands have been inadvertently replaced over time due to inefficiencies of our irrigation infrastructure. Leaky ditches and flood irrigation have led to the creation and maintenance of wetlands across the landscape. These wetlands provide refugia for wildlife, drought resilience to surrounding areas, evaporative cooling to the immediate vicinity, and base flow regulation and improve water quality for down gradient streams. Wetlands that are situated between agricultural landscapes and streams transform the nitrogen from fertilizer into that benign gas I mentioned earlier, preventing harmful algal blooms and dead zones in downstream water bodies. Regulating areas based on what they were historically would be logistically impractical. Instead, we should identify and regulate wetlands based on current conditions. I urge the Commission to include ditch-created wetlands as regulated features, regardless of their hydrologic source.
Mr. Pierce asserts on behalf of NRP that NMED should publish a map of surface waters used to determine whether a discharge permit is necessary, and argues that it is essential for this map to be subject to public comment and review by appeal to the Commission prior to use. What is your response?
While I support the creation of tools that facilitate decision-making and regulatory clarity, NRP's proposal is unworkable and with no precedent. At the federal level, there is no map that shows the true extent of jurisdictional WOTUS or state waters. Even if this hypothetical map did exist or could be accurately created, if a prospective permittee came across a water feature that contained the parameters identifying a wetland or stream, but was not identified on the map, that permittee would still be held to existing federal or state regulation. NRP is trying to put the onus on NMED to identify every single regulated feature in the state, which would be overly burdensome, if not impossible, and should not be the responsibility of NMED.
Mr. Lindenlaub claims that New Mexico needs a definition for ordinary high water mark to identify the outer boundary of a particular surface water. He proposes adopting the definition from Colorado's Regulation 87 and argues this definition should be used to determine the boundaries and area of a surface water to be regulated. What is your response?
I disagree with NRP's proposal that the ordinary high water mark should be used to identify the lateral limits of surface waters that can be regulated. But I'd like to clarify a few things, including first, the approach used in the federal program, which uses the ordinary high water mark to regulate impacts outside the lateral limits of that ordinary high water mark. Second, how difficult it is to actually identify the ordinary high water mark, particularly in degraded southwestern streams. And third, how New Mexico does not need to be constrained by how the federal program or other states operate. Although federal regulations provide the Corps with regulatory oversight of direct impacts within the ordinary high water mark, activities outside the ordinary high water mark that are detrimental to the health of that water body are still regulated at the federal level. The ordinary high water mark is a useful indicator for distinguishing between ephemeral channels and simpler erosional features. Ephemeral channels have an ordinary high water mark, but swales, gullies, and other erosional features do not. Regulation 87 in Colorado, for example, references the ordinary high water mark as a defining feature for identifying non-wetland state waters and differentiating them from erosional features like swales and gullies. The Colorado regulation does not, however, use the ordinary high water mark to identify the lateral extent of the regulated area. It's worth noting how difficult it can be to identify morphological features in stream channels in general, and how erroneous these field determinations can be in degraded systems specifically. Many ephemeral and intermittent stream channels are heavily impacted from a long history of detrimental surrounding land use. Incision is a common impairment in streams that disconnects the stream from the adjacent riparian area, with steep walled banks leading to the bottom of the stream channel. Because of this deep incision, the ordinary high water mark of these systems is normally at the bottom of this deeply incised channel. Not only is the ordinary high water mark feature difficult to identify in features like this, you can see one example on the screen here, but in my opinion, that's not actually what we want to protect. Those steep-sided channels are not normal, and we should be trying to protect and restore these stream systems from adverse impacts. Using the ordinary high water mark to delineate the lateral boundary of degraded and incised streams would mean that building and impacts could literally occur right up to the edge of that unstable bank. Building right up to the channel margin decreases stability and further impacts these systems. In addition, allowing impacts and development right up to the bank of an impaired stream essentially guarantees that some degraded systems will never be reconnected to the floodplain and restored to previous conditions in the future. I encourage the Commission not to limit New Mexico's regulatory protection of surface waters to just the lateral extent of the ordinary high water mark.
Mr. Lindenlaub states that NRP's proposed definition of ordinary high water mark is an appropriate basis to determine the acreage of a surface water in New Mexico and can be applied to all non-wetland surface waters. What is your response?
By definition, it is possible to use the ordinary high water mark to calculate the acreage of impact to non-wetland state surface waters. However, this simple area calculation is not sufficient to identify and quantify the full range of impacts a project will have on the functioning of adjacent surface waters and riparian areas. Discharging fill into areas immediately adjacent to waterways leads to significant impairment. Many restoration projects around the country are now focused on removing these features, like riverside levees, for example, to provide more lateral space for the rivers to fluctuate.
Regarding applications for individual permits, NMED's proposed language in 2304C2i would require an applicant to specify reasonable alternatives that are appropriate for the project and have the least adverse impact on aquatic resources. NRP proposes to instead require an applicant to specify reasonable alternatives that are appropriate and have been considered for the project. What is your response?
The witnesses for NRP consistently request more clarity and transparency in the regulatory language. Yet NRP's language introduces ambiguity regarding how alternatives should be considered. Project alternatives can be considered, quote, reasonable through a wide variety of lenses, with project cost being the most common. NRP's proposed language would allow an applicant to simply choose the least expensive alternative. In my opinion, the regulation should require applicants to consider alternatives that lead to the least adverse impact on aquatic resources.
NRP proposes to restrict general permit conditions to not be more stringent than the conditions in the corresponding federal general permit as certified by the state. What is your response?
The federal regulatory program has failed to protect and regulate impacts to the aquatic resources of New Mexico. My hope is that this program will address this deficiency. Permits issued under regulations implementing SB 21 should not be limited to the conditions in federal permits certified by New Mexico in the past. SB 21 goes beyond federal requirements by requiring that the Commission's rules protect aquatic resources, which is broadly defined in the Water Quality Act as wetlands, streams, rivers, lakes, playas, and other bodies of water, riparian habitat, and the organisms that live in them, and the ecological functions, services, and values they provide. New Mexico should take this opportunity to do what the federal program has never done and create a regulatory framework tailored to the New Mexico landscape that reflects the conditions and needs of New Mexico and its watersheds.
Thank you. This concludes Dr. Saltonfus's summaries of testimony. Water protection organizations move for admission of exhibits 13 through 17 and 21 through 24, which were filed with our direct and rebuttal testimonies.
13 through 17 and 21 through 24. I'll pause for objections. They're admitted. Thank you very much.
Thank you, Madam Hearing Officer. We do have some brief rebuttal from Dr. Saltonfus that responds directly to other witnesses' rebuttal. Should we go ahead and proceed? I see it's about 11:49.
Yes, as long as it'll fit in about 10 minutes.
Well, I think we can do that.
I'll try to not talk too fast, though.
Coasting right through. All right. Let's see. On pages 33 and 34 of Director Lemon's rebuttal testimony on behalf of NMED, she objects to Water Protection Organization's inclusion of 20.6.2, 2305 A1 and 2 NMAC. I've got the whole thing in there again, relating to general permits of requirements to follow federal regulations for point source discharges and dredge and fill activities. She states that adopting the federal regulations into this rule will reduce NMED's flexibility, and the NMED can incorporate appropriate federal concepts during implementation without constraining the program's flexibility. What is your response?
Because federal regulations have not done enough to protect New Mexico surface waters, we should ensure this new regulation is at least as protective as the federal regulation. The uncertainty of regulators making different decisions through time due to lack of clarity in regulations is frustrating to the regulated public and does not ensure adequate protection in all cases.
On page 43 of Ms. Lemon's rebuttal testimony, she objects to Water Protection Organization's proposed amendments to Section 2307J, which set forth more detailed requirements for permit conditions for compensatory mitigation. Again, this is the long section that I didn't want to put on a single slide, so that's our Exhibit 1, pages 36 to 38 in our direct NOI. Ms. Lemon believes the requirements would reduce program flexibility and responsiveness without demonstrable improvements in water quality outcomes. What is your response?
I agree with the portion of Ms. Lemon's rebuttal testimony that providing flexibility for practical innovation and adaptive mitigation approaches tailored to New Mexico conditions is valuable. But I do not think that innovation will be stifled by requiring applicants to critically think through and explain their mitigation approach in advance. In contrast, I think requiring applicants to exactly describe how they propose to meet their mitigation requirements will foster the creative thinking and innovation NMED wants to see. Based on lessons learned from the federal program, if compensatory mitigation details are not provided up front, the compensatory mitigation effort becomes ad hoc and not well thought out, leading to significant ecological failure of mitigation sites. Requiring applicants to think through their mitigation in advance encourages them to think critically and creatively, and, in my opinion, may encourage the innovation Ms. Lemon wishes to see. I do not agree with Ms. Lemon that our proposed amendments would not lead to demonstrable improvements in water quality outcomes, but rather I believe our proposed amendments will lead to significant improvements in water quality outcomes. As has been learned at the federal level, mitigation outcomes are poor when requirements are kept low or not specified. Loosely defined requirements make it difficult for regulators to maintain the high standards that are required for mitigation outcomes to be ecologically meaningful. I believe our proposed amendments would lead to demonstrable improvements in water quality and provide NMED regulators with certainty that mitigation sites will be objectively monitored and performance more likely.
Ms. Lemon also objects to Water Protection Organization's proposals for additional permit conditions for compensatory mitigation, including conditions for monitoring, a maintenance plan, an adaptive management plan, and financial assurance requirements, on the ground that NMED has enforcement tools and procedures to address project failures without overburdening NMED or applicants. What is your response?
The National Research Council evaluated compensatory mitigation sites around the whole country and published their findings in a 2001 report that highlighted the lack of ecological success of compensatory mitigation sites and suggested that regulations change to include, among other things, performance standards and associated monitoring. This led to increased requirements outlined in the 2008 mitigation rule, which has subsequently led to an improvement in compensatory mitigation sites as project proponents are forced to think through all of the details of their proposed mitigation activities. And the financial assurances ensure they have the funds to adequately address issues that arise. It is important for mitigation sites to be monitored and maintained in the early years of development following mitigation activities. Forcing applicants to create a monitoring and maintenance plan and link monitoring outcomes with adaptive management solutions ensures issues that are identified can be fixed immediately. Waiting multiple years to address deficiencies is problematic, and without requiring monitoring, maintenance, and adaptive management, the applicants will have no reason to go through these extra steps. The likely result is that poorly performing sites will not be addressed and fixed soon enough. And in some cases, the ecological failures may not be identified at all. Although NMED has enforcement tools to address project failures, I don't understand why we would wait for projects to fail rather than ensuring projects are successful in the first place. The lack of these same requirements led to the failure of mitigation sites around the country, and without them will likely lead to the failure of similar sites in New Mexico. These components of a mitigation plan are consistent with the federal program and other states, and requiring them has improved mitigation outcomes across the country. I believe these requirements are worth including in New Mexico.
On page 4 of Thomas Shelley's rebuttal testimony on behalf of NRP, he objects to the addition of a definition for New Mexico Rapid Assessment Method and the proposed use of the New Mexico Rapid Assessment Method. He asserts that it's best not to define and use specific tools in the regulation that may change over time or be replaced by new science and tools in the future. What is your response?
Because this regulation is protecting surface water area and function, and because functions are multifaceted and nuanced, we need a way to assess and quantify functions being provided by a particular surface water. New Mexico can certainly create a new functional assessment for this program if it desires, but there already exists a functional assessment for the state that was created from a well-studied functional assessment method already in use. Water protection organizations propose to define New Mexico Rapid Assessment Method as an existing evidence-based tool approved by the department for assessing wetland or riparian condition and an associated database system to track outcomes. The current version of the New Mexico Rapid Assessment Method, along with associated field guides and manuals for assessing various wetland types, is already available on NMED's public agency website and already being used and updated. The goal of including a definition of the New Mexico Rapid Assessment Method is to point out that this tool has been created and is already available for use. However, as Mr. Shelley rightly points out, best available science changes over time and our regulations may change accordingly. Ideally, the tools we currently use would also be modified according to these updates. But it is important to provide flexibility to allow for assessment tools that may become approved by NMED in the future. The goal of this proposal is to require a department-approved methodology for performing functional assessments. The proposed definition is intended to provide regulatory certainty about the process while allowing NMED to incorporate new science and tools over time. As an example of our ability to update these assessment frameworks, the Colorado Rapid Assessment Method, California Rapid Assessment Method, which many functional assessment methods around the country have been built from or inspired by, including the New Mexico Rapid Assessment Method, is now on version 6, highlighting the ability of these tools to be updated with new information. Even the New Mexico Rapid Assessment Method is on its second version, so has already been updated with new information. Because functions can be difficult to quantify and characterize, an approved functional assessment method should be required, and we are lucky to already have one created specifically for the state of New Mexico.
On page 5 of Mr. Shelley's rebuttal testimony, he asserts that water protection organizations' proposals rely heavily on vague and subjective concepts, such as ecological function, watershed connectivity, riparian influence, aquatic resource values, and landscape scale significance. On page 7, he also argues that the proposals improperly expand regulation from surface waters to undefined aquatic resources. What is your response?
My understanding is that these concepts are already part of New Mexico's Water Quality Act, which again defines aquatic resources as wetlands, streams, lakes, rivers, and other bodies of water, riparian habitats and the organisms that live in them, and the ecological functions, services, and values they provide, and requires the Commission to adopt rules that will avoid and minimize adverse impacts to, quote, aquatic resources. Aside from aquatic resources, Mr. Shelley argues that functions, services, values, riparian area, and, quote, watershed scale ecological processes are broad and undefined, which is demonstrably untrue, and lead to a shift away from what the federal program has regulated in the past, which is also inaccurate. The 2008 mitigation rule included many of these concepts into the federal 404 program, including functions and values, and the need to think at a watershed scale while evaluating impacts and mitigation. Although broad, these are not undefined terms, but rather well-used terms across the country. The regulated community is already familiar with these concepts from the federal program. And additionally, I would imagine that many citizens in New Mexico and the Western US can identify riparian habitat. Where uplands are brown and dry, riparian areas serve as a recognizable oasis, this green line through the brown Southwest. Mr. Shelley's argument represents a fundamental misunderstanding of the importance of these functions, these surface water features provide, as well as a misunderstanding of the existing federal rules around the Clean Water Act. The U.S. Army Corps of Engineers does not focus solely on the limits of identifiable jurisdictional waters, as Mr. Shelley claims, but also includes the functions, services, and in some areas of the country, the values humans derive from these functions and services. This is why so many functional assessments exist around the country, because functions are protected and mitigated when they are impacted. Although Mr. Shelley may not understand the meaning of these terms, they are widely used across the country and provide meaningful clarity to the proposed regulations.
I do have one more brief question, and I apologize for the delay on lunch, but I think we can do it quickly. Mr. Shelley also objects on pages 5 and 7 that the proposed revisions could result in the regulation of ephemeral drainages, ditches, arroyos, low water crossings, and stormwater conveyances, and would impose urban scale environmental review burdens upon ordinary rural maintenance activities that historically have operated under exemptions or general permits. What is your response?
Briefly, the proposed regulation protects New Mexico surface waters from impacts and requires the mitigation of unavoidable impacts to ensure New Mexico watersheds remain healthy and functional. Among the features Mr. Shelley mentions, ephemeral drainages and arroyos would only be protected if they had a defined bed, if they were a surface water, an ephemeral stream. If they do have a defined bed, they are a surface water of New Mexico that provides valuable functions and hydrologic connectivity to the watershed. Getting rid of these features or negatively impacting them leads to negative impacts to New Mexico residents downstream. As the dominant channel type in New Mexico, these ephemeral streams should be protected. And additionally, it feels self-evident that if a quote low water crossing is required, that feature is most certainly a surface water of the state, and that activity should be done carefully under regulatory oversight.
Thank you, Dr. Seldenfuss. Madam Hearing Officer, we would like to move for admission of Exhibit 25, which has been placed in the shared electronic Dropbox for this proceeding. It's a copy of the existing NMRAM and the associated manuals and field guides. I understand that the administrator, Ms. Jones, has placed that in the docket for this, and I don't know how much discussion, so we can.
All right, let me pause for a moment. In the event there are objections to Exhibit 25. Just the rapid assessment manual. All right, Exhibit 25 is admitted.
Thank you very much. This concludes Dr. Saltonfuss's presentation, and we would like to do the cross-examination on a panel with Ms. Khan and Mr. Sieber after lunch.
All right, thank you.
Thank you very much.
Let's come back at 1:05. Luis and Pam, if you would put something online. We return at 1:05 for public comment. So you might want to clear your computer from that table. Thank you.
Certainly.
Thank you.
We are on day 5 of the hearing in WQCC 25-74. These are proposed amendments and a new rule relating to surface water quality state permitting programs. We've reached the 5th of several public comment sessions. I'll call on those in the room and then those on the platform if you'd like to make non-technical public comment. Just a few things. I will ask you to spell your first and last name or the transcript. I will ask you pursuant to commission rules to swear or affirm to tell the truth. I will ask you to keep your comments to 3 minutes and just make oral comment once. To the extent you have more to say, please put it in writing and send it to Pamela Jones here on the desk. Her information is in the notice of public hearing. So let me just start here. I'll sweep this way. Sir, you're here to offer public comment? Okay, terrific. If you would come up to the front table. And you need to turn the button green. There you are. If you would spell your first and last name, please.
Alejandro Hernandez, ALEJANDRO, HERNANDEZ.
Thank you. Do you swear or affirm to tell the truth? Go ahead.
Good afternoon. My name is Alejandro Hernandez. I live in Albuquerque, New Mexico. First and foremost, I appreciate the opportunity to speak here today. I stand before you today just not for myself, but for many members of my community who were unable to be here. This issue is important to all of us because water touches every part of our lives. It provides It provides for our families, nurtures our gardens, sustains our communities, and supports the wildlife that makes New Mexico so special. When we protect our water, we protect the people, places, and future we all share. As someone who feels deeply connected to nature and appreciates every sunrise and sunset, water has always been incredibly important to me. Growing up, I spent my time caring up for the life around me, feeding stray dogs, watering trees, leaving water for out leaving water out for stray cats and other animals. Some of my favorite childhood memories are from hot summer days spent playing outside with my neighbors, sharing drinks from the garden hose whenever we got thirsty. Those simple moments taught me that water is important. It's a more important resource. It is something that sustains people, animals, communities, and the world around us. It is heartbreaking to imagine a future where the next generation no longer has these same opportunities and experiences. The consequences of losing or regarding our water resources will not only affect hardworking communities, animals, or wildlife, it will affect all of us. Water is something very important depends on, regardless of their background, profession, or position. The decisions made today will impact everyone, including those with the power to make them. None of us will want to live in a future where access to clean water is so limited that people are forced to choose between meeting their basic needs and other necessities. That is why it's important that we protect our water now, before these challenges become even greater. And that's why I'm here standing up and speaking up for a strong water protection regulation. The water in New Mexico is under a lot of stress because of droughts, big industries, and more people needing it. I respectfully urge strong safeguards because it's not a choice. It's about taking care of our neighbors, our natural world, and the way we live that rely on having clean water. Thank you for listening to me.
Thank you, Mr. Hernandez. Other folks over here? If you would spell your first and last name.
Cruz Henley, Cruzhenley.
Swear or affirm to tell the truth. Please go ahead.
Good afternoon. My name is Cruz Henley. I was born and raised in Santa Fe, New Mexico. Thank you for giving me the space for the community to provide public comment on this matter. Water is the most important resource for life. We all know we could not exist without it. I'm speaking before you today because I'm deeply concerned about losing our water to large corporations that seem more focused on their wallets being filled rather than protecting the communities that depend on these resources. For generations, these waters have been a part of people's daily lives, supporting families, traditions, and local ways of life. It is heartbreaking to think that something so essential and deeply connected to our communities could be taken away, putting both our environment and future generations at risk. Growing up, those childhood moments will always be precious to me. Some of my fondest memories were spent with my father, him taking us out fishing at the various rivers, ponds, and lakes throughout the state. These memories are incredibly precious to me because unfortunately I no longer share this physical world with him. The places we visited together hold a special meaning to me because of the moments and memories we created on those waters. What worries me most is that the thought of those places being lost or changed beyond recognition. It is about protecting water and preserving the places that connect us to the people we love and the memories we cherish. I hope to return to those places one day, reflect on the memories we shared, and create new ones with my family and future generations. Protecting these waters and landscapes helps ensure that those opportunities are not taken away from others, just as they should not be taken away from us. I am a firm advocate for mandating that applicants prioritize the avoidance of damage of waterways and wetlands before any mitigation strategies are even discussed. Far too frequently, environmental destruction is regarded as an unavoidable consequence. It is essential that the state compels projects to demonstrate that they have thoroughly evaluated less damaging alternatives and that any projected impacts are truly impossible to circumvent. Water is a basic human need and we must be responsible for taking care of it. I encourage NMED to adopt strong protections that keep our waters clean, healthy, and available for the people families, and wildlife that depend on them, while preserving the places where lasting memories are made for generations to come. Thank you for your time and consideration.
Thank you, Mr. Henley. Other comment? If you would spell your first and last name.
Maria Lozano, MARIA LOZANO.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Good afternoon. My name is Maria Lozano, and I live in Albuquerque, New Mexico, and I'm a photographer, a mother, and someone who cares deeply about the land of enchantment. Thank you for the opportunity to speak today. I appreciate the time you take to hear from the community on a daily basis. As a photographer, I spend a lot of time paying attention to the things people often overlook. I look for beauty in quiet moments, in the landscape around us, and in the connections between people and the places they call home. Through my camera, I have been seeing how important our rivers and natural water areas are to the people of New Mexico. Many of the photographs I treasure most are not just people, but of people experiencing nature together. Families walking along the Rio Grande, children exploring near the water and building a connection to the land, parents teaching their kids about the world around them. These places become part of our memories and our stories. Being a mother has made me think more about the future and the responsibility we have to protect these resources for those who come after us. I hope that one day I will have grandchildren who can experience the same beauty and connection to nature that I have been fortunate to enjoy throughout my life. I want them to walk along clean, healthy rivers, watch birds, and create lasting memories outdoors with their families. Most of all, I want them to inherit a New Mexico where clean water is cherished, protected, and preserved for generations to come. That is why I support strong and robust protections for all of New Mexico's surface waters. Every river, stream, wetland, and waterway matters. Even waters that do not flow year-round play an important role in keeping our environment healthy. They provide habitat for wildlife, help keep water clean, and support the larger water systems that our local communities rely on. New Mexico is a special place, and protecting these waters is our responsibility, especially with rapid climate change. As someone who spends her life documenting memories, I know that what we protect today becomes part of the story we leave behind tomorrow. I respectfully urge you to adopt strong safeguards that protect New Mexico's waters and ensure that future generations can continue to enjoy, depend on, and be inspired by them. Thank you for listening.
Thank you, Ms. Lozano. Other commenters? Sir? If you would spell your first and last name.
First name Brian, Brian. Last name Bodwin, Beaudin.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Good afternoon, Water Commission members. I live in a rural community south of Tijeras. I'm an outdoors person, a fly fisherman, and the current president of New Mexico Trout. I'm also a member of several environmental and conservation organizations. Having moved to New Mexico in 1989 from the northeastern part of the country, one of the things that occurred to me early on after spending some time in our public arenas and things was there was a general attitude towards water protection that was very nonchalant. I found people would say to me, hey, if something happens to that river, I'll just move to the next one. And I found that very curious coming from a state that is 1/22nd the size of New Mexico, but has 3 times more water. And we had a much more proactive public comment or public opinion of how we protected our water. I guess during the Industrial Revolution, we saw so many of our rivers destroyed, and it took 60, 70, 80 years for them to come back, even with lots of government money being thrown at them. So my experience with that was interesting. And going to church on Sunday mornings, we had to cross a fairly large river in western New Mexico, the Naugatuck River. And every day the kind of joke between my brother and sister and I would be, what color will the river be today? Some days it'd be green, some days it'd be orange. You just never knew. And public health said, stay out of the river, because just swimming in the river would make you sick. And so we developed a appreciation for our fresh water that I just didn't see here. And I still kind of don't see that much today. Where I live, we've had serious water issues the last few years. Between our water having high fluoride content, things of that nature, the cost to clean our water up has been extreme. I've experienced water bills in excess of $200 a month for an average usage of about 1,200 gallons, which is quite expensive. And so I see that and say, boy, if we don't have anything to protect the little bit of water we have, what's it going to be like in 10, 15, 20 years? This committee has an opportunity to set the standard for how New Mexico views and protects its water resources, all the way from our springs on the headwater streams, through our wetlands and ephemeral water courses, to the larger rivers those all directly feed. Anybody who lives in Albuquerque knows that a lot of the city water is drawn off of the Rio Grande in years when we have water. So protecting these headwater streams, springs, wetlands, eventually is going to affect the Rio Grande if that water is not coming in clean and usable. As a major player dependent on the water and quality and quantity of water we have available, I believe the Department of Wildlife should have a say or a seat at the table on what happens with our streams and water courses in this state. They are in charge of making sure we have fishing, we have quality water to put fish in. We spend a lot of money in those departments and stocking fish. So I think they have a say in what goes on with our water. And I can tell you, as someone who's regularly involved in stream habitat restoration, I can attest to the positive impacts I've seen from work I've personally done, got my hands dirty doing, between stream structures to help regenerate our wetlands and things like that. I see tremendous value. Even this year, I noticed with our exceedingly dry winter, how much it's benefits it. So in closing, I'd like to thank you all for your consideration of protecting our streams and surface waters. Thank you very much.
Thank you, Mr. Bowden. Who else is here to serve? If you would spell your first and last name.
John, John, Galvan, Galvan.
Do you swear or affirm to tell the truth?
I do.
Please go ahead.
Good afternoon, Commissioners. My name is John Galvan. I am the Governor for Pueblo Jemez of 2026. On behalf of my Pueblo, I am here to comment on SB 21, or amendments to the 20.262 and the new Rule 20.6.5 NMAC. We are located at the base of the beautiful Jemez Mountains. Our primary water resources is the Jemez River, the headwaters of which begin in our ancestral lands, the Valles Cordero, and flows through our Pueblo. Water is most precious resource that must maintain its purity to the greatest extent possible to use in our traditional and cultural practices. In my Pueblo of approximately 3,200 tribal members, we have a deep tradition of respecting and must be protected against all pollution. Our internal standards of what we believe that water quality should be are woven into the traditional and cultural practices of the Pueblo. However, the waters of the Jemez River have been threatened by upstream pollution, sewage spills, and wastewater discharge. In this hearing, the Commission has a choice to define tribal water quality standards, broadly or narrowly. The choice This choice will have a profound impact on whether my Pueblo or other tribes in New Mexico can meaningfully protect their ancestral waters. I'm here to urge the Commission to define tribal water quality standards as standards established by the governing board pursuant to Indian Nation, tribal, or Pueblo law. Some participation in this hearings have suggested a narrow definition of tribal water quality standards. They asked the Commission to define tribal water quality standards as standards established by the governing body pursuant to the laws of the nation, tribe, or pueblos, and which are applied in tribal water quality standards or programs. I asked the Commission to reject the applied in tribal water quality program language for 3 reasons. First, this language gives polluters an opportunity to argue that existing tribal water quality standards are not enforceable because 1, the Pueblo in question does not have the dedicated water quality program, or because 2, the Pueblo has not sufficiently applied those standards. My Pueblo is a sovereign nation with governing powers to administer programs and enforce the laws, rules, and regulations duly appointed by the governing body of the Pueblo. This suggested language by the other participants would make it more difficult for the Pueblos to protect their ancestral waters. Second, this definition misrepresents what the law requires. Senate Bill 21 requires polluters to apply for a permit with the New Mexico Environment Department if they want to discharge pollutants into waters under state and federal jurisdiction. For state waters, the law says that the department shall deny a permit if the surface water discharge would cause or contribute to water contaminant levels in excess of downstream state or water quality standards. For federal waters, the law grants the department the authority to deny a permit for the same reasons. The law does not require the tribes apply their standards in a dedicated water quality program. Tribes are only responsible for sharing their standards with the Environment Department. The Commission should not add requirements that the legislature did not intend to impose. Third, the Commission should define tribal water quality standards in light of the legislature's recognition and appreciation of the Pueblo sovereignty. This language clearly shows that the legislature understood tribal standards as important and enforceable in their own right. Pueblos may exercise their sovereignty by applying the treatment as a state or by fostering a cultural respect of water or both. The Commission should honor the decision of each tribe to protect water in their ways of their own choosing. Second guessing whether tribes have sufficient established their own standards would undermine our sovereignty, allow polluters to contaminate the waters of the Jemez River, and contradict the legislature's differences to the tribal governance. On behalf of the Pueblo Jemez, I ask the Commission to adopt our proposed definition that tribal water quality standards are standards established by the governing body pursuant to the laws of an Indian nation or tribe or Pueblo.
Thank you, Governor Gala.
Yeah.
Other commenters, ma'am, sorry.
My name is Joan Brown, JoanBrown, and yes, what I'm saying I hold as much as I know is true.
Thank you very much.
Good afternoon, Chair and members of the Commission. I'm Joan Brown, a Franciscan sister, the founder of New Mexico and El Paso Interfaith Power and Light, and I dedicate my life as a community advocate working for integral ecology around climate, extractive industries, community health, water, and spirituality and ethics. Thank you for your work, this hearing, which is extremely, extremely important for our communities, our state, and all creatures and Sister Water. As a Franciscan sister, I have lived and worked for decades in New Mexico, living first in Sunland Park and now in Albuquerque. And I'm reminded continually of St. Francis of Assisi, who is one of the patrons of this sacred place and people.
This year marks the 800th anniversary of his death, and many of us know him as naming sun, brother, moon, sister, and water, sister, and earth as sister and mother. As we and you discern this very important concerns in this rulemaking for Sister Water, it's important to understand that Sister Mother Earth sustains and governs us, as St. Francis of Assisi proclaimed in the Canticle. And many of us are not acting like Mother Earth governs us through systems and other ways. This commission is extremely important, and especially as we move deeper into climate change in extreme, not even drought, but aridity right now. And we must listen to Mother Earth who governs us. We've not been acting this way. And at the federal level, we have had 3 significant rulings that are responsible for degrading Sister Water and the Clean Water Act. The Supreme Court SWA-NCC decision in 2001, the Rapanos decision in 2006, and the Sackett versus EPA case on May 25th in 2023. These decisions, I believe, were not wisely made and have had serious consequences for many communities, bioregions, creatures, and us here in New Mexico. But we now have an opportunity here in New Mexico. I strongly support the Commission adopting rules to protect all the surfaces waters of the state, all the surface waters of the state, including all the waters that have lost protection under the 3 U.S. Supreme Court decisions that have collectively stripped away protection for 95% of our state waterways. I am often in the Permian Basin and work with the Carlsbad-based Citizens Caring for the Future community group. I'm also part of Communities for Clean Water, addressing contamination of water from Los Alamos National Labs, and am part of the Multicultural Alliance for Safe Environment, or MACE, that addresses uranium mining legacies and now fighting all of these mining permits that are before us. All these communities are very concerned about water. Their voices are important. All community voices are important. So I also want to say that public participation is extremely important in permitting, oversight, addressing concerns of pollution and endangerment. So to conclude, I just would beg you to listen to Mother, Sister Earth, who governs, and water as sister. Oftentimes we see the governing is about money, is about industry, is about certain entities, and we're not listening to the natural world that we're part of and have been part of for billions of years. So my prayers with you as you discern, as you listen to diverse voices, and I pray for your guidance and discernment. Thank you.
Thank you very much. Other commenters? Come on up. Spell your first and last name, please.
Yes, good afternoon. I'm Dana Loy, Danaloy.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. Go ahead.
Thank you. Good afternoon. I'm Dana Loy. I'm with New Mexico Interfaith Power and Light and the Franciscan Justice Circle, and I live in Albuquerque. Thank you for this hearing today and making it available to so many people over so many days. We all know that New Mexico is blessed with the beauty of nature, and as sisters and brothers to our water, we are responsible for protecting all streams and wetlands in our state. SB 21 is a lifeline. It must be at least as strong as the lost federal standards and guard against new and existing environmental threats. We are obligated to protect our waters because we know how to do that and because all water is sacred. It would be immoral to know that in New Mexico, 114 wildlife species are officially at risk of becoming extinct and yet not step in to protect them. Polluted and drying water is part of this threat, as well as the blatant destroying of wetlands. When I was growing up, there was a small secluded pond down the street. It didn't seem like such a big thing then, having trees and water and a little bit of wilderness near home. It was normal. It also became a terrible new normal when they cut it all down and filled in the pond. Many of us here today had similar places. Maybe some of yours are gone now too. We all want these kinds of places for our children and grandchildren and for the plants and animals who share our common home. As others have mentioned, one way to protect these places is for SB 21 to include the New Mexico Department of Wildlife in decisions about surface water. A lot of work just went into modernizing this department and increasing its funding. The Department of Wildlife could play an important role using the best science in the permitting process. Pope Francis said we must protect the most vulnerable, including plants and animals, and take protective steps before it's too late. The future depends on what we do in the present. Please act now by including the strongest possible protections for all New Mexico water in SB 21. Thank you.
Thank you, Ms. Loy. Other, sir? If you would spell your first and last name.
Christopher, Christopher, Toya, Toya.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Good afternoon, Commissioner and members of the Commission. My name is Christopher Toya, and I am a member of the Pueblo of Jemez tribal community, a lifetime resident of the Pueblo. I work for the Pueblo of Jemez as the Tribal Historic Preservation Officer. I have been the TIPO officer since 2015, when the Pueblo received recognition from the National Park Service to manage our own cultural resources. Prior to that, or since 2004, I was employed by the Pueblo as the Traditional Cultural Properties Project Manager. I am here today to comment on why the quality of water is important to our Pueblo way of life. In Jemez culture, water is life, and without water, there is no life. Water is a crucial element with all living creatures that live on the ground, in the water, and in the air. Ancestral villages were built around water resources to protect them because they understood the importance of water resources. Our main body of surface water that we want to protect is the Jemez River. The headwaters of the Jemez River start within the Valles Caldera National Preserve. The Jemez River is fed by San Antonio Creek and the East Fork River. The Jemez River, the San Antonio Creek, and the East Fork River are fed by many seasonal springs and streams, both within the Pueblo and upstream of the Pueblo. The Rio Guadalupe is a major tributary to the Jemez River and joins the Jemez River approximately 1 mile north of the Pueblo boundary. The Jemez River flows year-round through the Pueblo. Water brings life to the Jemez community in all the traditional ways life is lived and understood. Here are a few examples. As Pueblo people living in the community of Jemez Pueblo, water is truly sacred. All ceremony in Jemez Pueblo begin with water. Water is a very crucial resource used in the mixing of our traditional medicines that are used in our healing and blessing ceremony. Clean water is collected at natural springs located on tribal lands and on the ancestral lands managed by the U.S. Forest Service, the Bureau of Land Management, and the Valles Caldera National Preserve. Special places that the Jemez people have collected water since time immemorial. The water needs to be clean and safe for drinking, for the medicines to be consumed. Jemez Pueblo is a farming community a way of life taught to us by our ancestors. Our ancestors planted corn, beans, and squash in the floodplains of the drainages on mesa tops, river valleys, and on the south aspect of the mountains in the ancestral homelands. Farming was practiced even in the elevations as high as 8,000 feet above sea level in the ponderosa and conifer mixed forest in the Banco Bonito in the Valles Caldera National Preserve. Today, we continue to engage in farming our agricultural fields, growing crops that are used in our traditional cultural practices, as well as for personal consumption. We depend on good quality water from the Jemez River to irrigate our agricultural fields. We have limited acreages of prime agricultural fields that should not be contaminated with pollutants put into the river from upstream users or inhabitants of the area. Water sustains all life in the cultural landscape. Where there is water, there is life. The Jemez River and the Vallecito Creek are abundant in wealth in the form of natural resources. They are jewels in the Southwest desert. Jemez tribal members harvest medicinal plants, berries, birds, insects, and mammals and other natural resources along the riparian areas of the Vallecito Creek and Jemez River. The main source of drinking water for the community of Jemez is the Jemez River. Water in the Jemez River is also used for cleansing, spiritual cleansing. Men and women have cleansed themselves with the water before ceremonial activities to help prepare them spiritually, mentally, and physically since time immemorial. For these particular water uses, the water must be of utmost high quality. On a recreational level, Jemez children love to swim in the waters of the Jemez River and the irrigation ditches in the summertime. There is nothing like the feeling of cold water all over your body on a hot summer day. It is a recreational activity we all enjoyed as children growing up on the Jemez Reservation. In conclusion, water is a necessity in all aspects of life in Jemez Pueblo. Whether it is used in ceremony, farming, or recreation, it is the reason why Jemez people still live in Jemez Pueblo today is because of the Jemez River. Thank you.
Thank you, Mr. Toya. Other commenters? Please come on up. If you would spell your first and last name, please.
Marlene, Marlene, Parrot, Perrotte.
Do you swear or affirm to tell the truth?
Pardon?
Do you swear or affirm to tell the truth?
Of course I do.
Thank you very much, sister. Go ahead.
Good afternoon, Madam Chair and members of the Water Quality Control Commission. At this hearing on initiating rulemaking on surface water pollution program, I am Marlene Parrott, a Catholic Sister of Mercy, a woman of faith, and an advocate for environmental justice. I'd like to begin with ethics and the moral imperative for the common good. When I first was introduced to the Environmental Protection Agency, I said, oh my God, protection. And then I found out that the real role of the EPA and the Environmental Protection was that they had to decide how much pollution we could have. And I'm saying, oh my God, how much? Rather than saying, these are the sacred rivers and lakes and waters and there should not be pollution. We will protect from pollution, not how much. And therefore, I want to say that's ethics. This is a resource that is the common wealth for the common good, not for polluters or industry that can pollute. You know, you've been just hearing about the Jemez River and the Jemez Pueblo. I recently camped at Vista Linda, a wonderful stream with a beaver dam. It was healing and it was renewing. I don't want any pollution affecting these beavers or the rivers or the fish in the rivers. So I say to you, you know, the moral imperative is for the common good. Senate Bill 21 created a state permitting program to protect rivers, streams, and wetlands from pollution. But strong implementation rules are needed as federal rollbacks have stripped protections from most of the state's waters. The law's success depends on its effective implementation. I urge the Commission to adopt strong, comprehensive, clear, and enforceable rules. Enforceable rules, I want to accent, because many times we have rules, but they're not enforceable, that fully implement SB 21 to fully protect New Mexico's waters from existing and future pollution. We need rules that allow the public to engage in permitting decision. I urge you as a commission to adopt a 15-day comment period on the general permit coverage request. In addition, we need strong rules that require appropriate mitigation of impacts to aquatic resources. New Mexico deserves clean, safe, and reliable water. I urge the Commission to act accordingly, to be ethical, to pass strong, clean water protections that ensure a healthy and safe future. Long live beautiful, clean water. Thank you.
Thank you, sister. Anyone else, ma'am?
Hi, I'm Kim Rogers, KIMROGERS, and I affirm to tell the truth.
Go ahead.
Good afternoon, good people. I am here with the New Mexico Franciscan Justice Circle. I'm here to advocate for Mother Earth in the spirit of St. Francis. As a decades-long New Mexico resident, I enjoy this beautiful land and want to ensure that it continues to be enjoyed by our children, grandchildren, great-grandchildren, and subsequent generations. I understand the need for economic development and financial prosperity, but I would hope that shortcuts are not taken at the expense of the health and safety of New Mexicans. People deserve clean, safe, and reliable water, and you can ensure this happens by enacting strong surface water permitting rules. I urge the Commission to pass clean water protections that ensure New Mexico's health and safe future. Efforts to chip away protections and exclude specific types of waters must be rejected. The state program must protect all of New Mexico's surface waters, including rivers, streams, wetlands, and the smaller sources that sustain them. In addition, I urge the Commission to protect tribal water. Indigenous people have long suffered from others who have not taken good care of the earth. We owe it to the people and to the earth to protect the land and waters that we share. This can be done by denying permits that contribute to polluting downstream tribal waters. Tribal water quality standards must be adopted and not weakened. Finally, as climate change intensifies drought and water scarcity, New Mexico cannot afford weak protections that jeopardize our limited water resources. Weak rules leave vulnerable waters, communities, and future generations at risk. In the long run, it would be more expensive to treat polluted water than to prevent it. As the saying goes, an ounce of prevention is worth a pound of cure. Drinkable water sources are finite. Less than 1% of the Earth's fresh water is accessible. Please ensure that New Mexico is able to sustain our state's water through robust surface water permitting rules. Thank you.
Thank you, Ms. Rogers. Others? Public comment in the room? I'll go to the platform then if there's no one else in the room. Amber Louise.
Madam Hearing Officer, I have one on the platform, Adriana Laredo, if you could please unmute yourself.
I'm here.
Hello, would you spell your first and last name, please?
Adrianna, last name Loretto, Loretto.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. Go ahead.
Good afternoon, and thank you for the opportunity to share my thoughts with this committee today. My name is Adriana Loretto, and I'm here to support of strong protections for New Mexico's surface waters. As a proud Native mother, I was raised with the understanding and with the respect that water is sacred. It is more than a resource. It is a foundation of life. Every human begins life in water. Before we walk the earth, we develop water within the water sac, which is surrounded by protective fluids that nourishes and supports our growth. So our relationship with water starts before birth and continues throughout our lives, reminding us that water is not just important, it's an essential, or it is essential to our existence. Water sustains our families, our communities, our traditions, our agriculture, our wildlife, and our future. It connects us to our ancestors and reminds us of our responsibility to care for the generations who will come after us. I want my children and my grandchildren to have those same opportunities as I did growing up. I want them to grow up enjoying the rivers and the streams on the reservation the way I did. I want future generations to have the same resources and experiences that shaped my childhood, not a future where clean water is less available or less protected. Clean water is not something we should take for granted. It supports our health, our communities, our traditions, and our way of life. It is a resource that connects all of us, and we all have the responsibility to protect it. So upcoming relatives can enjoy the same opportunities and quality of life that we all have today. As climate change continues to impact our state, protecting every part of our water system is more important than ever. I believe all of New Mexico's surface waters should be protected, especially our beautiful rivers and small streams. These waters may seem very small, but they play an important role in supporting larger waterways, wildlife habitat, and overall water quality. Every part of the system matters. So my hope is simple. The future generations of my family, our native lands and pueblos and tribes and all New Mexican families will inherit the same clean water and natural resources that we depend on today. I urge the Commission to adopt strong, clear, and enforceable protections that will help make that possible. So thank you for your time and your consideration.
Thank you, Ms. Loretto. Anyone else at all? Our next public comment session is 1 p.m. Monday. All right, let's return to the technical case. We could have the water protection organizations come back to the tables. And Mr. Mullenberg. Are we ready? Yes. All right. Go ahead, Mr. Mullenberg.
Thank you, Madam Hearing Officer. And just for clarity, I believe we would have 90 minutes as a time limit for this panel. And I'm going to start the questioning, and I'll reserve some time for Ms. Saluja to answer some or to ask some additional questions.
Great. Thank you.
Good afternoon. Thank you all for your testimony. I'm going to begin with you, Ms. Khan, and just to start off on a happy note, we appreciate your agreement, at least in concept, with the NRP proposal on temporary authorizations, essentially using the federal general permits as a model. We may have still some differences in exactly how that language works, but we appreciate your acknowledgement of that and your help in getting that, I think, very important piece in. Just so you know, in case you want to have it there, I'm really going to just walk through your demonstrative exhibit and the points that you focused on. To start, just to clarify your testimony, the water protection organizations in their direct and rebuttal testimony proposed a number of text changes to many parts of the rule. And is my understanding correct that you have now narrowed the changes that you're requesting to those as set forth in the demonstrative exhibit that you went over in your testimony this morning?
Madam Hearing Officer, Mr. Chair, members of the commission, no, I think that for the most part, if I speak from back here, is that enough in the microphone, or do I need to lean in? Okay. For the most part, I think that that's true, the key areas, but there are some areas, because of the short amount of time that we had to present our testimony, that we didn't touch on in our summary, and we'll have some proposed language changes based on our Exhibit 1 that was submitted with our direct.
Okay. Are you referring to, let's say, proposed language changes perhaps after the conclusion of the hearing based on the record? Or I guess what I'm really trying to explore here is how many of the detailed changes that were proposed in the written direct and rebuttal testimony are still live versus things that are more or less taken off the table?
Well, I tried to do a summary in my slide 3 of areas where we have dropped our proposals due in a large part to the Environment Department coming closer, not completely there on some of those things, but close enough that we've dropped our proposals in a number of areas.
Okay, thank you. I won't try to get more granular than that. I was just trying to get a sense as to whether I was interpreting your testimony correctly or not. During your testimony, Ms. Khan, you testified that the department worked collaboratively with all stakeholders. And are you speaking to your experience with the water protection organizations dealing with the department as opposed to, say, the members of the Natural Resource Partnership that I represent?
I think that for the large part, yes, we have a large coalition with the water protection organizations and supporting organizations to a larger coalition called Protect NM Waters. But we also worked with stakeholders during the Surface Water Advisory Panel process, which you were a part of. And during the legislative process, representatives of water protection organizations, I believe, worked with you on some of the language in the legislation as it was being developed with the bill sponsor, Senator Worth.
Thank you. And I appreciate your bringing up the legislation. I do think there was some collaboration there. As to the Surface Water Advisory Panel process, would you agree with me that by design, it was not intended to lead to negotiations, compromise, that kind of a stakeholder discussion?
I would agree.
Um, so I'm on slide 7 now of your presentation, if you'd like to follow along, but one of your points at your third point regarding the Water Protection Organization's proposed changes is that the requirements should be at least as protective as lost federal requirements. Do you recall that?
Yes, I do.
Is it your view that the rules adopted by the commission should set no ceiling on the level of protectiveness under the surface water permit programs?
It's my opinion that we're not limited as a state by the federal rules as a ceiling. This commission has the ability to set protections at levels they see fit, regardless of federal protection.
Thank you. So you acknowledge that the commission has the ability to set a ceiling on the level of protectiveness where it deems that to be appropriate?
I think that the rules themselves, as they're applied, set the parameters for the rule.
Your fourth point on that slide discusses meaningful public participation in general permit coverage decisions, and we may go into a little more detail on that. But my question here is your thoughts on the need for public participation and a process for the issuance of general permits. Do you feel that the rules are clear enough on that point in terms of providing sufficient public participation for the issuance of general permits?
Yes, I think that the rules provide, there's a comment period for the issuance of a general permit, but as I mentioned, not for coverage as individual dischargers or permittees are requesting to get coverage under a general permit. And that's where the details are. That's where someone's going to know about a discharge that is impacting their watershed. The general permit is, the general requirements, but for the general public to want to be able to comment on a specific discharge, I don't think that that's asking too much.
And you mentioned the rule provisions that discuss comments on a proposed general permit. Is it your understanding under the rules that there is not an opportunity for a hearing on a proposed general permit such as we're having here, which I think would be before the department, not the commission? But I just raised that point because I'm not clear on that either. I think I read the rules as you do to just allow for comment, but no hearing.
I believe that there's an opportunity for a hearing on the permit issuance, whether it's individual or general permits. I could try to find that section.
That's okay. I just kind of wanted to get your position and view on that. Do you think it's appropriate then to have a hearing on the issuance of a general permit?
I do think it's appropriate for there to be ability to have a hearing on the issuance of a general permit. And my understanding of the rules is there is that opportunity provided, but now I'm worried. And so maybe we'll have a conversation afterwards to confirm that.
Okay, thank you. Ms. Khan, in your testimony, the water protection organizations propose a definition of project purpose as 20.6.2.7 subsection P, paragraph 10. You recall that?
Yes, I do.
And as I understand your testimony, your central purpose for wanting that kind of a definition is to avoid essentially abuse of the project purpose concept such that an applicant could define a project purpose so narrowly that it more or less preordains an outcome. Is that fair?
That is fair.
Okay. The definition you propose for project purpose essentially goes in the opposite direction as I read it, and it in fact intends to limit the specificity of a statement of project purpose. Is that fair?
I would disagree. I think that it is proposing, it's ensuring that the project purpose is the fundamental or basic purpose and not sub purposes that may be involved with a project.
So let me go to perhaps what that might mean. Let me go to a topic that's probably near and dear to both of our hearts, and those are minds. If a applicant is proposing a mine, I'm testing how far that could go. So for example, would they be limited to proposing a mine, or would they be able to identify the particular minerals that they're trying to extract?
I think that they could identify the minerals they're trying to extract. I mean, a basic purpose of a copper mine would be to extract copper minerals.
Okay. Could they be restricted, for example, from specifying an open pit mine versus an underground mine?
I still think that those are large, broad project purposes. To extract copper minerals from an open pit mine, that's a broad goal of a project.
Okay, but obviously those degrees of breadth versus specificity take some judgment, right?
Oh, yes, I think it does. And, and I think that's why it's important to have a definition in place so that the department has some guidance in making those judgment calls.
Thank you. And I'm just trying to illustrate for the commission that there's two sides to that. When you put in a definition, you allow judgment calls to that might frankly have the same outcome oriented result. Would you agree or disagree with that?
Well, I think right now in the rules, the applicants are called to give the project purpose, but there's no guidance at all onto what that means. So our attempt was to try to provide more clarity in implementing that, those portions of the rule.
Thank you. The next topic you cover is a proposed subsection G to section 2304 of the 20.6.2 rules. And I want to focus on the word may cause an exceedance of water quality standards.
Wait,
pardon me?
I was just trying to get clear on what section so that I can.
Oh, I'm sorry, 20.6.2.2304, and it's on slide 12 of your demonstrative exhibit.
Mr. Mullenberg, I have a note to myself that although the demonstrative exhibit Pam printed for me has a slide 12 with 2304 on it and the language you referenced, they didn't show slide, I think it was 11 or 12.
Oh, okay, thank you. And I observed the same thing as I was watching the slides, that I'm not sure that the printed version from what was placed in the record matched the slideshow that we were given. But let me, if I might, just read the language that I have from this slide, and I expect it's in your testimony. And it says, it's subsection G, prohibitions. No surface water discharge shall be permitted if such discharge may cause an exceedance of water quality standards in surface waters or downstream tribal waters.
Yes, we took out that slide. We were worried about time for our summary, so I was trying to condense my summary, but that is part of our red lines for individual permits. That was language that was originally in NMED's, I think, August draft, maybe the October draft. One of the drafts, NMED had that language in that same location in the proposed rules with a prohibition on exceeding, causing or contributing to exceedance of water quality standards. And we wanted to bring that back. We thought that there actually isn't a clear place in the rules that make that prohibition, and we think that aligns with the Water Quality Act.
Right. And again, my focus there is on the word may, and the concern that when you use the term may, that may allow for speculation. Let me ask your view on addressing that kind of an issue. If you have an appropriate permit term or condition that addresses the possibility, particularly remote possibility of exceeding a standard, from your standpoint, would that be sufficient to overcome that kind of a prohibition?
Could you state that question again? I'm sorry.
Yeah, it was a long one, but I guess my question again is, if there's a concern about whether a discharge may cause an exceedance of standards, in your view, would an appropriate permit term or condition that addresses the concern be suitable to avoid that kind of a prohibition?
Yes, I think so.
Okay, thank you. The next language, I think you did show this morning, is some language that the water protection organizations are proposing for 20.6.2.2305 subsection A, and particularly two paragraphs. Paragraph 1, which addresses, I believe, issuance, renewal, or modification of a general permit applicable to a discharge of point sources. Let me start with that one before I go on to the other. Does that sound familiar to you?
Yes.
And in that language, you're referencing a particular federal rule, 40 CFR section 122.28. Does that sound right?
Yes, it does.
And I guess a couple of points on that. You're suggesting that the department should comply with that section. Perhaps that's just being picky over the words, but since those are federal rules, they technically wouldn't be legally applicable as far as the 20.6.2 program, right?
Yes, what we are intending to do is to have those regulations, the federal regulations, in this case for the subparagraph 1, as you mentioned, 40 CFR 122.28, which is the section of the federal regulations that that lay out how general permits must be issued at the federal level. And so we're proposing that those be incorporated by reference, and so that the department is required to comply with those provisions at the federal level.
And thanks for that, because that's kind of where I was getting. Are you really looking at those to be incorporated by reference into the rule as adopted by the commission? The other point on that is you specify that particular rule section as it was effective on June 12th, 2023. So with that approach, any future changes to that rule would not be incorporated by reference, correct?
Correct.
I think we've heard testimony on some other provisions by the department that proposed an alternative approach, that future amendments to rules would be automatically incorporated into the 20.6.2 rules. Do you think this is the better approach to allow people to know exactly what version of a rule incorporated by reference is applicable?
Well, I'm not exactly sure what other rules the department was talking about in that situation, so I can't speak for what they were talking about. I can speak to these two provisions that we do think that these that the provisions as set forth on June 12th, 2023 for the point source ones and the June 22nd, 2020 rules for the 404 404B1 guidelines, that those are the appropriate versions to set forth and not subsequent changes to those versions of rules.
Thank you. Thank you. Fair enough. Madam Hearing Officer, I didn't do a good job of checking my start time. Could you tell me where I'm at?
You started at 1:54 and it's now 2:14, so
20 minutes in. Thank you. I'm next going to go to a proposed change to 20.6.2.2305 subsection B, where you've modified some language regarding consultation with state, tribal, or federal agencies. And I have some questions for there. In this instance, the water protection organizations are proposing to change a may to a shall, meaning mandatory consultation, right?
Correct.
The language, however, then says any state, tribal, or federal agency with jurisdiction over water, fish, wildlife, or public health. Now, that language isn't limited to agencies in New Mexico, is it?
I guess it is not. It does start with any state, tribal. I think the implication is that it is New Mexico. Again, we were taking language that NMAD had proposed in their Exhibit 79A. I think B as well, but I know for sure A. And basically, as you mentioned, took the shall to, I took the may to a shall. So we weren't proposing the rest of the language. And perhaps it would be more clear if it said New Mexico state.
Yeah, and really, I'm really just pointing out that if you change to the may to the shall, then some of the other language becomes rather important in a mandatory context. And for example, this relates to the issuance, modifier, renewal of a general permit, I believe, statewide. So perhaps the other piece isn't quite as important.
I would agree, and I would also note that we are not opposed to the SWAG group's language that would make, especially the consultation with the Department of Wildlife, optional for them, basically, with language that allows them to waive that consultation if they didn't have the resources to do so. So we don't have that included here on the slide, but we certainly support that language proposed by the other group.
Thank you. I'm going to move on to some language in 20.6.2.2305 subsection B. And in this section, you split up the categories of discharges for general permits to differentiate between municipal or domestic wastewater versus industrial wastewater. Do you recall that?
Yes, I do.
Okay. One of the phrases here, and I believe this is new language being proposed by water protection organizations, but tell me if I'm mistaken. It's subparagraph D, and it says, do not individually or cumulatively cause or contribute to a violation of state water quality standards, including the state's anti-degradation rules and policies. Do you recall that?
Yes, I do.
Okay. Now, in an instance where the state is considering, let's say, issuing a general permit that follows or is modeled after a federally issued general permit, would you expect that the kind of analysis needed on individual or cumulative contribution to violations of standards would have been done by EPA?
I do believe that that's a federal requirement to make sure that permits aren't issued that would individually or cumulatively contribute to a violation of water quality standards. And so it's essential that both individual and general permits have permit conditions that ensure that discharges that are permitted through that general permit won't cause a violation of water quality standards.
And the converse case would be a situation where the department might be proposing a general permit that isn't modeled after a federal permit. You understand what I'm saying there?
I think so.
Okay. And in that instance, would it be fair to assume that the department would have to do its own technical analysis to look at whether discharges that would be authorized individually or cumulatively could cause or contribute to a violation of state water quality standards?
Yes, we would hope that the department would do that in issuing general permits.
Do you think that might be a challenging analysis if we're talking about stormwater discharges?
I think that if you have appropriate permit conditions in place, you can make that determination. So what we're asking is that there be this this requirement added to each section in subsection B, that discharges will not individually or cumulatively cause a contribution to a violation of water quality standards, and that the department would then look at the permit conditions that they're applying in those permits to ensure that they're protective enough to ensure that all the discharges authorized under either an individual permit or a general permit are not causing those violations. I mean, that's a core fundamental requirement of the Water Quality Act. So I see adding this provision as implementing that core provision in the Water Quality Act.
So you're thinking that that might be done through crafting appropriate permit terms and conditions as opposed to, let's say, some large technical analysis to prove in fact that that there wouldn't be concerns with violations of state water quality standards?
I think that it's a combination. I think that there needs to be some analysis to ensure that those permit conditions are in fact protecting water quality.
Thank you. Below that, you propose a new paragraph 5 for treatment works for industrial wastewater, and I'm here just looking at a kind of a narrow choice of words. You talk about a discharge or a category of discharges discharging the same types of waste. By waste, you wouldn't be intending to exclude effluent that may not be a waste, are you?
Again, this language, I think you're referring to 5B.
Yes.
That is language that is not actually our proposed language. It is just carrying over from NMAC's proposed language in the category above. We're just splitting out the industrial wastewater.
Thank you. And then that waste concept would apply potentially to both.
Yes. Yeah. I mean, it already does because right now NMAC has that industrial up in the category above.
Thank you. I'm going to move now to the section on general permit coverage, section 2306. you're adding or proposing to add a couple of sections, one of which specifies a 5-day limit for the department to post a notification of a determination that a notification is complete on its website. And then a second one that specifies that once that notice is posted, the public shall have 15 days to submit written comments to the department. Do you have a view of whether, if that deadline is missed, that would be a waiver of the ability to comment and participate in that particular coverage determination?
Which deadline is missed?
I'm sorry, the 15-day deadline, the one that says following the department's posting, the public shall have 15 days to submit written comments to the department.
I'm not sure I'm following your question. Could you restate it?
Well, I guess, yeah, let me restate that there's a right to comment within 15 days, but if a comment's not made within that 15 days, that right goes away. Is that clear?
Yes, I think yes, there's a 15-day limit on the comment period, like most comment periods. If you don't, usually there's a 30-day comment period. If you send your comment in on day 31, it's not considered, and that would apply here as well.
Thank you. Moving to some additional language on general permit coverage, and this is on what I have labeled as slide 22, but it's the things that the department needs to do within 30 days of determining a notification is complete. And again, we're talking about, I believe here we're talking about both NOIs and PCNs.
Correct.
Yeah. Here again, you have this language that the department would need to make a determination that the discharge will not either individually or cumulatively cause or contribute to a violation of state water quality standards. Isn't that determination unnecessary if the department has already determined that the general permit itself will meet that condition?
Perhaps, but right now there isn't that condition on the general permits unless our proposal is adopted for the other section.
Understood, but let's say that proposal is adopted, then would you still contend that the department would have to do this additional analysis at the point of determining whether a general permit covers the discharge?
I think it's less necessary at that point, but we think it's a really crucial component to have that analysis, that there isn't either individually or cumulatively a risk of causing or contributing to a violation of water quality standards. So we would like to see it and have proposed that be incorporated in several sections of the rule.
Thank you. Yeah, and I noticed several sections, and mostly my point there is it could be a pretty complicated analysis if you're doing that in fact, but I'll stop dealing with that particular one. The water protection organizations are also proposing a provision as a new subsection E of 2306 that says a person who permitted in the permitting action and is adversely affected may file a petition of review before the commission, and then it references a statutory section 74-6-5 subsection P. Do you recall that?
Yes, I do.
Right. And would you acknowledge that all of the requirements of that subsection P would apply to any such petition for review?
Yes, I do.
Thank you. The next section I'm going to ask about is actually in the 20.6.5 rules. And it's some additional language proposed for 20.6.5.303 subsection A, paragraph 4, subparagraph E, that talks about determinations of general permit coverage under the NMIPD's program. Does that sound familiar?
Yes, it does.
In this instance, one of the last piece of the language says, determine that the discharge does not have the potential to cause or contribute to water contaminant levels in excess of downstream tribal water quality standards. The use of the word potential there raises a question of what kind of analysis might be needed to prove the negative. And I'm curious your thoughts on the practicability of having a requirement that might require a permit applicant to prove the negative.
I mean, we wouldn't be opposed to changing that to determine that the discharge will not cause or contribute to water contaminant levels in excess of downstream tribal water quality standards.
Thank you. On the issue of tribal water quality standards and the proposed definition of tribal water quality standards, I'm wondering whether the language that you support there might be so broad as to allow essentially a standard established by a governing body pursuant to Indian Nation, tribal, or Pueblo law to effectively veto any upstream discharge. Do you think that's a legitimate concern?
No, I don't. I think that tribes, that there's limitations on what type of tribal water quality standards. They have to be approved by a tribal government, adopted by a tribal government as the definition lays out. So there is a process for approving those tribal water quality standards.
Are there any public notice requirements when a tribe is considering changes to their tribal water quality standards, or perhaps the adoption of a new one, such that persons in other part of New Mexico would have reasonable notice of that tribal government action?
I don't know the answer to that. My guess is that it would vary by tribe.
Okay. Do you know if there are any limitations or allowances for persons outside of a tribe to participate in a tribal government process to set tribal water quality standards?
I don't know the answer to that.
Okay.
Would you identify a good time for a break, Mr. Mullenberg?
Yeah, this would be just fine for a break.
Great. Let's come back at 2:45. I thought you just turned it on. Okay. Let's come back from the break, please. Mr. Mullenberg, do you have other questions of this panel?
Thank you, Madam Hearing Officer. Yes, I do. A couple more questions for Ms. Khan. In your testimony, you mentioned the definition, I believe it's of surface waters of the state, and emphasize that it has been in place for over 20 years. Do you recall that?
Yes, I do.
But would you agree with me that over those 20 years, it has not previously been proposed for use to define, or at least define in part, who may need a permit?
I guess I would disagree that it has been proposed previously to determine what the scope of a permitting program. As I mentioned, in 2006, the department underwent a process to develop the same process. They started it and then didn't finish it, but they did put together draft regulations at that time. And the definition of surface waters of the state was proposed at that time in 2006. The definition of surface waters of the state at 20.6.4 was incorporated into those draft regulations to define the scope of the program as proposed at that time.
And I may not recall that, or I don't recall the details, but that effort in 2006, as you describe it, that was never brought before the commission for a hearing, was it?
No, it wasn't.
Also in your testimony, and I'm referring to a slide here, number 35, there's a statement that discharges into ephemeral streams drain into larger rivers. And I guess my question is, in New Mexico in particular, that's not always the case, is it?
That's correct. It's not always the case.
And in New Mexico, for example, some ephemeral streams basically wither away in the desert and perhaps have some groundwater recharge, but they don't actually connect to a downstream surface water.
That's correct. Those streams, I would argue those streams are even more important ecologically on the landscape because they may be the only water source available to wildlife in that area.
Another point on your demonstrative exhibit is a statement that many of New Mexico's surface waters lost federal protections well before the Sackett decision. And in that regard, I'm wondering if you would agree with me, however, that during the legislative process and in advocacy before the legislature, there was a lot of emphasis placed on the Sackett decision and its consequences for New Mexico, correct?
Sackett was brought up. It had just happened, so it was fresh in everyone's mind. So there was mention of Sackett during the legislative session.
Thank you. Let me move on to Mr. Siebert. Am I pronouncing that right? Thank you.
Thank you.
There was a very small town near where I grew up named after you.
I have nothing to do with it.
Mr. Siebert, I'm going to begin with your testimony on the concept of avoidance and your statement that no discharge shall be permitted if there's a practicable alternative with less adverse impact. And I believe in your testimony, you referred to the consideration of cost in determining what is practicable, right?
That's correct.
Are there any standard criteria or approaches to considering costs when an agency is trying to determine whether there's a practicable alternative?
Maybe before I answer that question, are you coming off my direct testimony or is it part of the presentation? Just want to make sure as you ask me questions, I'm following along.
Yeah, fair enough. And I'm actually speaking from your demonstrative slide 4 right now.
Great, thank you. I think in any analysis of alternatives, weighing the overall project purpose, as we've talked about here, is part of that analysis. The range of alternatives are going to be determined by that project, the overall project purpose. So in my experience, ranges of types of projects, we would get some examples and that would build your guidance going forward. And a lot of that also could be discussed in that pre-application meeting with an applicant to discuss the range of alternatives that we ought to be evaluating.
Thank you. Is that analysis any different depending on whether the applicant is a private entity or a public entity, say for a public works project?
I wouldn't say so. Again, it's hard to answer that in the abstract because I think things are very project specific.
An example that I'm aware of done, at least in some cases in New Mexico, of avoidance might be, say, for a pipeline project, directionally drilling underneath a water body. Are you familiar with that concept?
Yes, I
am. Would it make any difference in your analysis if you were, say, looking at that approach to avoidance for, let's say, a crossing of the Rio Grande, as opposed to perhaps multiple crossings of small ephemeral streams?
I think it could be different, yes.
I believe in your presentation, you discussed some of the differences between your experience in Wisconsin versus the New Mexico landscape. Did you make that kind of a comparison generally, at least?
I do think that within my testimony, I referred to the differences between Wisconsin and New Mexico, yes.
And just exploring what some of those differences might be. In Wisconsin, for example, or at least in some parts of Wisconsin, it might be relatively easier to avoid impacts to wetlands than perhaps in New Mexico, where wetlands are much less prevalent. Is that fair?
Could you restate that? I'm not sure I understand.
Yeah, I'm just asking whether, with your experience in Wisconsin, or at least in some parts of Wisconsin, it might be more challenging to avoid impacts to wetlands. And I'm referring to wetlands as, say, they'd be defined under federal law, compared to New Mexico, where there are fewer wetlands.
Yeah, I would agree with that. I think you said it backwards the first time.
Oh, perhaps I did.
Yeah.
Sorry for that. That would have been confusing. And similarly, for example, in Wisconsin, you may not have so many ephemeral streams to avoid, but in New Mexico, would it be fair to say there's probably a lot more prevalence of ephemeral streams that would need to be addressed for avoidance?
That's my understanding, but I do not have expertise in the aquatic resources of this state.
Fair enough. In your original testimony, I believe that you advocated for incorporating a number of federal rules or the language from those rules into the New Mexico rules, particularly in the areas of avoidance, mitigation, and the like. Is that true?
I think that's a fair statement, yes.
And were those changes offered originally so that the water protection organizations would have more certainty as to how the New Mexico rules might operate?
I'm not sure of the basis there. I would say it this way. I was asked by water protection organizations to review language that they had proposed and ask for my response on how I would talk about it in these settings. And so quite often throughout my testimony, you'll see that that's consistent with what my experience is, and it's consistent with federal regulations, and then citing those regulations where it was appropriate.
Is it fair to say, at least nationally, there's a lot more general understanding of the meaning of federal rules, guidance documents, and things that have been in place for a long time?
I suppose for those that are regulated by the federal government, yes.
Are federal rules and guidelines, in your experience, say in Wisconsin, utilized or borrowed from for purposes of state rules?
In some cases, yes, in order to achieve that consistency.
You comment in your testimony on a definition of alternatives analysis. Do you recall that?
I do.
Okay. The language I have in front of me for your from your presentation speaks to a process of analyzing all feasible project alternatives. Who identifies feasible project alternatives?
Well, the point of the definition was to lay out the range of alternatives. And so, as I said earlier in your question, some of that I think can come through that pre-application meeting to talk about the range of alternatives that should be looked at in the case specific. I think sometimes in my experience, applicants will say, well, we have this information. Is that what we might want to bring? Other times the agency might bring forward, we would like you to analyze this. So there's not an answer that I can give you that would answer that in all cases.
Thank you for that. So in your experience, and I'll use a term, it's more of a collaborative process of identifying the range of alternatives considered feasible and that should be analyzed.
Especially in the most complex cases, yes.
Okay. And there can be simple cases too, where there's a pretty narrow range of feasible alternatives. Is that fair?
That's fair.
The definition in front of me says analyze alternatives to the maximum extent practicable. I'm familiar with the use of that phrase, maximum extent practicable. Is in this context, do you know if that's intended to refer to the cost of the analysis, or what practicability is intended to mean there?
I believe the language that you're looking at is NMED language.
I believe so. It's in your presentation, but yeah.
Right. So I don't know that I can answer where that language comes from. I was mostly commenting on, does that seem reasonable? And I do think it's a reasonable approach, and it's language that I've seen before, but the specifics of what exactly that language means by this agency in this state, I can't speak to how they would define that exactly.
Fair enough. You discuss a definition of avoidance and some additional language that the water protection organizations are proposing to add the phrase "or adjacent to a surface water." Do you recall that?
Yes, I do.
Would you agree that by definition, an area that's adjacent to a surface water is not itself a surface water?
I think my testimony here was talking about avoidance. And if we're talking about avoiding impacts to surface waters, avoiding impacts to those areas in or adjacent to the surface water is the range of alternatives we should be looking at.
Okay, so if the commission were to consider and adopt this language, what would adjacent to mean? Would that be defined by property boundaries? Would that be defined by distance? Would that be left to the full discretion of the permit reviewer, or what would that mean in this context?
I'm not sure that I can answer exactly how the NMAC will handle that. I would say, as I said in previous answers to you, that pre-application discussion about what are the range of alternatives that should be explored to avoid impacts is a way to get at that.
I'm moving next to some language you discuss in section 20.6.2.2304 subsection C. And first of all, am I this is a piece titled new permits. Is it your understanding that this would apply to individual permits as opposed to general permits?
Not sure.
May I share our exhibit 1?
Absolutely.
I just want to see it in the context of the whole rule.
Yeah.
Yeah, as I'm reading this, 2304 is for individual permits.
Thank you. In the language in red, I'm reading from slide 8 of the demonstrative. It's discussing which practicable alternative has the least environmentally damaging impact on aquatic resources. In the context of that sentence, is it fair to expect we're expecting to talk about aquatic resources within a project area as opposed to aquatic resources elsewhere?
I would say generally, yes. If we go back to the conversation about overall project purpose, have had experience where that range of what is that impact area could be larger. For an example, if the overall project purpose was to provide housing within a community, limiting that analysis of alternatives to the site that was chosen versus something a little bit broader might come into play there.
So sort of to help define that, what's a little bit broader, in this particular context, you wouldn't be looking at issues such as climate change and impacts that might be more statewide or national or even global at level, correct?
In my experience, the alternatives analysis has been much more down on in the direct and indirect impacts at a project scale. So some of those things that you talked about would be broader than I've experienced.
Thank you. I'm going to a section 20.6.2.2305 subsection E. And this question, I believe that there's some language in red on the slide. It's slide 10, and I believe this is new language proposed by the water protection organizations. Are you with me?
Yes, I am.
I covered this a little bit with Ms. Khan, but this language says a general permit issued, renewed, or modified shall be based on a determination by the secretary that includes first a demonstration relating to more than minimal individual or cumulative adverse effects. And then there's some other demonstrations here. Using the term demonstration, are you contemplating here, let's say, a complex technical demonstration versus in my conversation earlier with Ms. Khan, we talked about, for example, permit conditions that might be used to address this type of thing?
I would agree with what I was here for that conversation with Ms. Khan. I would agree with what she answered in that question.
Okay, so you're not suggesting that there'd have to be like an environmental impact statement performed by the state on a general permit?
As I said, I think what Ms. Khan answered is how I would answer that question as well.
Thank you. And I think this is, well, I have maybe a question on your rebuttal testimony. I'd like to talk to you about the concept of the language on single and complete project and what that might mean. Now, as I understand it, the concept that you're trying to get to here is what I've heard referred to in some other circles as segmentation, where you're taking a discrete project and splitting it into parts to use to allow you to use multiple general permits that would not otherwise be you would not otherwise be able to fit your project into general permits. Is that what you're generally getting to here?
I would agree with that, yes.
Okay. So my question gets to, and I think this particularly relates to some language at the end, a single and complete project means the total linear or non-linear project proposed or accomplished by one owner, developer, or partnership or other association of owners or developments. And in this context, I'm going to talk about a mine. So often a mine might be operated by a single developer operator, right?
Yes.
And what I'm getting to is whether a mine under this language might be considered a single and complete project. A mine might operate over a period of many years or decades, right?
Yes.
And over the course of that period of time, they might have a number of different discrete projects, say, for example, road crossings, pipeline crossings, remediation projects, a lot of different things that may be occurring in different time frames, each of which individually might be covered by a general permit. Do you understand what I'm getting to there?
I do understand what you're getting to. I will say, in my experience handling mining reviews within my state, we had a whole nother statutory set of provisions for how those were handled. And so I can answer to you generally, but my answer at some point is going to be, I don't know how things are regulated here when you talk about mining in the Southwest and in New Mexico.
Well, fair enough. And actually mines are regulated very comprehensively here under a completely separate program. I'm not going to ask you about that because I know you're not familiar with it, but
Okay.
that's a different, a different topic. I'm really trying to just get to the point that the language needs to take care here so that operations such as a mine are not considered to be a single and complete project and they only get to use one general permit once. That's not your intent, right?
I would agree with that.
Thanks. I believe I'll stop there and turn it over to Ms. Saluha.
Thank you very much, Mr. Mullenberg. Ms. Saluha?
And so she knows where are we at time-wise, Madam Hearing Officer?
Okay. Give me 1 second here to do the math. 14 plus 12 is 26 plus 38. Carry the 2. That's what I got too. Okay. We're at 104.
1 hour. Okay, thank you. Hello, panelists. My name is Serafina. I believe most of my questions are going to be directed at you, Dr. Sultanfus. But if any other panelists want to jump in with a better answer, please feel free to do so. You state in your direct testimony that your recommendations are based in part on permit requirements under Section 404 of the Clean Water Act, the 2008 mitigation rule, and programs adopted by other states, including Colorado. Is that right?
Yep, remember that.
And you further testified that using federal regulations as a guide is important when developing new regulations.
I still agree with that.
And one reason for doing so is to promote consistency and predictability.
Yes.
You also testified that significant departures from established federal programs can create confusion for regulators and the regulated community.
I think that's potentially true, which is why we use it as a starting point. I would caution that we would use it again, maybe this is where you're heading, that we use it as the floor and add on to it to make it specific to New Mexico's needs, though.
Fair enough. I believe many of the amendments you support are based on concepts already developed under the federal Section 404 program. Is that right?
That's right.
Okay. And others are based on Colorado's recently adopted Rule 87.
That's right. I think it is worth noting Colorado Regulation 87 leaned very heavily on the federal regulations. They tailored it a little bit to Colorado, but they're very, very similar.
So in developing a new state dredge and fill program, you believe there's value in looking to existing programs that have already addressed similar issues?
I do. Mm-hmm.
Okay. I'm going to transition now to some questions about compensatory mitigation. Compensatory mitigation can be accomplished in a number of different ways, correct?
Yes. Would you like me to expand on that?
Yeah, well, one of my questions was one option is permittee responsible mitigation, right?
Yeah, typically there's 3 methods to mitigate impacts. In New Mexico, I would assume most of that would be permittee responsible mitigation because the other 2, being mitigation banking and in lieu fee programs, to my knowledge, aren't, we don't have ILF programs in New Mexico, nor banks, to my knowledge. So yes, permittee responsible mitigation, where the applicant offsets their own impacts, would be probably the predominant method of compensatory mitigation.
And those 3 approaches that you listed are recognized under the federal mitigation framework, right?
Correct.
And I think you just answered this, but compensatory mitigation is not always performed by the permittee itself, right?
Yeah, fair enough. So the permittee in permittee responsible, they can hire a consulting firm. The primary difference though, between permittee responsible and say banking or ILF is that they hold the risk of project failure into the long term. And so They might hire some restoration contractor to offset those impacts, but they are still responsible for the monitoring and long-term management.
Thank you. I believe that one of your recommendations is that the department shall develop mitigation guidance that's consistent with federal mitigation requirements, right?
Yes.
Do you believe that compensatory mitigation guidance should be available for public comment and commission review?
I'm not sure I have much knowledge about that regulatory process, but maybe John does.
Could you state the question again?
Sorry. Do you believe compensatory mitigation guidance should be available for public comment and commission review?
Yes.
Friend.
I'm going to transition again now to talk about ephemeral streams. In your rebuttal testimony, you state that historical imagery can be helpful to differentiate between ephemeral streams and erosional gullies. Is that right?
Potentially, I think there's a broad suite of available data sets that can be used to identify ephemeral streams, although I would caution anybody trying to identify them from desktop analysis alone.
I was curious, when you reference historical imagery, what does that mean?
As far back as you can go, which typically is not as far back as a lot of these features were created, but a lot of erosional, a big distinction in my mind between erosional features and ephemeral streams is how long they've existed on the landscape, sort of the maturity that that ephemeral stream has developed through time, and many erosional features are quite novel on the landscape. You might see you might see these erosional features increasing in sort of extent because they're actively eroding, whereas an ephemeral stream has likely been there for some time. But I wouldn't put guardrails on what historical means.
Would you say historical imagery would be different from a map showing ephemeral streams and erosional gullies?
I would assume whatever map could be created would have itself relied on imagery of various ages to be created in the first place.
Okay. In your rebuttal testimony, you described characteristics that typically define ephemeral waters, and this includes channel stability, sediment sorting, slope, and stream beds. Is that right?
Mm-hmm.
What specific field indicators must be present for a feature to qualify as a stream bed?
Yeah, so I mean, typically as NRP's exhibit, I forget what exhibit number it was, but it was the identification of ordinary high water mark. I often rely heavily on the ordinary high water mark to distinguish streams from non-stream features. And as that field indicator protocol goes, explains there are vegetation indicators that you can identify, differences between the vegetation in the channel and outside of the channel. There are sediment differences, as I indicated, either sediment sorting on the bed or differences in sediment between what exists in the channel versus the channel bank. Getting the third one, my apologies. I rely heavily on vegetation and morphology. Maybe that morphology actually is, because I said sediment and vegetation. The morphology itself, distinct slope breaks, are the third indicator.
And what physical, hydrological, or biological features distinguish an erosional feature from a surface water?
Yeah, I think hydrologically, it's even more limited than an ephemeral stream. So this will be very, very fast runoff that has high erosive power. The sediment, because it's an erosional feature, it'll be actively eroding. There's going to be sediment sort of like chaotic sediment rather than sorted sediment actively eroding from that feature, rather than within a stream channel, as water goes around a bend, the water going around the corner on the outside is faster than the water on the inside. So the sort of the softer sediments, the smaller sediments deposit on the inside of a meander, while the bigger sediments are carried around the bend. Within the channel, how that manifests is you have pockets of very small sand versus some slightly larger sediments, depending on the source.
What New Mexico rules define the criteria for an... Oh, no, it's okay. Oh, what New Mexico rules define the criteria for an ephemeral stream versus an erosional feature?
I'm not sure that there is a definition for erosional feature, but I could be wrong.
Are you advocating to include all ephemeral streams as aquatic resources?
I am.
And is it fair to say that not all ephemeral streams function identically?
It's fair to say not all aquatic resources broadly function identically, yes.
And some ephemeral streams occur within closed basins, right?
Yeah.
And a closed basin is a drainage system that does not ultimately discharge to another watershed.
Correct. And these closed basins can be ginormous or quite small.
And in some closed basin systems, stormwater flow may terminate within the basin, right?
Yes.
And some ephemeral channels may not ultimately convey surface water to a perennial stream or river.
Correct.
I want to return to your comments about the ordinary high water mark, because I heard you say today that an ordinary high water mark should not be used to identify the lateral limits of surface waters. Is that right?
That is my opinion.
If we don't use the ordinary high water mark, what measurement is used to identify the lateral limits?
My personal opinion, which is not the position of water protection organizations, is that we should do our best to protect the entire river corridor. It's not the ordinary high water mark itself that maintains and sustains the functionality and health of a river. It is those surrounding areas as well. We rely on ordinary high water mark is a regulatory definition, not really a scientific definition. And we're sort of using that from existing regulatory language. If we were relying heavily on science and the connectivity within a river corridor, we would greatly expand what we were trying to protect if our goal truly is to protect surface waters.
Thank you so much for your time. Those are all my questions.
Thank you very much, Ms. Sullivan. Mr. Stomp, do you have questions of this panel? Thank you. Mr. Stomp declined. Do we still have Ms. Taylor here? Perhaps she's on the platform. All right. I'll keep moving. Mr. Perkamenko, are you on the platform? Perhaps not. Let's see, Mr. Brooks.
Thank you, Madam Hearing Examiner. It's just rotten luck to be last on Friday after the rulemaking. I'll try to be as brief as possible and as exciting as possible. I think all of my questions are going to be for Ms. Khan, but anyone on the panel should feel free to answer. Ms. Khan, your educational background is a bachelor's degree in environmental biology from Colorado College, is that right?
That's correct.
And are you a licensed attorney?
No, I'm not.
Do you have any formal legal education?
No, I do not.
On page 45 of your written rebuttal, you offer an opinion that the commission cannot act beyond the statutory authority given to it by the legislature. Is that a legal opinion you're offering the commission?
That's an opinion based on my experience and my conversations with colleagues and participating in the legislative session.
Okay, so if I wanted to examine somebody about the basis of that opinion, it would be your colleagues, your attorneys, it wouldn't be you?
Well, that is my experience of the way that the law has been applied and implemented here in New Mexico.
Okay. Similarly, when you state on page 47 that the agricultural district's proposed amendments to the dredge and fill exemptions, quote, represent a new exemption from that authorized under the WQA and therefore is prohibited by the Act, end quote. Is that intended to be a legal opinion?
That's an opinion based on my involvement in the legislative process. We worked with the bill sponsors and in drafting that language with input from other parties here in this room. And it's also based on my reading of the law, which very specifically says only these exemptions shall be allowed.
I presume your answer is going to be effectively the same when you say on page 48 of your written rebuttal that deleting the recapture provision would be, quote, inconsistent with and not authorized by the Act, end quote. Is that intended as a legal opinion?
That's my reading of the legislation of SB 21 that says only these exemptions shall apply. And so any attempt in the rules to expand on those exemptions would be in violation of SB 21. And in my opinion, as a policy expert that works a lot in the state, New Mexico, at water policy issues.
I want to transition to talk a little bit about the composed entirely language and the agricultural exemptions. On page 45 of your written rebuttal, you state that the composed entirely language, quote, comes directly from the federal exemption language in the Clean Water Act at 33 USC section 1342 L1. Do you recall that testimony?
Yes, I do.
In section 1342 L1 of the Federal Clean Water Act is the agricultural limitation on the NPDES permit requirement. Is that right?
Could you state that question again?
Yeah, that section 1342 L1 of the Federal Clean Water Act is the agricultural limitation on the NPDES permit requirement.
I think that's right, but I don't have it in front of me, so I will.
Okay, if we get there, I'm happy to help you refresh your recollection, but I don't think we're quite there yet. Do you recall that the definition of point source appears in section 1362.14 of the Clean Water Act?
I didn't include that in my testimony, the definition of point source, and so I'm not recalling that. I don't think it's in my testimony.
Are you familiar with the federal definition of point source?
I am. I just not recall what section of the Clean Water Act it.
Yeah, it doesn't need to be a memory test. Are you aware that the federal definition of point source excludes return flows from irrigated agriculture?
Yes, I am.
And that definition and that exclusion does not include the composed entirely qualifier, does it?
I, again, am not, was not part of my testimony, I don't think. Refresh me if I'm wrong, but I'm not sure I know the answer to that. I'm sorry.
Oh, and that's fine. I'm just trying to understand your rebuttal testimony that the composed entirely qualifier is consistent with federal practice, because Mr. Kazuka is going to testify that that's not the case. So in your experience, does the definition of point source as it's used in federal Clean Water Act permitting include the composed entirely qualifier?
So
objection asked and answered.
She just said she didn't know.
Well, I'm asking her not about the language. I'm asking her about her own experience. It's a different question, but I can move on if you'd like.
Unless you have an answer, but you already said you weren't sure that that language was in the Clean Water Act.
I know that the composed entirely language is in the Clean Water Act, and that's what our exemptions are based on. The exemptions that were in SB 21 and are carried forward in the rule are all based on language that comes directly from the Federal Clean Water Act.
So let's talk then about the Federal Clean Water Act's implementing regulations. Do you agree that EPA's implementing regulations at 40 CFR 122.2 also defines point source in such a way that it does not contain the composed entirely qualifier?
in the regulations.
Yes, ma'am.
I don't have those regulations in front of me. You know, what I prepared for and what I know is that the Federal Clean Water Act does have the composed entirely language, because that was taken directly from the Clean Water Act language to compose those exemptions.
Maybe we can cut this short, just if you could help me to understand. Do you contend that in New Mexico, federal permitting practice, either the Corps or EPA looks at agricultural drains and decides whether they are composed entirely of agricultural return flow before deciding whether the exemption applies?
I would hope that they would. We would not want to have, you know, discharges like a wastewater treatment plant or, you know, individual, you know, small batch treatment plants discharging into agricultural return flow and then fall under that exemption. I think that that's the purpose of that language, and composed entirely of is to prevent other sources of pollution from being able to fall into that exemption.
But what about incidental flow from roadways, from suburban areas? Are you aware of any analysis that is presently undertaken to determine whether or not those incidental flows disqualify agricultural drains?
I am not aware.
Are you familiar with the agricultural return flow exception at 40 CFR 122.3 subsection F?
No, I am not.
Okay. Do you have any reason to testify that removing the composed entirely qualifier would be inconsistent with federal practice?
I think it would be inconsistent with SB 21.
Okay. Well, that's not quite what's in your written testimony, but thank you for that clarification. Are you aware that the composed entirely language in 33 USC 1342 L1 has been the subject of litigation?
I have heard that. I'm forgetting the case, though.
Are you familiar with the Ninth Circuit's recent decision in Pacific Coast Federation of Fishermen Associations versus Nichols?
I have not read it, but I'm generally aware of that case.
Okay, I'll represent to you that in that case, the Ninth Circuit held that irrigated agriculture exception for return flows applies notwithstanding the presence of incidental non-point source pollution like road, non-point source runoff, incidental runoff from residential and suburban areas. In your experience, have you seen any different rules applied in New Mexico at any point?
Than those federal rules?
Then that basic federal standard, that non-point source pollution does not disqualify an agricultural drain.
I don't have any experience with it being applied otherwise.
Okay. Are you aware of any instance in which EPA has required an NPDES permit for the drains of MRGCD due to the presence of permitted stormwater discharges or incidental non-point pollution?
I'm not aware of any.
I guess here's the kicker. I just would like to understand whether you would oppose a definition of composed entirely that aligns with federal practice in this regard.
I think we'd be open to looking at a definition.
I just want to transition quickly to talking about the historical treatment of MRGCD's infrastructure. You acknowledge in your rebuttal testimony that MRGCD's facilities have never been determined to be jurisdictional waters under the CWA, except for during a brief period in 2024. Is that right?
I don't recall mentioning that in my testimony. Do you have a?
Yeah, I'm happy to pull it up.
Like 100 pages, so I may have forgotten.
Do you have a copy of your rebuttal testimony? It's not in my bag of tricks. It ought to have been.
Madam Hearing Officer, can I go grab my reading glasses? Getting old. Well, look, Bruce.
So the passage that I'm referring to begins on page 42 and continues when you're discussing Mr. Kasuga's discussion of impoundment. And specifically when you get onto page 43, there near the bottom of that bottom paragraph, you write, as Mr. Kasuga indicated in his testimony, MRGCD has not been regulated under the CWA except during a brief period in 2024 when the court determined that the Corrales ditch was jurisdictional.
Yeah, I was referring to his testimony where he makes those statements.
And that's perhaps a good clarification. So do you have any personal knowledge one way or the other whether MRGCD has been considered jurisdictional waters at any point?
Just in terms of I looked at the jurisdictional determination that was the exhibit to Mr. Kasuga's testimony, and I actually went back and I looked at the previous jurisdictional determination from 2024 for the Corrales ditch.
Mm-hmm.
So I am familiar with those two. I looked briefly at those, but one jurisdictional determination that found the Corrales ditch jurisdictional, and then a subsequent one which found it not jurisdictional. So I have reviewed those, but I don't have a broader knowledge of other jurisdictional determinations or lack thereof.
In your general work in water permitting in New Mexico, are you aware of any other jurisdictional determinations that agricultural infrastructure of one of the 4 irrigation districts in this proceeding was determined to be waters of the United States?
I am not aware of any.
Are you aware of any New Mexico agricultural ditch that has been determined by either EPA or the Army Corps to be waters of the United States?
Not off the top of my head can I remember a JD determining that.
In your rebuttal testimony on page 43, you rely on the 2015 Clean Water Rule response to comments that EPA produced to support the statement that, quote, historically under the Clean Water Act, ditches like those of the agricultural districts were often regulated. I just want to be clear, you're not aware of any specific example of a ditch like those of the agricultural districts in this proceeding in New Mexico being regulated?
No, I was referring to EPA's language in the response to comments and their summary of the history of the Clean Water Act jurisdiction over ditches, where they said, as I put in my testimony, quote, EPA and the Corps have consistently interpreted the Clean Water Act, Waters of the United States definition to include ditches, end quote.
And that's actually a pretty interesting and helpful document because it's a fairly extensive history of the treatment of ditches leading into the 2015 WOTUS rule. Did you review that document before you cited it?
I did. I reviewed the part of the document that was related to ditches. I mean, the Clean Water Rule response to comments was very long and covered many different issues, but I did look at that portion of it.
Just that section on ditches is probably 600, 700 pages. Yeah. Were you aware of the 1986 guidance from the final rule for regulatory programs for the Corps of Engineers, providing that the Corps would generally consider non-tidal drainage and irrigation ditches excavated on dry land to be non-jurisdictional?
I am not familiar, but I am familiar with features that are excavated on dry lands that don't have a connection to a surface water, that they are not considered jurisdictional.
And that's a practice that goes back 40 years or more.
Yes.
So the guidance document that you cite led to was part of the rulemaking process for the 2015 WOTUS rule, is that right?
Correct.
And that rule specifically excluded ditches with ephemeral flow that were not excavated in or relocating a tributary, is that right?
I believe so, yes.
And it also excluded ditches with intermittent flow that were not a relocated tributary and do not drain a jurisdictional wetland. Is that right?
I think that sounds right, though I don't have all the specific language in front of me.
Yeah. And finally, that rule excluded all other ditches that do not connect to a jurisdictional water, whether directly or through another water. Is that right?
I think so, but again, we're going beyond where my testimony went, and I don't have that exact language in front of me.
Well, I'm just trying to understand if you think that federal practice would regulate MRGCD's facilities. Because I read your rebuttal testimony to suggest that its MRGCD's facilities would be subject to permitting jurisdiction under the Clean Water Act. I just don't think that's true. But if I have a misreading of your rebuttal testimony, I'm happy to move on.
I think that that there's a difference between whether legally they could have fallen under the definition of waters of the U.S. and in practice whether they were by EPA and the Corps. So I think that I do think that legally they could have been considered jurisdictional by the Corps, but I don't have any evidence besides that one jurisdictional decision in 2024 to say that in practice the EPA or the Corps actually did exert jurisdiction over those ditches.
Even though the ditches of MRGCD are predominantly excavated in dry land, it's your view that they could be jurisdictional under the Clean Water Act.
If they are contributing return flow to a waters of the U.S., not if they are not connected to a waters of the U.S.
Let's continue to walk through the history then of WOTUS regulation to understand sort of the basis for that testimony. The 2015 WOTUS rule was replaced by the 2019 WOTUS rule after the Rapinos decision. Is that right?
I think so. Could you state that question again? Sorry.
Yeah.
I was still thinking about the last question there.
The 2015 WOTUS rule was replaced by the 2019 rule after the Rapinos decision.
Correct.
Is that right?
Yes.
And the 2019 rule did not have any special dispensation for ditches. They were subject to an analysis of whether they're tributary. That's basically what you testified a moment ago, is you would determine whether or not that ditch is tributary. Is that right?
That's my understanding of how, the way that the federal interpretation has been in the past.
But the 2019 rule didn't last very long, right?
None of them have.
Yeah. 2019 rule lasted a very brief amount of time. It was replaced by the 2020 rule. Is that right?
I believe so, yes.
Yeah. And did the 2020 rule have specific dispensation for ditches, agricultural ditches?
I am not sure.
Have you ever reviewed the 2020 rule?
I have reviewed the 2020 rule, but I'm not again, it's also very long. I'm not recalling the specific language around ditches at this point, and I don't believe it's the topic of my testimony. I don't think I brought up the 2020 rule in my testimony.
Madam Hearing Officer, I think we've explored this topic sufficiently.
Mr. Brooks, you really are going beyond what she specifically testified about, and having established that she's not a lawyer, continued to press her on how the law reads. I understand she's testifying as a policy advisor, but I'm wondering if perhaps you could move on to this rule and not necessarily the history of the federal landscape.
Well, she's represented that historically, ditches like my client's ditches were subject to the jurisdiction under the Clean Water Act for permitting actions. I don't believe that to be true, but I'm happy to move on, Madam Hearing Officer.
Thank you.
Maybe speaking in generalities will make it a little easier. Do you agree that there has been an exemption for upland ditches for effectively the entire history of the CWA program?
Yes, as long as they don't combine with other waters.
As you read it, does the definition of surface waters in this rule maintain the distinction between upland ditches and potentially jurisdictional lower ditches?
Yes, I believe.
In what language would you point to?
In terms of, I think that the surface waters of the state include, do not list ditches as a water of the state.
So you would not consider ditches to be tributary?
I think that in practice, the state has not considered ditches as tributaries. There haven't been water quality standards applied to ditches in New Mexico. They haven't been included, as far as I know, on the in the monitoring schedule or on the 303D list for New Mexico. So I don't believe that in practice they have been treated as surface waters of the state.
In your reading of this rule, would this rule be consistent with that practice?
The proposed rule is incorporating the definition of surface waters of the state, which is the same definition that has been used by the state to implement other parts of their program, such as the monitoring program and setting water quality standards.
So perhaps my last question then on this line would be, as you read these proposed rules, they would not take otherwise non-jurisdictional, non-waters of the United States irrigation district facilities and transform them into facilities for which a state permit is required.
Not knowing all the specifics, I would say generally no.
On page 43 of your rebuttal, you testify that explicitly excluding MRGCD's ditches from surface water regulation, quote, would take away a tool from agricultural districts to ensure that discharges of waste into their ditches are controlled. Do you recall that testimony?
Yes, I do.
When you say discharges of waste into their ditches, are you referring to discharges by third parties?
Yes, what I was referring to in that statement was that if a ditch was a water of the U.S., there would be very strong, a water regulated under the state program or a water of the U.S., there would be strong provisions to stop discharges into that ditch. And so that it would be protective of the ditch, of the water quality in the ditch, to be able to push back on those discharges and require a permit. Say if someone wanted to discharge wastewater through a pipe into the ditch, that would provide strong protections for ditches to stop that.
Is this a problem of which you're aware, that there are many discharges into agricultural ditches that agricultural districts can't otherwise control?
I do think that there are issues with illegal discharges into ditches where there's pipes that homeowners put. We have one in Taos where there is a septic field that wasn't draining properly, and to get it to drain properly, a landowner created a channel to discharge directly into an acequia, and that caused a lot of water quality problems in that ditch.
Are you aware that MRGCD already has a licensing program that governs who can discharge into its ditches?
No, I'm not aware.
Do you have any personal knowledge of who owns the ditches for a district like MRGCD?
No, I'm not aware of who owns the ditch.
So it's fair to say then that you don't know what other legal recourse a district like MRGCD may have to prevent such discharges?
No, I don't.
Are you aware that stormwater agencies that discharge into MRGCD's drains like Amathka, the city of Albuquerque, Bernalillo County, already hold NPDES general permit coverage for those discharges?
Yes.
Why then do you think that agencies like MRGCD need an additional tool?
I think that they hold what you just talked about was coverage under a general stormwater permit, right? And so that's what I was referring to, and I answered your question, is my knowledge of their being permittees under general stormwater permit coverage. And I don't know if that doesn't, in my mind, protect explicitly against point source discharges into their ditches.
Okay. But you're not aware of what other legal recourse MRGCD or other districts might have to prevent those point source discharges?
No.
Okay. This is probably my last topic for you, but I want to talk briefly about the recapture provision. On page 48 of your rebuttal, in response to the agricultural district's proposal to delete the recapture provision, you state that, quote, this limitation on exemptions comes directly from the federal regulations at 40 CFR 232.2A and has been in place since the 1977 amendments to the Clean Water Act. Do you recall that testimony?
Yes. Can you generally, but could you say the page number again?
Yeah, it's page 48 of your written rebuttal.
Of rebuttal.
And am I right that the federal recapture provision is triggered when an activity involves the discharge of a toxic pollutant listed under federal law, specifically under Section 307 of the CWA?
Oh, yes. Yeah. I'm tracking you now.
Am I also right that the proposed rules recapture provision at 20.6.2.2303 subsection C triggers anytime there's a discharge of a toxic pollutant as set forth in rule by the commission?
Correct.
And that refers to the commission's own toxic pollutant list, is that right?
Correct.
And the state's toxic pollutant list includes pollutants that are not on the federal list, is that right?
I believe so.
No. So when you say the recapture provision comes directly from federal regulations, that's accurate as to the structure of the provision, but not as the list of substances. Is that fair to say?
Yes, it's yes.
So the burdens associated with the recapture provision on an entity such as my client, MRGCD, might be different because the list of covered substances is different.
Well, I would argue that the federal list of toxic pollutants hasn't been updated for a very long time. And there are a lot of toxic substances for which we have scientific evidence and information about, to enough information that we have adopted them as toxic pollutants or qualified them as toxic pollutants here in New Mexico, and that it's perfectly appropriate to ensure that we're protected as a state from those discharges, from discharges that would contain toxic pollutants that have been identified by this body as being toxic.
Yeah, my question is not about appropriateness so much as it's about burden. Can you agree with me that the burdens associated with the state recapture provision being proposed are different than the federal burdens?
Yes, I guess. I mean, I don't know about the burden. I'm unclear what the burden would be. And so maybe I take issue with your use of the word burden, but I would agree that it would be applied using the state's toxic pollutants instead of the EPA's federal toxic pollutants.
Maybe making this more concrete would be helpful. So if, for instance, PFAS contamination is present in the sediment that MRGCD uses in reconstructing an embankment for the Riverside Drain in Albuquerque, and it becomes detected downstream, the recapture provision under the state rule would trigger, but it would not trigger under the federal rule. Is that basically right?
Because PCBs are not considered toxic at the federal level?
Yes.
Is that correct?
And if that detection were to happen, regardless of whether MRGCD is at all at fault for that contamination, MRGCD would lose the protection of the agricultural exemptions.
I guess, yes, if MRGCD used fill that had toxic elements in it in a project, brought in fill that has toxic.
In your view, it has to be brought in fill as opposed to just moving fill from a sloughing embankment?
I don't know if that would be considered adding pollutants if it was moving it.
Okay. I think that concludes my questions for you. Thank you very much, ma'am.
Thank you, Mr. Brooks. Ms. Taylor, I see you've rejoined us. Do you have questions of this panel? Ms. Taylor declined. Ms. Richards, I think I might have seen her on the platform.
Good afternoon. Can you all hear me okay?
Yes.
Thank you. I just have one or two questions actually of the panel. And this, I'm going to ask the same question of both folks. Is it a fair characterization of your testimony that the commission should reject 20.6.2 as petitioned by the department?
No.
So you're saying that they should not reject it, they should implement it as exactly as petitioned by the department?
We are proposing amendments to the department's proposal. We generally support the department's proposed rules at 20.6.2 and 20.6.5.
And while you're proposing amendments, you don't believe those amendments are necessary for the commission to pass the rule as proposed, that it is sufficient as proposed. Is that correct?
No, we are proposing amendments because we believe that the rule would be stronger with our proposed language.
And even without your language, would you suggest the commission, in your opinion, pass the rule?
Yes, we support passing rules. We believe that the language we have proposed makes the rule stronger and more protective of water quality. We generally support the framework that NMED has put forth.
And I apologize, I'm just trying to get a little bit more clarity in your answer. My question was very specific. I know that you've proposed changes. We're aware that you believe your changes will strengthen the rule. But if the commission were to reject your changes, would you advocate to adopt or reject 20.6.2 as proposed by the department?
Adopt.
And sir, what would your response be?
There's two other sirs. Do you care who says yes? No?
I'm sorry. Can I have both of your answers with regard specifically to 20.6.2?
I agree with Ms. Khan's answer. Thank you.
All right, I have no more questions. Thank you.
Thank you, Ms. Richards. Ms. Dolan, I think you are on the platform.
Yes, thank you, Madam Hearing Officer. I have no questions.
Thank you. Do we have Mr. Maxwell or Mr. Weatherby? No? Okay. Mr. Kermsey? Alrighty. I'm being asked for a short break. Can we take, you can sit over there, but let's just take a very short break. If we could come back at 4:10. Alrighty, we are back after a very short break. Mr. Kermsey, your questions of this panel, please.
Thank you, Madam Hearing Officer, Mr. Chair, members of the Commission, and thank you, panel, for your presentation today. I have a very short amount of questions. If I could begin with Ms. Khan. Ms. Khan, you had a few questions with Mr. Mullenberg regarding a proposed rule. It was 2304G that's on page 15 of your direct testimony. I just wanted to ask a few questions about the citations that you used.
What page?
Is 15 of your direct, is the Bates number 87?
Okay, I am there.
All right, great. Ms. Khan, section 7465E3 of the Water Quality Act, the statute you cited in your own testimony, says a permit shall be denied if the discharge would cause or contribute to water contaminant levels in excess of a state or federal standard, correct?
Yes.
The word the legislator used in that provision is would, not may, correct?
Yes.
And Ms. Khan, in your explanatory narrative on page 15, you wrote that the Water Quality Act prohibits permits if the discharge would cause an exceedance. You used the word would there too, correct?
Correct.
Thank you. Now, my questions will move on to Mr. Siebert. So, Mr. Siebert, I'll direct you to page 21 of your direct testimony.
Yes. 21. Yes, sir.
Okay, so your edits to 2307G4 state the permittee shall avoid any adverse impact on aquatic resources, including acreage and functions, correct?
That's correct.
And by shall, you mean even if it is not feasible?
I'm not sure what you mean by if it is not feasible.
So you use the word shall. You edited to include the word shall, so that the permittee shall avoid any adverse impacts. Now, I'm asking if that directive requires that you shall avoid these these impacts, even if it's not feasible.
I guess I would say that as we've talked about during the alternatives analysis, the feasibility, practicability is part of that aspect of the avoid.
Okay. Mr. Siebert, the phrase adverse impact is not defined in part 2 or part 5, correct?
I don't know.
Then what is the minimum showing of adverse impact on aquatic resources, acreage, or functions that would be a violation of Water Protection Organization's proposed edit?
I'm not sure I know what you mean by the word violation.
So in this rule,
Excuse me, what Bates stamp page are you referring
that's
to?
184.
184?
Yeah.
Thanks.
So okay, back to your question. In the proposed edit, it's stating that there is a threshold that, we see there's an adverse impact that this permittee shall avoid it. Now, I'm asking you, what is the minimum showing that there is an adverse impact?
I just want to make sure I'm looking at the same spot. This is the duty to avoid, minimize, and mitigate phraseology. We're looking at the same place on page 21 at lines 4 through 7?
I don't have the exact lines right now, but I know it's an of adverse impact.
I don't know that I can define that. This language, as I read it, is talking about those important steps and laying that out as a framework. And then through definitions and other places within the rule where you get into more details about what needs to be required in an alternatives analysis, including practicability and that phraseology that's also defined in the rule.
And the proposed rule edit does not specify how NMED will determine whether a permittee's discharge caused an adverse impact on aquatic resources, correct?
I'll agree with you on that, yes.
When there are multiple dischargers into the same receiving water, your proposed edit contains no methodology for attributing the specific party who caused the adverse impact one was found, correct?
I think that's beyond the scope of my expertise in this matter.
And then last question, if the Water Protection Organization's proposed rule, this one that we've been discussing, was adopted, how will NMED monitor this?
Again, I think that's outside the scope of my.
Well, thank you for your time. Thank you, panel. Thank you, Madam Hearing Examiner.
Thank you, Mr. Kermsey. Ms. Miller, are you on the platform? No? Okay, let's see. Mr. Micklejohn told me that he does not have questions of this panel. Ms. Udall, I think I saw you on the panel.
Thank you.
Platform.
Thank you. No questions for this panel.
Okay.
Thank you very much.
Thank you, Ms. Udall. Ms. Scott, or yes? No questions. Do you have redirect, Ms. Fox?
Madam Hearing Officer, I have one question. Ms. Khan, of course it's to Ms. Khan. Do you remember the question from Mr. Mullenberg about whether the swap, whether there is any compromise or negotiation during the swap in the context of your testimony about that being part of the stakeholder involvement process that NMED had?
Yes.
What parts, with regard to that stakeholder process, what public participation elements did that process include?
So there were, I even forget how many meetings, but there were a lot of full day meetings where all the stakeholders came together and we discussed general concepts of a program and what it should include. And then there were comment periods. The Surface Water Advisory Panel got a preliminary draft of the rules and had a first comment period that was just for the Surface Water Advisory Panel participants. I believe that those were released in May of 2025, and the comments were due in July of 2025.
Thank you. That's all I have.
Thank you, Ms. Fox and panel. Can I start at this end? Oh,
Madam
I'm
Hearing
sorry.
Officer,
Yes.
can I bring up an issue? It looks like we've got 2 out-of-state witnesses. Would it be possible to limit our questions to the out-of-state witnesses today and expect that we'll have Ms. Khan back on Monday?
Sure. I mean, if you think the questioning is going to exceed 40 minutes, I think do you think we're not going to finish by 5? Okay.
I'd also say while I won't be able to be here on Monday, I would make myself available on the platform.
That would be acceptable.
I would be the same.
All right.
That's a great suggestion.
Okay. So, Commissioner Sloan, do you have questions of this panel?
I do not.
Thank you. Commissioner Zemlich.
I do not.
Thank you. Mr. Chair.
I do not.
Mr. Thompson.
Let me check. Okay, yes, I do. Thank you. I have one question for Ms. Khan, and if the commission accepts all of your suggestions, it looks like there would be a fairly substantial burden on applicants because they're going to be requested to provide a lot more information. Do you have any estimate of how much additional work an application for a dredge and fill permit would take?
Madam Hearing Officer, Mr. Chair, Commissioner Thompson, I don't actually think we're proposing a lot more requirements for the permit application. I mentioned that there were 4 additional requirements that we're proposing. I think it was 4 for the PCN and NOIs, and I don't think that those are overly burdensome. That we proposed that there be a project purpose. Let me get to. Oh, I'm not on my presentation. I'm on Mr. Siebert's. That's why I was not finding it. We propose that PCNs include a project purpose. And if there is, that's the one thing. The second thing is that for pre-construction notifications, if the proposed general permit activity is going to result in unavoidable losses above the thresholds when compensatory mitigation would be required, we also propose that the applicant provide information about how they propose to do that compensatory mitigation. So that would only be triggered in those projects that exceeded that threshold, right? We also requested in the pre-construction notification a list of any other general or individual permits being used, so that I don't think that's too big of a burden to ask for permittees to provide other permits that they're intended to use to authorize other parts of the project. And so that's to get at that stacking issue, the single and complete project issue. I don't think that that's too much more information. And then the last thing that we're proposing there is for pre-construction notifications, the names of any federally and state threatened or endangered species and their habitat. So just list those out. So I guess I don't see it as being that much of an additional burden.
Thank you. I appreciate it. And I think I agree. The same question regarding the administrative burden on the regulatory agencies, both the NMED and Department of Wildlife. Several of the suggestions require analysis. Some of the analysis could be very simple, but I think some of them could be quite extensive. So do you have an estimate on what the increased administrative burden on the regulatory agencies?
No, I don't think we're proposing anything that isn't done at the federal level for federal permits. So it's not like we're proposing this whole new regulatory burden that hasn't been experienced, at least by the federal regulating entities. And my understanding is that the department based a lot of their proposed fees based on how federal permitting goes. So I guess I think that they're I don't really see that being too much of an issue.
Okay, thank you. My next questions are for Dr. Sultanthus. We'll start with functional assessment, and you suggested that there are ways of doing that. Would functional assessment be required for every dredge and fill application?
That's not my understanding of what we were proposing. I think it's more about for larger projects that are going to have compensatory mitigation, I think. I think that said, functional assessments, and maybe there's sort of a functional assessment light that we can promote. I think functional assessments can be really valuable in the minimization and avoidance perspective. If we know that we're going to impact some resources and we have the option of impacting one over the other, a functional assessment can inform us on which one is lower functioning, and we could choose to impact that. But I guess my thinking is that for smaller projects, a robust functional assessment would be not required.
And the functional assessment would be done by the permit application, by the permittee?
That's right. Mm-hmm.
And how much effort goes into a functional assessment?
In my experience, most functional assessments are meant to be done within half a day to a day of data collection.
Okay.
And it's meant to be rapid.
Is that a something that's done in the office, or it requires field work?
Both. Yeah, both field. There are some, typically in particularly the New Mexico rapid assessment method and others, there are some metrics and indicators that you characterize from desktop imagery, and others that require field assessments.
Okay, so that brings up my next question. You talk about the rapid assessment. Is that only for functional assessments, or is that for other projects, for permit applications, characterization of the stream?
I'm sorry, I guess I'm not.
Okay, you said in the functional assessment you would use the rapid assessment tool.
Or an otherwise approved NMED functional assessment. Yeah.
Okay, and are you suggesting that we put the New Mexico rapid assessment method in the regulations?
We propose to include that as a definition, recognizing that there's a lot of concern. You've just used the word burden. We've heard that word before. Our stance is that we're not proposing anything overly burdensome. We wanted to highlight that creating a new functional assessment could be a big lift. And the reason we included the New Mexico rapid assessment method was simply to shine a light on the fact that one already exists.
Correct, but it's my understanding that the rapid assessment method does not have regulatory standing. In other words, you can do a rapid assessment analysis, and the results, it's not a determination of whether or not the stream meets the designated use. Is that your understanding?
It's not my understanding, but there is some nuance there. So there are other assessment techniques, particularly for rivers, excuse me, that like this CSQT or SQT, stream quantification tool, that specifically characterize some metrics, and then you multiply that by feet of impact, and you end with this functional feet. I personally don't really love that approach, but in terms of the New Mexico rapid assessment method and the California rapid assessment method, other places where those are in existence, appreciate that. You can use the functional number that ends as a performance criteria. So if we were to restore some river or restore some wetland, We would have a starting baseline number, functional score, and we would say after 5 years, here's what we're doing to arrive at some final score, and achieving that number would itself be the success criteria performance standard for the mitigation site.
Are you aware that the Surface Water Quality Bureau does an analysis in principle of every stream reach in the state, and I believe it's once every 7 years?
I'm not aware of that.
Yes, well, that is a way that they generate information for the 303D, 305B list, which I believe we approve every 2 years. And the way the Surface Water Quality Bureau does these analysis is they use, part of it is the hydrology protocol. And are you familiar with the New Mexico Environment Department's hydrology protocol?
Briefly familiar, yeah. I looked at it the other day after you asked somebody else if they were familiar with it.
Yeah, and just based on your quick review, how does that compare to the rapid assessment method?
My understanding is that it's focused specifically on hydrology, and it's particularly meant to differentiate between ephemeral, intermittent, and perennial waters rather than characterize sort of the functional condition of those waters.
Actually, it's much more than that.
Is it?
It involves a lot of everything that goes into a rapid assessment model. But I'm sort of getting out of I'm providing testimony.
There may be a tool in existence, to your point, that would be suitable.
There is a very extensive procedures that the Environment Department does for their stream determinations.
I think one benefit of something like a rapid assessment method is that it's not only focused on the streams, but all aquatic resources. So it would sort of be a one-stop shop, if you will, functional assessment method that could characterize both isolated wetlands and all the various stream types.
I'll add my opinion. I would be reluctant to reference something like a rapid assessment model in the regs unless the Environment Department, the Water Quality Control Commission specifically reviews and approves them. And I don't think we're prepared to do that. That's a lift.
Not a hill I'm going to die on. Yeah.
Thank you. Thank you. My last line of questions. I love your presentations. Beautiful pictures, gorgeous pictures. But most of the ephemeral streams are sand bottom channels, and we haven't talked about that very much. And let me give you just a little bit of preface this question. There was 3 or 4 years ago, there was a news story, fairly prominent in northern New Mexico, about a landowner had an ephemeral channel, sand bottom ephemeral channel that flowed through his property, and he went out and he was cleaning. My recollection, he was cleaning tumbleweeds and accumulated sediment out of the channel that flowed through his property, and the Corps of Engineers came down on him for doing dredge and fill activities without a permit. So my question is, are there de minimis activities in some of these ephemeral streams? And I'm focusing on sand bottom channels. I'm not talking about, high altitude first order streams that feed directly into very high quality perennial streams. Are there de minimis activities that wouldn't require a permit? So for example, cleaning a culvert, doing a couple 100 feet of erosion protection on a channel that flows through your property, cleaning debris or removing invasive species. Are there de minimis activities that we don't have to permit?
Is that to a particular person?
I'm asking you.
Me, okay. I think, I imagine that some of those maintenance activities would be an exclusion, say like cleaning out a culvert, for instance, removing tumbleweed. I have significant heartburn hearing about the idea of excluding erosion control. There's significant erosion control in sand bottom reaches all the way up to large perennial rivers that harden banks and significantly impair the functioning of stream reaches, ephemeral up to perennial. I would not be in favor of including that particular, of the 3 to 4 examples you provided, I would not be in favor of including that as an exemption. But I assume there would be some exempt general maintenance activities for private landowners in particularly.
So you had one picture, I've been kind of watching for this. You had one picture of an ephemeral sand bottom channel.
I can picture it.
With a very large head cut. And
oh, it was up against a big, wall. Yep.
Yes. And so if the landowner wanted to protect his property, would he have to go through a full dredge and fill application permit process?
From a scientific standpoint, the addition of erosion control structures within the stream channel leads to significant impairment of that stream, and I would be in favor of them needing a permit for that.
What kind of impairment of that particular stream could you describe?
I kind of doubt a landowner would fortify that size of wall, but in general, when we restrict the movement of a stream, generally we're kind of redirecting that power somewhere else down the line. You're sort of kicking the can down the road to your landowner downstream, which is also a bit unfair, I guess. I think rivers operate functionally best when they have room to roam and room to meander. We don't like that for obvious reasons. We don't want it to eat into what we view as our land, but in fact is floodplain. So we add structure to a lot of our rivers, which I continue to maintain significantly impairs them when we lock them down.
The photo you had was pretty extreme because that was a very large head cut, but in drier parts of New Mexico, similar phenomena occur frequently. They're fairly widespread. And again, if a landowner's got, structures, house, barn, whatever, asking him to go through a full dredge and fill application permit process to armor a couple 100 feet of channel seems excessive to me.
I disagree, but I would encourage that landowner if they did not want to go through that. There are ways of burying like toe of slope type structures within more of the upland area to provide some fortified, provide the river room to roam, but say this is where you can no longer roam anymore onto my property. I mean, that might be one suggestion.
Excuse me.
But I would also, I just want to clarify too, because Trout Unlimited was promoting some restoration activities that shouldn't be included and needing a permit in some of these ephemeral waters. So if you're talking about a true head cut, which when I think of a head cut, that's actually like a large elevational drop within the channel, that might actually fall into that restoration perspective that they were promoting, as opposed to, say, a hardened bank. I view those personally differently.
I guess I'm having trouble understanding the impact of armoring a couple 100 feet of channel on a piece of property where the water flows less than 10 days a year. And that is a very common problem in dry parts of New Mexico.
Yeah, no, I in no way am I trying to push against that, but I do disagree. When we include hardened structures within our stream beds, that's a problem.
No more questions. Thank you.
Thank you.
Thank you for the pretty pictures.
Mr. Chapman?
Yeah, I've got a few questions. Thank you all for being here today. Appreciate your presentations and like Vice Chair, really appreciated the visual aids as we were going through proposed amendments. I've got just a few high-level questions for Ms. Khan, and then a couple for Mr. Siebert. We'll start with Ms. Khan. You talked about like 2006 versus now, and the efforts to get primacy back then, and here we are, kind of going through it at the moment. So with 20 years of hindsight, what do you think the consequences of not establishing a state surface water permitting program in 2006 are?
So there have been a number of discharges that are no longer federally regulated. So a big example is the Silver City wastewater treatment plant. It's in a closed basin and it no longer is required to get a federal NPDES permit because it's in an isolated closed basin. And if we had established the state surface water permitting program back in 2006 when it was first looked at and proposed, we would have a state permit that is regulating those discharges.
And then just to build on that idea, so what are some lessons for all of us today?
I think it's important to be proactive as a state to protect our resources here at the state level and not depend on the federal government.
Thank you. And then just going to Mr. Siebert. Consequences of not adopting WPO amendments to NMAD's proposed rules. What are some high level big consequences that you see?
Sorry, make sure I'm understanding. You're asking not adopting the Water Protection Organization. Well, as I said through my testimony and in my summary, I think the package that the agency has brought in front of you is a solid package. The kinds of things that I was commenting on were adding clarity, places where experience would say using extra language here would, I think, help applicants and help the agency be able to defend its decisions. So I think that in a broad sense is where I was coming from.
Appreciate that. And then just so that we have the whole picture, what are some trade-offs of WPO's amendments in your opinion?
I'll focus on a couple. There are a number in there. And so if I don't get to ones that you were asking about, I think in the compensatory mitigation area, the proposed language added to add a little more clarity in terms of what does a compensatory mitigation plan need to look like. I think that's something that would be a really good addition. It's an amendment that I would advocate strongly for. It'll only help out applicants understanding what they have to provide, and it helps the agency, I think, in developing mitigation guidance that'll, again, drive that program forward. I think other places, I think there were just language there that, again, as I said, would make it clearer and tie to federal language where there's a long practice. I think that's kinds of things I would think of.
I guess I was getting more towards like trade-offs, like negative, like Vice Chair was talking about this idea of burden on applicants. So trade-offs of those amendments.
I was thinking when Commissioner Thompson was asking the question, my answer there, I don't know that it's burdensome to have in the rule language of this is what we mean by this. And there's more detail there. Because in my experience, when you don't have the detail in rules or guidance, applications come in and they're not enough. And the agency's got to seek, and that back and forth process is hard for everybody, and nobody has the time and money for that. And so as much as we can front load, here's what's expected, here's the decisions we need to make, I think you're going to be better off in making sure that you get a clean application right up front, and then the agency can turn a decision around in a much more expedited process.
Appreciate it. Thank you. No more questions.
Thank you, Commissioner Fry.
I have one question for Ms. Khan, and it's in regard to your slide number 24 with the Mexico pollutant discharge elimination system, so 20.6.5. I was confused by, I believe both your points are relative to 20.6.5, correct? That they incorporated some of the changes that you were requesting in the, it's not the second amended, it's the Exhibit 79B, correct?
Yes, NMED did incorporate some of our proposed changes into the 20.6.5 proposed rule as shown in Exhibit 79B. The only three remaining general areas of our proposals for 20.6.5 are the three general, the three, I guess it's more than 3 lines, but it is 3 proposals. One is public review and comments on NOIs and PCNs. There's also proposal to have NOI review criteria. And then there's proposal to for the ability of the public to file petitions for review of general permit coverage if they've commented on general permit coverage. And those proposals, the remaining proposals we have for 20.6.5 can be seen on our slide 23, at least on the one that that I'm working from, but I may have shortened it from the time that we filed it. But it is the slide that says notice of intent, NOI requirements and review for 20.6.5 303A. And there's 3 bullets on that slide that summarize those proposed changes.
Right. So that's where I'm coming up with, okay, proposed changes over the 3 changes. So 5.303A4. I'm not seeing it when I look at your red line.
Commissioner, are you looking at our submitted red lines?
Yes.
Our Exhibit 1?
Yes.
The issue is that our red lines that I put on the slide, we changed the red lines to reflect the 79 A and B proposal. So the numbering is now based on the proposed language that NMED has put forth in those exhibits.
Okay, because those are not actually on your slides, those 3 that you're withdrawing, correct? Or did I just miss it?
On the slideshow that I just shared.
Yeah, so slide 24 gives, it says that you are withdrawing those proposed changes except for the 3. Okay,
yes,
all right, okay.
Yes.
But you don't show it on your slides, it's on a red line that doesn't exist because
we have not put together our final proposal for 20.6.5 where we've reflected our withdrawal of our proposed changes that were filed in our Exhibit 1, I think our Exhibit 2, that we filed on April 15th with all of those red lines. What happened is in Exhibit 79B, for 20.6.5, the department incorporated a lot of our proposals in that, and so we are withdrawing, if not word for word, in enough that we are happy with it, and so we are withdrawing all of our proposals except for those 3.
Okay, thanks for that clarification. I get it now. Thanks to all of you, and that's all my questions.
Thank you, Commissioner Laney.
Yes, thank you for your presentations and your testimony today. I'll leave it open for whomever is best suited to answer the questions or provide additional as we go along. I don't think I have too many. Most of them were answered, but I did want to follow back up with something that Commissioner Thompson had asked about, which was the New Mexico Rapid Assessment Method. You said that it was included in definition, but from what I see, and maybe I'm getting confused as well, but what I'm seeing in the red line document, is actually being included under the permit requirements. So I'm looking at, and this was in Exhibit 1. So like I said, this may be, so for example, under the general permit requirements of 20.6.2.2306, that rapid assessment method is part of what they would have to submit. As well as, ooh, I lost my spot. As well as under the individual permits. And I'm sorry, I don't have that right here in front of me. It says use of the New Mexico rapid assessment method or other department approved functional assessment tools when the functional assessment is required. So that's effectively making it a requirement of submitting the permit. That's my understanding.
Is that a question for me or for?
Sure, you or.
Yeah. At the end of that clause, it does say when it's required, but I guess off the top of my head, we've specified that requirement.
What exactly was the question? I'm sorry.
It appears to me that it's included as a requirement of when you submit your permit, you have to also submit this New Mexico rapid assessment method. If your permit also includes a functional assessment. So let's just say that it does. So then you'd have to submit the method, rapid assessment.
The results from the method?
I'm not sure. It doesn't specify that much.
Which are, can you give me the exact? It's 2306.
So let me see if I can get this to cooperate with me. So under 20.6.2.2305, which is the general permit, I think. Sure. Yes. So is it 4? I think it's in both. It's under the general and the individual permit from best I could tell.
I am not seeing it in 2305. I do believe it's in 2304, and that's at H, our proposed 2304H.
I do see it in 5. It's number 7 under C.
C7.
General permits shall specify use of the New Mexico rapid assessment method.
I think that actually is not providing the results, but describing what method you're going to, that you will use a functional assessment to characterize.
Well, I feel like it's telling me that you have to use the New Mexico rapid assessment method.
Or other departmental approved functional assessment tool.
Yes, which is even more wiggly. So
it requires, I guess, our approach to that was recognizing there is an existing tool, but not that we should lock this whole thing down with that tool. There could be times where there could be at some point in the future, NMAC approves a separate functional assessment tool like Commissioner Thompson suggested.
So I'll be the first to say I am not a lawyer by any stretch, but my interpretation of that is that it would require the permittee to submit the New Mexico rapid assessment method or some other tool. And my concern there was, wouldn't that effectively make a guidance document equivalent to regulation? I believe it would.
If I could answer that. In my testimony, I think the language that's key in that number 7 that you're referring to is the when. And that's getting at the idea in my view here that if you're using a functional assessment tool, let's make sure you're using a tool that is accepted. It's an accepted methodology when you submit the results. Otherwise, an application could come in, well, we just use this method over here. And again, that back and forth of, well, that's not an accepted method. So that's what I think that language gets at is when it's coming in as part of an application, it should be an accepted methodology that's been scientifically defended and validated in the state.
So I guess then I'm questioning what makes that an accepted method if it, because it then is equivalent to rule, and it hasn't been purviewed to public comment nor come before the commission. So it's just, it feels very squirrely to me. It feels like it's requiring that when a functional assessment is required, you must use the New Mexico rapid assessment method. That's what I feel like it's telling me.
The New Mexico rapid assessment method is currently available on NMED's website.
It is.
I take that sort of as a indication that it's an approved NMED functional assessment. Maybe that assumption is unfounded, but I think that there would need to be some indication from NMED that that is the case.
I think that it's an NMED tool. I would agree. I feel like by including it in the permit requirements, even if it's only if it's for a functional assessment, that gives it the same degree of authority as a rule, which then means that they have to make sure that they're providing all of the documentation that New Mexico rapid assessment method has in there. I won't belabor this anymore. I'll move on to my next questions. Okay. This was again in the red line document. I apologize. I just had a question on under section, okay, it's section. Sorry, I should have wrote myself better notes. Okay, I believe it's also under 20.6.2.2306. And this is going to be under J, emergency permits. And it's just one line I want to ask about. So under there, you guys added under J part 2, you added a C.
Yes.
Yes. Perfect. Thank you. Okay. Which reads that an emergency permit shall include any necessary requirements for compensatory mitigation. What does that do? What is that requiring?
Great question. In my mind, that protects us from somebody sort of claiming that this permit that they need is itself an emergency and it exceeding the thresholds that would require compensatory mitigation, but because it is in fact an emergency, not having to actually perform that compensatory mitigation. It's simply meant to clarify that even if it is an emergency, those compensatory mitigation requirements still apply.
So I guess I would like a little bit more explanation as to why. It wasn't part of what NMED had proposed, so it didn't, I'm wanting to understand the why.
Yeah, I think more broadly, we have been pushing for compensatory mitigation, sort of expanding clarity around that. And in the spirit of that line came with that encouragement to include compensatory mitigation more robustly, rigorously within this new rule. If an applicant in a hypothetical were to come and say, this is an emergency, or even a true emergency, let's not make it like some devious intent. If it has a larger impact that this regulation otherwise would require compensatory mitigation, this line simply confirms that even under emergency situations, compensatory mitigation requirements are still valid and applied.
Would that delay the issuance of an emergency permit in any sort of way?
Not in my mind, no. I don't think that typically compensatory mitigation isn't necessarily even done before the impacts happen. That's why in a broader sense at federal and other states, we prioritize mitigation banking because that mitigation is complete and performance is secured before those impacts happen. But in terms of permitting responsible mitigation, typically the impacts are done, the permit is applied, the permit is provided, the impacts happen, mitigation is afterwards performed, which is why it falls on sort of the lower end of that 3-part, because there's a temporal loss there, but in no way would that hold up an emergency permit.
Okay.
Or a non-emergency permit.
Last question on the red line document. It's got to get there.
Actually, is it your last question or?
Yeah, let's let it be the last question. Everything else has really been aired.
Okay.
Okay. So this should be a fairly quick question. I'm just curious, and this is kind of in the same thread on the emergency, but it's actually tied to the feed tables. So under the feed tables, which is 20.6.2.2354, I believe. You added a fee requirement for emergency permits.
Yes, I mean, emergency permits are going to take department resources just like other permits. And so it's appropriate that, you know, that if someone has to take actions that are from an emergency situation, and those actions are going to take processing and analysis by NMED, there should be a permit fee associated with it.
So I was just curious because NMED obviously did not include that under there. So then it brought questions to my mind, like, were you expecting that there would be undue burden that the agency would need to be paid for with the issuance of these emergency permits?
We just saw that as, yes, and a gap in the fee table. And so we proposed, I mean, that's not something that we have provided extensive testimony on or is a big priority, but was a suggestion that we made because we do see costs associated with emergency permits.
Okay, that's it. Thank you.
Okay, thank you. Let me just ascertain whether Commissioners Hall, Barunda, or Langer who are on the platform have questions. Please unmute yourself.
I have no questions.
Thank you.
Thank you.
Yeah, I have
Commissioner-
no questions.
Thank you. And Commissioner Langer put in the chat that she had no questions. I believe that means then that this panel can be excused. And thank you all very much. We'll see you Monday at 9 in room 322.
Which is another big risk.
And Madam Hearing Officer, I'd just like to note, if our fourth witness, Vidal Gonzalez, who couldn't be here today, he has 5 minutes of summary of testimony. If he could go first, okay, for the NMBD panel, we'd appreciate it.
Okay. And Ms. Taylor?
Yes, ma'am. I just wanted to mention that. So.
Okay. We'll do that too. Thanks.